welcome everyone to Immigration Talk Show. I'm your host Sam, and today we are back again with another very exciting and very lively topic. So, before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, once again, welcome back everyone to Immigration Talk Show. And we are live on YouTube, LinkedIn, Facebook, and on X as well. So let us know from which platform you guys have joined us and post your questions, post your queries, because today the topic is very important, and that's about traveling to the US in 2025, how to stay safe under new executive orders. So we all know that what's going on and what's happening in the US is very chaotic, and people are very concerned, especially not only the travelers or the tourists, but everyone, workers, students, or even the family visitors as well. So in today's session, we are going to explore each and everything, like what documents you have to carry, what are the steps you have to follow, what tips and tricks are important for students, for travelers, for everyone, those who are trying to visit US in this upcoming year. So friends, without any further ado, let me welcome today's very special guest and very honorable guest, attorney Kimberly Best Robideau. So, Kimberly, please come to the stage and let us know how you're doing. And I'm really excited for this session. So, thank you so much for being here. And we are really grateful that you are here with Immigration Talk Show.
Yeah, hi Sam. It's great to see you again, and I'm excited to be here as well to help answer some questions and provide some information. Because as you said, it is a little maybe very chaotic here in the U.S. right now. A lot of different things going on in addition to immigration.
So, Kimberly, can you please let us know, like, what is actually the situation going on, what people are reacting, and how is everything going on, matlab, just like that way? Yeah.
Yeah, so one of the biggest things that I think maybe people have heard around the world is about the deportation effort here in the United States. So our Immigration and Customs Enforcement Agency has been given a quota to meet with respect to arrests, and that is 1,200, about 1,200 or so, which translates it into 75 individual arrests for each field office at any given time. So that's pretty high. What ICE has been doing is, especially in some of the communities people may have heard in Chicago, New Jersey, there's been some here in San Diego as well, is going after, meaning going to people's homes or their workplaces, looking for specific individuals that have either criminal background issues or they are in the system, the immigration system to some extent, because of having been, having had entered the United States without authorization and violated their status. So those are some of the, I guess, low-hanging fruit that we're seeing right now. Unfortunately, some individuals who do have valid status are being what we call collateral damage. So they have been affected by this action as well. What typically happens is if ICE is looking for individual A and an individual B is in the same area or work site or complex, if the agents ask for documents, they might then bring that individual in for detention. So that has happened to some individuals who do have some type of legal status in the United States, which is typically related to temporary protected status or DACA. So those are some actions that are happening here in the US. And we're expecting some additional worksite actions to include ICE asking employers for various documentation so that they can determine if there are any undocumented workers that could be detained. And then we expect in the near future at some point for there to be an increase in the what we call the I-9 audits, and that's the employment eligibility verification form. And that is the form that all employers have to complete for every employee. And typically ICE has done audits of those forms to ensure that the individuals do have valid work authorization to work in the US. And we do expect increased audits in the coming months. Right now, we're more focused on those individuals who have criminal violations or are undocumented.
All right, all right. So, Kimberly, is it that, as you already said, that the target for the ICE raids are 1,200 to 1,500, and that's we all know about it. So, why is it that also the legal people are also getting affected? Because it's mostly about the illegal ones, right? But why is it that legal one are also being targeted, and why they are also being questioned? I mean, what's your call on that?
Yeah, so for one of the things that we understand is that some individuals who do have a valid status in the United States might not be the direct target of these actions. And I typically we would refer to a raid as a situation where ICE has investigated, for instance, a particular company, and then they go in and they serve a warrant and they review the workforce, round up essentially the individuals who don't have valid authorization, and then may seize documents from the company. So these are more targeted actions and not what we typically call or refer to as raids because of how they're not going after the company and the individuals within the company, but maybe one particular or two particular people. So what has been happening for those who do have a valid status is they may be next to an individual who is being targeted. So ICE will ask them for their documents. It's important to know that individuals do not have to respond to an officer or an agent asking for their immigration status unless there is a judicial warrant that forces that disclosure. And again, individuals who have either a valid immigration status in the US or who are undocumented, we are recommending that they do seek legal counsel in order to understand what their rights are. The
Mhm.
ACLU has a lot of know your rights information that's out there that we recommend individuals review, even if they are legally in the US. So one of the reasons that those individuals are being caught up in some of these actions is because they're, like I said, they're collateral damage, unfortunately. So they're not necessarily being targeted, but they're there in that direct vicinity, or they're in that area where ICE is conducting their arrests. And because of this quota, it's easier to just pull in as many people as possible in order to meet the quotas. So that's one of the reasons that we're seeing individuals with status being affected by this process. And so those who are in the U.S. in a valid non-immigrant status, they should make sure to carry their documentation to prove their status at all times, as well as people who are permanent residents, and even in some instances there are U.S. citizens that are starting to carry their documentation because they don't look like what ICE thinks as somebody who is not undocumented. So in other words, individuals who are not white tend to be questioned more often than ICE, unfortunately. Questioned by ICE, unfortunately, because of, to a certain extent, this profiling.
Absolutely. I think that's wonderfully explained, Kimberly, and I would say thank you so much. And friends, we are really going to discuss each and everything like what are the rights, what are the legal things that you have to follow so that you can stay safe in this year if you're planning to travel to the US. We'll go each and everything step by step. You also make sure from your end that you ask questions, you put up your queries on the comment section because until and unless you're not going to ask, you're not going to raise questions, I think it will be very difficult for you all to understand and to plan out everything. So question each and everything. Make sure this session to be more conversational and lively. And we are here for an hour. So thank you so much, everyone, for joining us. And also, Kimberly, I would like to directly jump into my very first question. That what are the most important changes in the new executive orders that travelers to the US need to know for 2025?
Yeah, so the executive orders have essentially stated that there's going to be additional vetting of individuals entering the United States, both at our port of entry as well as through the visa application process. So that is one of the biggest things. The executive orders are talking about securing our borders. So there are additional National Guards that are posted at the southern borders. And that is to assist in case there are actions of individuals trying to enter the United States without authorization. But the Customs and Border Protection officers are also, to a certain extent, asking additional questions about an individual's purpose for entering the U.S. and ensuring that they have the proper documentation. Now, with individuals that are applying for visas at U.S. consular posts abroad, the executive order that is saying more extreme vetting will likely end up with more administrative processing of certain applications. But at this point in time, we haven't really seen a negative impact on the consular visa application process, which is a good thing. But we'll continue to keep a watch on that. We do know that Customs and Border Protection has asked additional information of individuals coming into the U.S., especially those who have an advanced parole document. There's a little bit of confusion at some of the ports of entry about the parole documents. So some individuals have been placed in secondary for a couple of hours while the officers review to make sure that that advanced parole document is valid. So those are some of the things that we're seeing with these executive orders that call for more secure borders, and then also the internal enforcement of immigration laws. So that's where we're seeing the deportation impact as well.
That's right. Okay, so I think let's move ahead with our next question. Kimberly, as you explained about what are the changes, and I would also like to know that how will the new executive orders in 2025 is going to affect the H-1B applicants who are planning to travel and also the work status in the US? Yeah.
Yeah, so for H-1B individuals, again, until we see that there's a backlog with the visa applications at the U.S. consular posts abroad, which might in fact happen if we lose the individuals who are part of the civil service that process the visa applications. That could result in longer wait times to get a visa appointment. We're also expecting that the government might either eliminate or reduce the visa, not the visa, the waiver of the visa interview at the consular post, right? So a lot of individuals have been able to schedule their visa appointment, provide their documentations in a Dropbox, and never actually have to go in for a meeting with a consular officer. So that might be removed, but yet that has not happened. But those are some things to expect. And if that happens, again, that would increase the wait time to get a visa appointment. So that could have a negative impact on individuals who are applying for H-1B visa stamps at consular posts abroad. So that would mean if traveling back home for family issues or reasons, or going on vacation outside of the United States, or even for business travel, it might mean planning that further in advance to ensure that a visa application appointment is obtained while they're going to be abroad. And then on the back end, potentially having longer wait times if it's going to take the consular post longer time to process the visa applications, either because of increased, not reduced, but increased vetting and background checks. So those are some things to keep an eye on. We are also, based on one of the executive orders, waiting to hear about the current administration's implementation of any travel bans, right? So there has been a lot of talk about travel bans. Based on information that's been provided by the administration, we would expect to hear something in the next 45 days or so. And that would provide us with additional information about, is that banning certain countries, individuals who are nationals of certain countries? Would it impact particular visa applications or statuses? And then with H-1B applications in the United States, we do have an action by our Congress that is trying to rescind the H-1B Modernization Act that the Biden administration put into place, which clarifies what is considered a specialty occupation. It opened up the CAP exempt organization eligibility a little bit, and it provided deference to prior applications and petitions that were adjudicated for certain individuals, so that a U.S. officer, if they saw, oh, this person has had an H-1B visa, now they're filing an extension, let's give deference to the prior approval. So that Modernization Act put that deference into the regulation. And so there if they were to rescind that, then we might have a situation in from Trump 1.0 where officers, when they're reviewing an H-1B petition, would review it as if it's the first time that the individual has held H-1B status and place a higher level of scrutiny on it. So those are some things that we're concerned with. And
Mhm.
then some of your viewers, and you may have heard that there's also been some talk about putting into place regulations that the Trump administration tried to do the first time, which would make it a requirement to essentially pay higher level wages to H-1B workers, which actually would be way above what U.S. workers are paid right now. So it's using the prevailing wage survey to say, okay, everybody needs to be a level 4, and no one in H-1B status can be a level 1, 2, or 3. So those are some things that we're looking at, as well as we know, and we've seen a little bit, right? I mean, it's only been a few weeks, but we've already seen some increases in requests for evidence, which again would just create a little bit more stress, anxiety. It delays the process. And so that's what we're keeping an eye out to understand what the patterns are with respect to any kind of request for evidence.
That's right. But also, Kimberly, I would like to know it from you that why the H-1B applicants are being targeted in this new Trump, I would say Trump's administration, because we all know that H-1B workers have been contributing a lot to the U.S. economy. So why is it that they have to face these challenges, or why is it that it's going to be difficult for the H-1B applicants this year?
Sam, I would have to say we don't know 100% why, right? There's for some reason there's been this disdain for the H-1B program by Republican congressional members and some senators for a significant period of time. The H-1B program has been attacked many, many times as saying that it takes away jobs from U.S. workers. There have been a lot of reports that have reviewed this and have shown that H-1B workers actually contribute significantly to our workforce. There are things in place that prohibit paying H-1B workers less than what you would pay a U.S. worker. Now, there might be some organizations that find a loophole, not even a loophole, but they get around that by classifying someone as a level 1 when they're really a level 4 in terms of the prevailing wage. So there have been some abuses by some organizations, but for the most part, U.S. employers are employing H-1B workers when they can't find a good U.S. worker, right? And a U.S. worker is a permanent resident, a U.S. citizen, an asylee, or a refugee.
Yeah.
So there's been that tension for many, many years. Unfortunately, some of the congressional representatives don't really want to understand and see the documentation that shows the significant value that H-1B workers bring to the United States workforce. H-1B workers are also entrepreneurs, right? We've seen that as well. So those are some of the things that that is just, in a way, it's common sense based on the reporting that has been done to find out what has been going on with the H-1B program. And then, we have the tech industry here that are significant supporters of the H-1B program. So right now they're kind of at odds with the MAGA base, right? So you have the MAGA base that for some reason, and I don't understand it completely, because I don't think like that. I don't have a mentality where all H-1B workers are bad. Like, that is not the case. All H-1B employers are not bad, right? There are some bad apples, as with any kind of program, but the vast majority of H-1B employers and H-1B workers are really incredible, and they provide a lot to our businesses here in the U.S. So there has been that tension for a really long time. It's just kind of, with what's going on here politically, it's kind of brought that to a head. But there are those two factions that are fighting it out right now with respect to what do we
Yeah.
do with the H-1B program.
Absolutely. I think that's very well said, Kimberly. You said a lot of things about H-1B workers. And of course, they are getting less payment as compared to the American workers. And also, there's a being like tech industry is so many H1B workers are also there. So we have been seeing that H1B workers are a lot in the US businesses and US companies, and it's really hard to accept that they may find some difficulty in this year so that they can have jobs, and there are a lot of things that going on with the H1B workers. But I think you said that you are not in favor of this, and you said that they are incredibly good in their work. So I think that's what we got the idea from you. Like, how do you think about it? And we really want to know about it. Okay, so now my main question to you is, Kimberly, that as viewers are really concerned about traveling in the US, so what steps should they take to ensure that they comply with the new immigration regulations?
So for travelers, it's really important if someone is in the United States and is going abroad and then will be returning to the US, every time that someone seeks admission at the port of entry, it's at the CBP officer's discretion, right? So it's really important that if someone is in the US, they leave and they come back, or if someone is coming into the United States for the first time from abroad, it's incredibly important to make sure to have the correct documentation in hand. And that will depend upon the reason for the visit. But every individual has to have a valid passport, and that passport should be valid for at least 6 months beyond the anticipated length of stay in the United States,
Mhm.
because CBP officers can limit admission into the United States until the expiration of the passport. So the way that that would play out is if an H-1B worker or an L-1B worker has a passport that is valid until January 1st, 2026, but their approval notice is valid until July of 2026 into the United States until their passport expires on January 1st of 2026. So make sure to have the passport valid beyond the period of requested stay. Make sure to have an appropriate visa stamp in your passport if you are a citizen of a country that requires a visa stamp. Pretty much the only country that is exempt is Canada, and they
Mhm.
have visa requirements for a few visa categories, but for the most part, only Canadians are visa exempt. So an individual will have to have that H-1B visa stamp for their H-1B classification, their L-1 classification, TN, F-1, whatever is their status that they're seeking admission, and then documentation to support that, right? So someone who has H-1B classification, or in some circumstances, the L-1 classification, they would have a form I-797 notice of approval, and they want to make sure that they carry that with them. And if they carry that with them, and they also want to present it to CBP officer. My
Yeah.
recommendation is don't wait for CBP officer to ask for it, just include it with the passport, right? So that it's crystal clear that someone is seeking admission based on that petition approval notice. And then for individuals that are students in F1 status, they need to make sure that they have their appropriate Form I-20 that has been endorsed by the DSO for travel. And if they hold OPT or STEM OPT, we also recommend that they carry their EAD cards with them. And it also is not a bad idea to have an employment verification letter that comes from the employer stating that the individual is in fact employed and returning to the U.S. to continue to work with this entity, or to start work with the entity. And that letter does not have to be presented automatically to CBP, but it's something to have in your pocket, so to speak, in case CBP asks for proof of work authorization in the U.S. Yeah, via the employer. And then, you
Mhm.
know, depending on the individual's particular status, there might be additional documentation that is necessary in order to prove their valid entry into the U.S. But those are the key things, Sam, is the passport with a visa stamp and an approval notice.
Absolutely. I think that's really good of you that you explain everything about the H1B applicants, what are the things necessary for them, for the L1 visa applicants, for the students as well. Also, Kimberly, I would like to know it from you, like when they go to the CBP officers. So, can you give us some examples, like what questions do they ask from the applicants?
Yeah, sometimes the officers will ask, what status are you requesting admission in? probably not in that exact language, but, how are you coming into the US?
Mhm.
What is your status? Let me see your passport. Where do you work?
Okay.
Who is your employer?
Mhm.
Um, what period, when do you want to, geez, it's escaping me right now, but what I want to say is the officer might ask, when is your H-1B valid until, right? That's another question that they could ask.
Mhm.
They could also ask just a couple of questions to understand if the person does in fact work for the company. Because the CBP officers have so many people that they are reviewing at an airport, right? When people come in on the plane, they have very, very limited time. So
Yeah.
typically the questions are really, really fast. Like, what's the purpose of your visit to the US? I'm in H-1B status, right? So you want to make sure that it's crystal clear. Or I'm in H-4 status. My spouse has H-1B. So it's typically, what is the purpose of your visit to the United States?
Mhm.
Only answer the questions that are asked, right? There's no reason to provide additional information. And one exception that I always want to tell people, because individuals in H-1B status or L-1 status can use an H-1B visa stamp from company A, even if they're with company B, it's important that in that circumstance, the individual makes it clear that they are coming to the US to work for company B, and here's the approval notice. Because a lot of times officers might just enter the information based on the visa stamp. But if your employer is your new employer, and it might even be an employer you've been with for over a year, but if the employer on your approval notice is not the same employer where you obtained your visa stamp, make it crystal clear that you are entering based on that H-1B approval notice or L-1 for the
Mhm.
employer for that period of time. So that's where I say the one exception where you would give a little bit more information to the CBP officer at the port of entry. Otherwise, just answer the questions that are asked. And typically, individuals are not placed into secondary for additional questioning unless there's something that an officer thinks this doesn't pass the smell test, right? There's just something odd here. So those are some things to definitely consider before entering the U.S. And the other thing is, I guess I don't ever feel like I have to say this, but I do, and I will, is just be really polite to the officers, even if they're mean and not very nice. They could be having a really bad day. Don't contribute to that, right? It's always to be respectful. And that's where I see some issues that happen is where an officer may not be the most pleasant person, but that results in the individual not being very nice or being rude as well, and that can result in bad things happening. So, as much as it might be difficult, always be nice, always be respectful, and if there's any questions, with respect to if someone has a question, they can ask for a supervisor if there is a problem that's happening with the CBP officer.
I think the last step was really important because most of the time, we forget the last one. But I think that was really great. Thank you so much, Kimberly, for making us aware about these very, I would say, important tips and, very, I would say, the tips that we can never exclude from our list. And the last one was also very great to be respectful because we should understand how frustrated they might be by inquiring each and every applicant. So it's really tough, but I think now we at least got to know, what are the steps or what are the tips that viewers can be, can check out to travel to the US. And also, Kimberly, with this I would like to know it from you, like how have the executive orders affected the rules for students who are entering the US?
So it's just as with H-1B individuals, it's pretty similar, right? Additional vetting, potentially asking additional questions of an F1 student at the port of entry, ensuring that the student has their appropriate documentation in hand, right? Their passport, their visa stamp, the endorsed I-20, and if they have OPT or SEM OPT, then that EAD card. So that's really important. One of the other things to consider is there's an executive order that was signed. I think it may have been last week. I know the weeks are blending together right now with all the executive orders that are being issued. But there's one that is directed against anti-Semitism, and there were some students who had protested with respect to the war in Israel and Gaza that were pro-Palestinian. And that executive order essentially says that if individuals are doing something that is perceived or is in fact anti-Semitic, that they can be arrested. So there have been actions and talk about the administration asking for information from universities and colleges about individuals who may have participated in certain protests. So that's something for students to be aware of. And then the other thing, and this isn't just students, but it kind of reminds me right now when I'm talking about the anti-Semitic or the executive order on anti-Semitism, that there's a Laken Riley law that was just signed by President Trump, which essentially says that if anybody is arrested, not convicted, but arrested, they can be detained and deported. So that is something to be really careful about. I know individuals don't come to the United States with plans to violate the laws in the United States, and individuals in F1 status and non-immigrant status, that's typically not their main reason to be in the U.S. But sometimes things happen. Something as what a lot of people think is, well, it's called a petty theft, which is stealing something from a grocery store. People people just need to be aware of this new law that makes it really difficult for individuals in non-immigrant status, because they have that situation where they could be arrested and detained for a violation before they're even convicted of the crime.
All right. Also, Kimberly, are there any additional documents that maybe for students that they need to be, they need to have during their traveling?
I mean, in addition to, so they always need to have their Form I-20 that's endorsed by the DSO for their travel, their OPT and their STEM OPT EAD card, if they've already graduated and are working based on those. If a student might be engaged in curricular practical training, that would be noted on their I-20, and they might want to have a letter from their employer confirming that they are, returning to work. Same thing with individuals who have already graduated from their programs and have OPT or STEM OPT. A letter from the employer confirming their work in the United States can be presented to the officer if the officer asks for proof that they are, in fact, abiding by their work authorization with respect to the OPT or STEM OPT.
All right. Okay. Also, Kimberly, do you think that the students they have a better chance in this year to travel to the US as compared to the H-1B workers? And what's your call on that?
The F1 students have in the past, in many instances, have been given priority when it comes to visa application processing so that they can ensure that they're at the school when classes start. So there has been some, I wouldn't say preferential treatment, but there has been some consideration of individuals who are in F1 or M or J1 status that are starting a program. So the consular posts have put those visa applications first, specifically in the summertime, right? So people can get into the US for their programs. So that is definitely something that has been more preferential for individuals in F1 status compared to H1B status. So those are some things to think about. Right now, we haven't seen any significant issues that have happened with individuals in H-1B status versus F1 at our ports of entry. And I hope it continues that way, but we will see.
Yeah, absolutely. That's okay. Okay, so Kimberly, right now we have gone through a lot of different perspectives about today's topic. With that, I would also like to know what are the legal rights do travelers have if they experience increased security checks or face some unexpected delays?
So when someone is applying for a visa stamp at a U.S. consular post abroad, if their application is placed in administrative processing, it could be one, the officer needs a copy of a resume or information about their job duties. And so once the officer receives that documentation and or information, Typically, the administrative processing and the visa application are completed within 3 weeks, for the most part, is what we've typically seen. Um, there are situations where someone's application may be subjected to additional background testing, which means either the FBI background test or background security clearance by various other government agencies. In those situations, if a visa application case is in administrative processing, it could take as little as 3 weeks for the review, or it could take several months. So those are some things that could significantly delay a visa application process,
Mm-hmm.
especially under the executive order that calls for extreme vetting, right, of individuals coming into the US. When someone, once they get their visa stamp in their passport and they come into the US, now they're being reviewed and inspected by Customs and Border Protection. So if an individual has any history in their background of a status violation or a criminal issue, they definitely want to talk to an attorney to understand how that may impact
Mm-hmm.
their time with the CBP officer at the port of entry, right? What questions to expect, how to answer them, and how to be prepared for them. So that is one thing that individuals can do in advance if they have a prior immigration status violation or a prior criminal issue. Make sure to speak with experienced immigration counsel to know what their rights are at the port of entry, what they need to present, and how they should reply to various questions. So typically
Mm-hmm.
that's what we'll see with CBP. And as I mentioned, some individuals who have been entering under a parole document, specifically humanitarian parole, they may be placed in secondary inspection for additional questioning and for the officers to also confirm that their parole document is still valid.
All right. So, Kimberly, as you mentioned about the criminal backgrounds as well, I would like to know it from you. Like, what are the implications for travelers with past immigration violations or criminal records under the new orders? Yeah.
So for some individuals, with our new order, one second, I'm sorry, I have to cough. No, I'm okay. All right, sorry about that. With some of the new executive orders, but especially under the Lake and Riley Act, our understanding is it might be for criminal issues going forward, but it could be individuals who have had a prior arrest, and if they have not yet concluded that criminal process, that is something that they want to make sure before they're leaving the US that they're not going to have issues returning to the United States. So again, talking to an experienced immigration attorney and individuals who do run into unfortunate issues with our criminal system should in fact work with a criminal attorney and an immigration attorney who are
Mm-hmm.
experienced with the impact of criminal law on immigration status, so that a criminal attorney doesn't do something that would be advisable just from a criminal defense perspective, but could have a negative impact on someone's immigration status. So that's really important to have those two attorneys work together. We call it crimmigration, to help individuals. So those are my recommendations and advice is to seek counsel before ever leaving the United States if you're already here in the US, so that you can ensure that you're prepared for a reentry to the US. And if there's any kind of possibility that you might not be admitted back to the United States, and that's something to really consider and talk through with attorneys.
That's right. I think Kimberly has said it very well. And friends, I would also like to know you that it's very important to seek legal advice and to know the legal rights as well. So why don't you go and contact attorney Kimberly Best Robideau and consult with her, or let know about her what you guys are facing, any problem or what queries you guys are having. So please go ahead and contact her on the given contact details that has been provided on the screen. So I think the contact details will be on the screen soon, but I would like to know, let her numbers know. And that is 619 4010. This is a contact number. And you can also email her in case if you're not able to contact her. Then you can also email her on the email ID that is krobido@wolfsdorf.com. And you can also visit her website that is www.wolfsdorf.com. So this is a contact detail, and with that, Kimberly, I can see a lot of viewers who have joined us. I can see Ram, Yash, Gauravi, and Rekha as well. So thank you so much, guys, for being here. And let's take first question of Ram. So Ram is saying that I'm planning to visit the US this summer on a tourist visa, but I have heard about new executive orders affecting travelers. Should I be worried about any sudden changes when I land at the airport? Oh God. Okay, yeah.
Okay. Can you say that again, Sam? I want to make sure that I'm understanding it correctly.
Sure. Let me read it out again.
I'm
So,
planning to visit the US,
this
right?
summer on a tourist visa, but I have heard about new executive orders affecting travelers. So, should I be worried about any sudden changes when I land at the airport?
So that is a good question. We are anticipating some additional information or travel bans coming out in the next approximately 45 days or so that could impact travel to the US in the summer. One of the things that I recommend is just keeping on top of any visa changes and admission requirements into the United States because they could change at any given time. So what we're saying right now might not be what's in effect come June or July. So it's really important to just stay on top of any kind of changes that might come about between now and then. And that would be because of the executive orders that are asking for extreme vetting, for
Yeah.
additional security at our ports of entry. So those are some things to consider.
Absolutely. I think Ram is really concerned because he just asked that he's really worried when he arrived to the airport or when he landed to the airport, there might be some sudden changes. I think this is something that, every viewer and each, I would say everyone is really concerned that as soon as they land in the US, there might be some new executive order, there might be some new changes because that's what's happening in the US right now. So thank you
Right.
so much, Ram, for your question, and thank you so much, Kimberly, also for your answer. Let me take Yash comment, and Yash is saying that I am a green card holder, but I have been living outside the US for almost a year due to family reasons. Will the new executive order affect my re-entry, or could they question my intent to maintain permanent residency?
Yeah, that's a good question. And absolutely. So CBP officers have typically taken the viewpoint that if someone has been outside of the United States for 12 months or longer and they don't have an application for or an actual reentry permit, then they typically have abandoned their permanent resident status. That's the perception by CBP officers at the port of entry. If someone has been outside of the United States for more than 6 months, there can be a presumption of abandonment of permanent resident status. So it's really critical that an individual who is outside of the United States for more than 6 months apply for a reentry permit. And that reentry permit has to be applied for while physically present in the United States.
Mhm.
And one of the things that officers do ask is where's your residence? So if someone's main residence is now abroad, that is indicative of someone not maintaining their lawful permanent resident status in the United States. So that has been the rule and the law for many, many years. CBP will probably be tightening up their questions and possibly having more actions of individuals where they are saying you are not maintaining your lawful permanent resident status. And an individual in those circumstances, if the officer says we're revoking your green card, essentially, person should ask for immigration proceedings in order to prove if they are in fact, you know, keeping their ties and maintaining their ties to the United States. So that's what's really, really important. If anybody has any possibility of being outside of the United States, once a permanent resident for more than 6 months, it is definitely recommended to apply for and obtain a reentry permit. And that reentry permit is, when the individual submits an application to the Immigration Service saying, hey, I'm a lawful permanent resident, I'm going abroad for a period of time, it's up to 2 years, because of family reasons, medical reasons, or I have a temporary job, but I intend to return to the US and I don't want to abandon my permanent resident status. So in those circumstances, the reentry permit is that document that tells the CBP officer, hey, this person already told USCIS that they intend to be outside the United States, but don't want to abandon their permanent resident status.
That's right. Okay, so I think we already talked about Yash comment, and let's move ahead and let me also take Gauravi one. So, yeah, just I don't know why am I not able to show this. Yeah. So Gauravi is asking that as someone who is concerned about online privacy, I would like to know how will the expanded biometric data collection and social media monitoring under the new executive order affect international travelers like myself? What specific information will be collected and how will it be used? Yeah.
That is a good question. We don't know exactly what information will be collected or how it will be used. What you may see is happening here in the United States is with our Department of Government Efficiency essentially asking federal workers if they have loyalty to President Trump. We
Mhm.
could anticipate that individuals who have voiced opposition to President Trump or to his administration could
Mhm.
potentially have issues entering the US. That's speculation at this point in time, just kind of based on what we're seeing. It isn't, in fact, that we know of happening or definitely happening, but it's just something to consider. And again, that's based on what we're seeing with the federal workers. So, to the extent that people are posting in social media, it's probably best to be a little bit more, what's the word I want to use? Just be more careful about what's being posted.
Absolutely, because most of the time, we have been seeing fake news are also there, and most of the time, people are really getting anxious and concerned about when they got to know about those things. So it's very important to have a very credible source of your learnings as well, because that can mislead you as well. But I think Gauravi, thank you so much, and Kimberly has already answered your question. So in case if you still have any follow up question or any query, then please go ahead and post it in the comment section. And let me take Rekha's comment now. So Rekha is here and she is asking that as I navigate the recent changes to the H1B visa program, how can I ensure that my employer is complying with the new rules regarding specialty occupation, definitions, and wage requirements, particularly when dealing with complex or emerging fields like AI and cybersecurity?
So, with respect to that, employers are going to be working with their immigration counsel to ensure that they are reviewing the regulation as well as any new policies and orders in order to comply with the specialty occupation requirements and prevailing wage requirements. So, the requirement for the H 1B program is that an employer pay the individual H-1B worker the prevailing wage for the position based on the duties, the minimum requirements, and the location of employment, or the actual wage, whichever is higher, and the
Mhm.
actual wage, the wage that is, offered to an individual. So that's one thing that needs to be complied with, and that is, whether or not an employer is complying with the actual wage requirements is something that is reviewed by the officer when they are reviewing an H-1B, when they're adjudicating an H-1B petition. So, with respect to any, the changes for the definition of specialty occupation and newer positions, emerging positions, um, preparing the H-1B petition is something that would be done by the employer and by the immigration attorney. And as we, move forward, we're going to learn more and more because right now we don't know necessarily how the immigration service is going to treat some of these new emerging positions, how they're going to be, whether it is very strict or high level of scrutiny of H-1B petitions for certain specialty occupations. So at this point in time, it's kind of we're waiting. We're not waiting, but as we file petitions, we are seeing what trends are coming out in order to be able to address those in petitions going forward.
That's right. Okay, so I think we all are waiting right now, like what's going to happen, and especially after this new administration, and that too, we have been seeing a lot of things that has been implemented by Trump, and that too, I think not more than 2 weeks, right? So, okay, I think Yash is saying that thanks a lot for that information. Thank you so much, Yash, for being here and participating in this session. Kimberly, we do have some Facebook questions as well, so I would like to know it from you. That can we go ahead and uh, ask these questions?
Sure.
That's great. Yeah, I think this is the first question that we got from Rohit. And he's asking, my spouse and child's H4 visa is expiring on 13th Feb. Their H4 extension got filed on 4th Feb. So are they good to continue in US while their H4 extension petition is in progress, or they will need to leave US by 13th Feb?
Yeah, as long as the principal beneficiary, so the H-1B beneficiary, is maintaining valid H-1B status, and
Mhm.
the H-4 application for extension of stay has been submitted before the current I-94 document expires, then the individuals in H-4 status can continue to remain in the U.S. while that H-4 application for extension is adjudicated by the Immigration Service. And again, that's also as long as the H-4 spouse hasn't violated status by working without authorization or other immigration status violations. So the main rule is that as long as the request for the extension is filed before the current status expires, then an individual can remain in the U.S. while that application is adjudicated by the government.
All right. Let's move ahead with the next question. And this is a question that we got from Sai. So he's asking that I'm requesting guidance on emergency traveling to India on F1 OPT as unpaid intern. And also, I made initial transfer from university to day one CPT college. Will it be a problem? What are the possible questions asked while returning back to the US?
Yeah, Sam, unfortunately, this one is really based on specific situation and would require, that legal advice by an attorney. So anything that I provide here, would be really generic and that would not help this individual. So I would really recommend seeking guidance from an immigration attorney just to ensure that any kind of travel will not have a negative impact on status in the U.S. and to be prepared for what documentation might be needed, because this is a slightly unique situation where someone was on an unpaid internship and is now day one CPT. So sorry about that, but it's just a really, really fact specific situation that really needs attorney guidance.
I think that's completely all right because we have an expert attorney here. So, Sai, please go ahead and you can contact Kimberly Best Robideau attorney in 619 and you can also email her. Her email ID is krobideau at wolfsdorf.com, and you can also visit her website, that is www.wolfsdorf.com. So I think these were some of the questions, and we do have one more question also from a viewer. Okay, this is from, okay, it's a question that my H1B extension has been approved. Does my wife's EAD get the automatic extension for 540 days, or should I have to file for the EAD extension before the expiry? That is end of March, in order to get the 540 days extension. Yeah.
Yeah, so that's a good question, and it's actually it's a very confusing situation for H4 EADs. So H4 EADs are valid based on the validity period of the H1B beneficiary, as well as the I-94 document for the H4 spouse. So the H4 EAD card is not automatically extended for 540 days
Mhm.
directly. If the H4 spouse has an I-94 document that is valid beyond the expiration of their current EAD card, then they're eligible for an automatic extension of that EAD card up to the expiration of their H4 I-94 document. So H4 EAD card holders do not get that automatic 540-day extension, but rather the period of extension is based on the underlying H4 I-94 document, which could potentially be 540 days. But when an H4 extension is filed together with the H-1B workers extension, they should be adjudicated at the same time, although now the USCIS is saying that they're eliminating that policy. So that's really something to be, to watch out for, is that the EAD card can only be automatically extended through the validity of the H4's I-94 document.
That's right. Okay, so I think we have already covered a lot of questions, and this is the last question that I think we should cover from the Facebook because I have some more questions to ask. So, Zafrin is asking that I was on F1 visa, finished the degree, and changed the status to B2 visa. Right now, I'm on B2. It is valid until March 20 this year. In the meantime, I had some health issues. I have doctor letters as well. I want to apply again for B2. Last time it was a change of status from F1 to B2. I submitted I-539. This time again, I'm applying for B2. So, what form should I fill out? If anyone could let me know about the procedure. Yeah.
Yeah, so an extension of a B2 is also submitted on the form I-539. That's for the form I-539 is for a change of status or an extension of status for categories such as the B2.
All right. So I think that's all. We have already covered a lot of Facebook questions, and now, Kimberly, I would like to come back to my questions that I have prepared for you. So I would like to know it from you. Like now, we are seeing a lot of immigration changes that's happening in this year. So do you think that these immigration changes may lead to some hostile relationship between the U.S. or the other country, or will the relations will remain the same? Do you think it's going to affect their relationship?
It's a good question, Sam, and I wish we all had a crystal ball to know what's going to happen, but it definitely could have an impact, right? If there are issues going on between the two governments, that could result in changes in visa reciprocity. It could result in visa processing times. So it definitely, the political environment could have an impact on the visa application procedures and or processes or even eligibility. So that is something to keep an eye on.
Yeah, that's absolutely correct because the H-1B workers, if they are also being affected, they have been having a very delay in their process, then automatically we can understand the relation between the two countries will definitely be impacted a lot. And but we hope it doesn't happen, but let's see what's going to happen. Also, Kimberly, I would like to know it from you that is there any specific visa category or any specific country that may face more challenges as compared to others?
Based on prior travel bans, more Muslim countries were impacted and had a negative impact with respect to their travel into the United States and their visa application process. So until we have more information about what countries may be impacted by a travel ban, I don't know specifically, but based on prior experience, that might be what would be happening with a future executive order.
That's right. And what about the visa category? Any specific visa category that you would like to mention?
Yeah, it's a good question. I mean, typically the student visas like F, M, and J have not been negatively impacted in the past. What was impacted in the past were visa categories such as H-1B and L-1. I mean, the Trump 1.0 did prohibit the issuance of visa stamps for H-1B holders, L-1 holders, as well as for E holders. So those could have a negative, could be negatively impacted. by any future policies or rules.
That's right. And I think we already understood that you said us that why H1Bs are affected and what people think about it. So it's very high time for the H1B applicants, and it's very important, friends, to stay updated and to know each and every changes that's happening, especially in the world of immigration in US. That's how you can save yourself, and that's how you can protect yourself. With that, I would also like to know one more question from you, Kimberly, and that is, which digital tools or mobile apps, are recommended from your side to stay updated on the latest travel and immigration policies? That could be anything like website, apps, or YouTube channel, anything that you prefer.
Yeah, I would say, um, people can subscribe to newsletters. Our firm WR Immigration does a newsletter that provides information to individuals about what's happening. We also have a lot of videos that we do online, but there's also a very reputable source is the American Immigration Council, and
Okay.
they are a nonprofit entity that follows what is happening with respect to immigration issues in the US, and they produce reports and fact sheets and guidance for the general public. So the American Immigration Council is a very reputable site that I would, recommend that people sign up for their newsletter, their updates, or check in on their website on a regular basis because they do provide accurate and informative information and guidance.
That's right. And I think that was really important question, Kimberly, because most of our people are just getting confused that where to take those credible news and where to, I mean, which website or which app should they rely on. So I'm sure that now they are getting these guidance from attorneys, so they will definitely look upon it and at least have a track, where to go ahead and which platforms they can look for the right information. So thank you so much, Kimberly. And it's almost an hour. We have covered a lot of questions. We got a lot of questions from viewers as well, and also different people as well. And here's another question. I think let's take this, and after that, we can move ahead with wrapping up. So, what should travelers with dual citizenship? Absolutely, this is another very important question. That what should travelers with dual citizenship be mindful of when traveling to the US under the latest travel restrictions?
So it's really important that, when individual enter the United States, if they have dual citizenship, that they enter using the citizenship for which they've been approved for a visa, right? That's really important that they do that. And it's also important just to stay on top of any additional or further travel restrictions for individuals that are from certain countries to see if our administration makes that applicable to those with dual citizenship. Typically, in the past, if someone has dual citizenship, they can use the citizenship that has not been impacted in order to enter the US. But again, we don't know how that might play out in the coming months based on potential guidance from the administration. So that's something to stay in tune and, as updates become available. But, for the typically individual with dual citizenship, they would be entering the US on the citizenship that has not been impacted or the citizenship through.
Absolutely. I think that's very well explained. And Kimberly, I think you have taken each and every questions very patiently. You explained everything in a very detailed manner. I honestly loved your answers, and always I really enjoy having shows with you because I get to learn a lot of things from you, and I'm sure our viewers are also learning a lot of things from you. So it's really good, and we are really honored to have you here. So thank you so much for being here. It was really a great show, a very informative show, and a very important show as well regarding considering today's discussion as well. So, any last message that you would like to say to our viewers before wrapping up?
Yeah, Sam, thank you for having me. It is always lovely just to speak with you and have this conversation. My recommendation is to stay update on what's happening with U.S. immigration issues because they can be changing, on a daily basis. So that's just one thing to just be aware of what's happening, especially if traveling to the United States, to make sure that you are protecting yourself and having the appropriate documentation to enter.
Absolutely. Thank you so much, Kimberly, for being here. And we are really waiting for your next time to come ahead and join our another show. So we'll definitely have a more show together, right?
Sounds good. Thanks, Sam.
All right. Thank you so much, Kimberly. Thank you so much, our friends also who have joined us and participated in this session. And thank you so much for watching this session till the end. Make sure that you are updated, you are connected, and also stay vigilant because that's how you can save yourself and you can protect yourself if you are planning to travel to the US in this year. And also make sure that you can contact attorney Kimberly Best Robideau, as that can be the best advice I could give you in today's episode. And the contact details are on the screen, so go ahead and contact her. And thank you so much, everyone, for being here. I'm also waiting for the next episode to have with attorney Kimberly Best Robideau. Stay connected, stay tuned. Goodbye for now, and take care, everyone.
Hi everyone, welcome to Immigration Talk Show. I'm Rajni Bharara, your host, and welcome back to this amazing show. Well, today, before I move ahead, let me very quickly read out this important disclaimer first. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to this amazing show. Today, we are diving deep into the H-1B visa changes for 2025, and we have none other than immigration litigation attorney Jonathan Wasden, who is here to guide us through it. So without any further ado, let's welcome John to the show. Hi, John. Welcome back again to Immigration Talk Show. Thank you so much.
Thank you for having me.
Thank you so much, John, for being here. And this is a very important and a very timely topic because people are really confused about, and people really want to know what's happening with H-1B visas because some days, the eminent political figures and the important people are supporting them, and then they are going against it. So people are really confused about, what's actually happening. And are they in favor of H-1B visa, or are they not in favor of H-1B visa? And is the H-1B visa really secure, or what's going to happen? So a lot of questions there, which we are going to deal with today. John, let's directly, start the show. And because I have so many questions to ask from you. So my very first question, John, but before I ask you this question, I would like to tell our viewers that one of the big changes this year is that, jobs actually need to really match the degree someone has. And, it's not enough to be close anymore. It's been described as direct relationships. So, John, if you can tell our viewers that how do employers make sure that their job descriptions are spot on to, avoid getting rejected?
So there's really two different categories of employers and two different burdens that you've got to establish depending on what type of company you're going to work for. If you're going to work for a direct product company, say like an Apple or somebody like that, it's typically very easy to establish the degree requirement. You have to just put the specialty occupation code, and the Department of Labor connects that code up with the type of degree, typically computer science, And that usually will not get a whole lot of questions asked. The second category of employers are the staffing consulting companies. There is where we see all of the scrutiny on degree requirements. And it's tied into another requirement, which has been resurrected in the new regulation that's come out, which is attempting to force employers to show that they have a specific work project for the employee at the time of filing the petition. And that's a project with a third party, placement type situation. So in those cases, for those employers, what we're seeing is USCIS is pushing for involvement from the end client and having them endorse or provide information, excuse me, information about the degree that's required for the project.
Okay, thank you so much for answering the question, John. Also, I would also like to know from you that if someone requires a specific job and they have like a specific degree, but they are not completely related, but like closely related with the relevant experience. So would that still be considered a valid match under the new rules?
One second. My apologies. Yeah, so the closely related thing is going to be driven by a couple of different factors. And again, if the Department of Labor says that the job that you're doing, the specialty occupation or the standard occupational code requires a degree in that specific specialty, then that should really satisfy it. Now, the question is going to be for staffing companies, the project that you're working on, they're asking for details about that project to show whether or not the degree matches up with the project that they're going to be working on. Now, in reality, the vast majority, if not all, are going to be the same. They're all going to be requiring a degree in computer science or equivalent. And most of these things, I don't think the degree requirement is going to be the issue. I think where the issue is going to come in is the involvement of the third party or the client and them endorsing the petition basically, or providing their requirements for that contract.
Okay. And what if a company is hiring for a brand new role, where there isn't a perfect existing job description to follow? So how should they approach crafting that description?
So I guess it would really depend on what they're hiring for. As a general rule, hybrid positions do get a little bit more scrutiny, right? Quite a bit more scrutiny, depending on what the hybrid is. It's historically been the kiss of death to have any type of requirement for business administration in an H-1B. So I would say any type of hybrid that requires, a business administration is probably going to be a tough sell. But, if you're talking about, other types of hybrids where it's equally technical, those I think are pretty easy to craft the job description and fit into an SOC code. Just it takes a little bit of work and analysis and some documentation, but I don't think that's going to be a huge insurmountable burden for people to make.
Okay. Thank you so much for answering the question, John. And to our viewers, I would like to say that we are live on Immigration Talk Show. And if you have any question regarding the topic, related to H-1B, you can also give us a call on the number 425-436-6335. And you can put the access code 988888. Yes, so dial this number, put the access code, and you'll be able to ask your question directly from John on the show. So any question related to H-1B, please dial the number. So John, coming back to you, I would also like to ask that, USCIS is saying that for extension, they'll usually approve them unless something big has changed, right? So I would like to know that what counts as major change. People are a bit confused about what could cause problems. So if you can please explain our viewers that what exactly is major change, in either the job or the company that could cause an H-1B extension to be denied under this new policy?
Yeah, so all things staying the same, USCIS is allegedly going to defer to the prior adjudication that approved the petition if nothing's changed. Again, but what they're really getting at is a project-centric analysis. So if you've been working on a project with, client A, and then for the new petition, you're going to be switching to client B. That's not going to be getting any type of deference or respect from USCIS to the prior decision, because it's a new project and they'll analyze that particular project.
Okay. And let's say if a company maybe is acquired by another entity, does that also always necessitate the new H-1B application for existing employees, or are there exceptions?
So that there may be some RFEs, showing connecting the dots of ownership, especially if the acquisition was done, mid visa petition, like halfway through your 3-year stint. They'll want to make sure that the employee maintains status and they were working for the right employer all along. And so the maintenance of status issue may come up, and you'll just have to provide that documentation about the transition of ownership. That shouldn't really be a huge concern, but in terms of deference to the prior decision, if you're working on the same contract, you show that it's the same ownership situation as before, just a new owner has stepped into the same corporate structure. It shouldn't be a problem. You should be eligible for deference as long as the project hasn't changed.
Okay. Also, John, this is one question which I, usually get a lot from people. So they also want to know that, let's say, if the employee receives a significant raise, that reflects the market value. So also, is that considered a major change that could, impact the extension?
That is one of the trickier things to deal with, because the Department of Labor and USCIS have differing views on what constitutes a major change, especially in the wage area. USCIS doesn't comprehend how wages work in the private sector. And so you're going to draw some scrutiny if you have evidence of bonuses that really are disproportionate to the prevailing wage that's listed on the petition. Now, typically USCIS is not going to have access to what you're actually getting paid unless you give it to them. And the place where that happens typically is in the site visit. And the important thing for employers to know and for employees to know is during the site visit, 2 things. One is you have the right to a lawyer to handle that process. The other is your lawyer really shouldn't be giving evidence of pay to USCIS, because pay evidence is something that is by statute given to the Department of Labor exclusively. And USCIS has no oversight or no, statutory authority to manage the wage requirement in a particular case. So if you give them that information, you're just asking for trouble. So, my take is when I represent people in site visits is I push back on any type of request for wages just to avoid the problem. Because quite frankly, I just don't trust USCIS, especially FDNS, the people doing the site visits, to comprehend how the real world works and understand how business works. So I just don't want to complicate the situation at all.
Okay. Thank you so much, John, for those insightful answers. I see a lot of people joining us and are also posting their questions in the comment section, which I'm going to take in a bit. But before I do that, I also want to talk about, these worksite inspections. So, John, we are hearing that there will be more worksite inspections to prevent fraud, right? So it sounds like the employers need to be prepared. And if you can talk about, what are the key things they should have ready?
Yeah. So, the first thing there is they say it's to prevent fraud, but USCIS's definition of fraud doesn't really match up with the legal description of fraud. And again, in their mind, they're trying to make sure that the project that you're working on is the same project as when you had the petition filed initially. That's something that we're in the process of preparing to challenge in court. That's an aspect of the new rule that we're litigating. We've won this issue once before back in 2020. And we got this project-centric analysis rejected and kicked out of court. I don't see the end result being any different in the next case that we file. So until that court rules on it, though, we're stuck with USCIS's reg. And fraud is overtly going out and providing false information on an immigration application to get your visa. But switching employers is something that the law allows. That there's no fraud in switching contracts or switching projects, not employers. So, focusing on where you're working is not something that's fraud. And they misconstrue that and they screw that up all the time. So again, that's why, it's important for these site visits that you take advantage of your right to counsel. There's a law called the Administrative Procedure Act, and it's if anybody's writing it down, 5 USC 555. And that's what gives you the right to counsel in administrative proceedings like this. And your lawyer is going to know what the problem areas are. Your lawyer is going to know what they're actually looking for and how they're going to use it, and is going to be best situated to protect you and shield you from invasive, unreasonable questions and demands for document production. And so take advantage of that. I know a lot of people will sit there and say, oh, I haven't done anything wrong, I'll just give them everything they ask for. Those are the people that end up getting visas revoked and get fraud findings, because USCIS will take information that you give them that you have no idea that there's any problem with, and they will flip it and use it against you. And that could be the end of your future in the US, because some high school educated FDNS officer misunderstands what's going on. So you just really want to be careful. And if your employer hasn't retained somebody for the site visit process for the company, I would say just, it's probably worth retaining your own person just for that site visit, just to protect you, because it's a relatively cheap expense considering what's at stake. So I would just make sure that you don't give in, you stick to your guns, you tell them to talk to your attorney at every turn, no matter how hard they nag you, no matter how hard they try to manipulate you. Just keep bringing it back around to talk to my attorney, he'll schedule everything. And don't interact with them directly.
Okay. So should they hand over the documents to them, or should they tell them that talk to the attorney? And
yeah, the only document they should turn over is a G-28, which is the notice of appearance of counsel. That has the attorney's information. And the only thing they should say to the officer is, here's my G-28, contact my attorney, or I'll get my attorney's information to you, or my attorney will reach out to you. Everything should be channeled through the attorney. A very simple reason. If you say something or provide documents to FDNS and USCIS, then they can flip that around and use it as a fraud basis of a fraud finding against you. If I say something as an attorney, they can't really flip it against you so easily. And so, you buy yourself a little bit of protection and insulation. These site visits are getting far more frequent and far more aggressive than they've ever been before, in large part because they have, hired so many of these FDNS investigators, for lack of a better word. I think they're over 2,000 now, and just 4 or 5 years ago they were around 800. So they've really expanded their reach and scope, and they're bored with nothing to do other than harass people. And these are not the open-minded type of people that you would like to have working in government. They are all on board with Stephen Miller and Trump, and they are not to be trusted.
Okay. And John, this is also one of the important questions that we get from a lot of our viewers. Sometimes they're worried about losing the original document, right? So they also ask that can they keep the copy of the document with them if they get these visits, or do they really need to have the original document with them?
So for the G28, the G28 can just be electronic. Anymore, everything, you should take a digital copy of everything with you anywhere you go anymore. It's easy to do. You've got the cloud. So I would have all of your documents organized electronically. If you want to hold on to the hard copies, fine. But I would think electronic copies should be fine as a general rule.
Okay. Okay. And John, also, are there specific red flags that these immigration officials are likely to look for during these employee interviews?
So it's interesting because they will just get hooked on something that is incredibly inconsequential and you wouldn't in a million years think would be a problem, and they will twist it into a problem. We see this a lot, especially at the port of entry with CBP, but we've also seen it with FDNS, where somehow they get access to your email, like you give them your phone or you give them access to your email account, and they'll see that somebody emailed you a draft resume that you used as a template when you created your resume. Everybody who's ever made an initial resume, especially early on in their career, has borrowed somebody else's resume for formatting to make sure they're doing it right. I did, many times. What USCIS and CBP are doing, however, is they're saying, oh, you're using somebody else's resume. That's fraud. You're inadmissible. That's a fraud finding. Absolutely bonkers, absolutely crazy. Doesn't meet the legal definition for a fraud finding, but that's how far they're going and how far they're reaching to mess with people. And so you just really need to protect yourself and advocate for yourself and set up some firm boundaries so that you don't give them the opportunity to mess with your life like that.
Absolutely, absolutely. And John, do you think, are there some specific industries or maybe some sectors or company sizes that are more likely to be targeted for these worksite inspections?
Yeah, I think the consulting, staffing industries are the ones where all this focus is being placed. There is a smaller degree of attention given to EB5, and that's a kind of a minimal role for FDNS, but most of it is looking at F1 OPT issues and H1B issues. That's where the vast majority of their time is spent. And it's all, for those cases, it's almost all within the staffing and consulting industries for IT.
Okay. Okay, thank you for answering the question, John. Let me quickly say hi to RK. Hi, RK. I see your questions, and I'm going to take those and ask from John. And hi, Bhavin, Rahul, and Trisha. I'm very quickly going to take your questions. Please stay there. Let me, finish a few of my questions, and then I'm completely going to move to your questions. John, I would like to talk about the H-1B lottery also for a bit. So the H-1B lottery now, not only focuses on individual applicants, focuses on individual applicants and not just applications, right? So how does this new process change the odds, and how can people improve their chances?
So there's really no way to improve chances for an individual applicant any longer, because it doesn't matter how many companies register your name, you only go into the lottery once. So it's when they came out with the lottery the first time around, immigration lawyers looked at the process that they were suggesting and said, this is going to be a massive mess. You're going to have, companies filing a whole bunch of duplicative registrations, and it's going to skew the odds in their favor. And USCIS, again, in their infinite wisdom, said they weren't concerned about that. And they would fix that problem by making employers certify that they would, file a petition if they were selected in the lottery. And we all know what happened. They looked like fools for creating a lottery system that was so flawed. And so then they started lashing out at individuals and companies that got H-1Bs for multiple registration filings. But in the new system, the new system is what a lot of people had recommended they do in the first place. And there's really no way to game that system. You go into the lottery once, it's in the random, and you get selected or you don't. And there's really no way to up your odds.
So then there is a downside to having multiple employers, submit registrations on behalf of the same candidate.
No downside, but there's no upside either. So, your name only goes in one time, regardless of how many job offers you have. So there's really no benefit or harm to having multiple jobs.
But then will this be considered, or maybe do you think it is going to reduce the chances? Because then, they might think that this person has applied a lot of times, or not the person, but has a lot of employers who have filed on his behalf. So will they consider this as maybe gaming the system? Because you never know. I mean, these days, anything is happening, right? So just curious to know.
Yeah, no, I don't think they'll consider that gaming the system, just because, again, gaming the system means that you're increasing your odds of selection, and there's no way to increase your odds of selection in the current system because your name goes in once. So the number of job offers you have is pretty irrelevant to where you may see them digging is in the petition process. If you have a whole bunch of different job offers, they may question if those were bona fide job offers. But as long as the petition that you're getting hired for is a bona fide job offer and they can establish that, I don't think it'll be a problem that you got a bunch of others.
Okay. And also, are there specific maybe degree levels or fields of study that are currently seeing the higher chances of selection?
You have the master's draft, master's lottery, and you have the bachelor's lottery. And again, there's really no way to game the system. So your odds are the same if you have a master's or higher, a qualifying master's or higher. And if you're in the bachelor's group, everybody has the same odds. So I don't think there's really any secret sauce that you can come up with to increase your chances of selection.
Okay, and what about the smaller companies? Because, they often feel that maybe the larger companies have more chances. So do you think that the smaller companies have a disadvantage under this new system compared to the larger corporations that can afford to submit maybe more registrations?
Potentially, because, if you have multiple employees that you're putting in, you would have more bites at the apple for those employees. But when it comes down to it in the adjudication process, if you're selected, you're still going to have to show that you have the bona fide job offer. And that's where, the abundance of job offers to people, either from the company side or abundance of job offers for the individual, isn't going to help you. If you're applying for 1,000 employees, it's highly unlikely that you're going to have 1,000 bona fide job offers. And so that's just going to draw scrutiny. So I think it'll all even itself out, but I don't think it'll hurt or help in the selection process.
Okay. Thank you so much, John, for answering those questions. Now, I would like to also talk about the I-129 form. So, there's a new version of the I-129 form for all petitions, right? So, if you can please, tell our viewers that what do companies need to know about this new form?
So, for the new form, and also the supporting documentation, if you're doing staffing, they're going to want some extra details about the project and the client that you're getting placed at. And, again, this is one of those things that we're litigating, that we're preparing to fight. And if we're successful on this, the next thing we challenge is the form and have them change the form, because if the form is asking for things that, isn't supported by the outcome of the lawsuit, then the form needs to change. But for right now, the focus is going to be on the project and establishing whether or not you have a project. We're also seeing a return to a policy that was kicked out in court back in 2020, which is the short approval process. So you'll request the validity period on the petition, but if you don't have documentation to support a project for that entire duration, they're shortening it again. And so that's something that you're going to have to contend with is, do you have documentation to show that that project is going to last for the duration of the requested validity period?
Okay. So are there any particular sections of the new form that are causing maybe confusion or errors for applicants?
So not right now. I think most lawyers that are handling this are seamlessly transitioning to the new form. I'm not terribly concerned about the form per se as so much as I am concerned with the substantive requirements and the regulation that are driving changes to the form. And those are things we're just going to have to fight out in court. I think we'll be successful on the short-term approval issue. I don't think they can do that legally. And I think we'll be successful on their invalidating their project-centric requirement. But until we get there, USCIS isn't going to change until the court tells them to stop. Okay.
Also, but John, do you think that will there be any potential consequences maybe, or even if the applicants make even the minor errors or inconsistencies on the I-129 form?
So inconsistencies are always going to be a red flag. Okay. And so, for the employee, you just want to make sure that everything that you submit to your employer is as accurate as it can possibly be. And you just want to make sure that there's nothing in your work history that you're using to support your qualifications that has any problems. And it may be worth talking to your own counsel, your own attorney, if you suspect there might be a problem, just to make sure that all your ducks are in a row and everything checks out. Your employer is hiring the attorney to file the petition, and you can't pay for that. In the rules, you're not allowed to pay for that for good reason, which means that they don't really represent you. They represent the employer, and they have the employer's interest at heart. Okay. So if you're concerned about a problem in your immigration history and how to deal with that and how to address it, it's best to get your own independent analysis of the situation by an attorney that actually works for you. And your attorney that works for you can talk with the employer's attorney, and that you can come up with a strategy that's best for your situation. But just don't get tricked into thinking that just because there's an attorney working the case for their employer, that they're worried about you. They're worried about the employer.
Okay. Well, thank you so much for answering these questions, John. Let me now quickly move on to our viewers' questions, because I'm sure they've been waiting to get an answer from you. So let me quickly take RK's question first. RK, he's here. And he says, do you see the new administration trying to change the H-1B regulations? What do you have to say? Because they are mostly trying to change everything.
So here's the dirty little secret. As a general rule, and this was definitely true in the Biden administration, the political level, the people appointed by the president and confirmed by Congress, those people had very, very little impact, if any, on the direction USCIS headed. USCIS has been heading in the same basic trajectory for 20 years. And it's all the senior executive civil service people that are driving that. And they have been 100% on board with Trump from Trump's first administration. And in fact, the regulation that they created was pretty much everything that the Trump administration tried to do in its first term. And it got finalized under the Biden administration. It was basically a Trump regulation that Biden's team signed off on. But the people that were really driving that policy and doing that work were the career civil service executives. And they don't change with the administration. But they are completely on board with Team Trump. And I don't really see how Trump would make the regulation any worse than it currently is, because it's everything that they wanted on their first go round. So I don't really see them going through the regulatory process to change it, mostly just because it's a very, very long process. It's very difficult. And it's even more difficult when you have a brand new regulation that just came out. So I'm not terribly concerned about seeing any new regulations coming out dealing with the H-1B.
Okay. RK, I hope you have got your answer. He also has one more question. He says, are they allowed to give short or 1 year extensions?
So legally, no. But are they doing it? Yes. Now, they were doing something similar back in 2018, 2019, and we sued them on it and pointed out where in the statute it says that they can't do that. And the court very quickly sided with us and invalidated USCIS's policy. I don't see how we're going to have a different outcome this time around, just because the law hasn't changed, the statute hasn't changed. And so I think ultimately that process will get invalidated again. But until a court rules on it, until the judge bangs the gavel and enters an order, we're going to be stuck with USCIS screwing people over by doing these short-term extensions. So far, I haven't seen anything as crazy as we saw in the first Trump administration, where you'd see one-day approvals where they were mailed out and they were invalid by the time you received it in the mail. That level of insanity hasn't occurred yet, but I wouldn't put it past them to try.
Okay. RK, thank you so much for your questions. I hope you have got your answer. In case you have more, continue posting your follow-ups in the comment section. And meanwhile, let me take other viewers' questions. Rag is also here, and Rag says, okay, I think, Control, if you can please show the question. Okay, what changes can we expect with L1A and blanket L1? It's not related to H1B, but if you would like to answer this, John.
Sure. So we're already seeing problems with the blankets at the consulates. I expect the L1 category in general is just going to get a lot of additional scrutiny that they haven't seen so far. I mean, the dirty little secret is, as much as USCIS hates the H-1B program, they hate the L1 worse. And in their mind, the only people that really are eligible for L1s are massive multinational companies. And smaller IT companies really shouldn't qualify. I expect to see the policies of the consulate and also within USCIS to track their belief on that. And you'll see policies on L1s and adjudication trends on L1s get really, really tight and very difficult.
Okay. Rag, if you have any more questions or follow-ups, please continue posting them in the comment section. But I hope you got your answer. Thank you for your comment and your question. RK is actually back, John, and he says, so this means they will not try to remove the lottery method of selecting H-1B.
No, they won't. They won't take away the lottery. There's really no way other than the lottery to do it, just because they get so many applications in a fiscal year that they have to do the lottery.
But John, don't you think, sometimes, because mostly, especially the current administration, they are always talking about, merit-based selection of the visas, and people should be here in the country on their merit basis, right? And then they have this lottery selection process. Do you think these two align with each other?
Yeah, so I guess the merit filtering would be, do you qualify for the specialty occupation? Do you have the required degree? Do you have the highly specialized body of knowledge? That's where the merit comes in. And if you have a whole bunch of people that have that level of knowledge and that type of degree, how do you pick between them? It would, the lottery is the most efficient way. If they switch to, a weighted process in the lottery where they give different points and weight to different factors, they could do that and change the lottery in that way. I'm skeptical about how effective that would be and how quickly they could get such a regulation through the process. I think that would probably take longer than they have patience for. And it would be harder for them to get worked out in practice. It's because I don't think they understand, the space that well. You don't have people working in USCIS that have, bachelor's or master's in computer science. You don't have people with the degrees, and the experience to even know how to create a weighted system because they don't understand the industry. So I'm not terribly optimistic that a weighted lottery process would come into play based on merit characteristics.
Okay. Thank you so much again for answering the question, John. Let me quickly take maybe Trisha's question also. Trisha is also here. Trisha says, what are the key changes to the H-1B electronic registration process in 2025, and how can employers ensure they are complying with the new requirements?
So the biggest change is it's no longer an employer-centric process. Obviously, when you have employers, filing a whole bunch of registrations, and each registration goes into the lottery, there was, opportunity for some shenanigans because you can dramatically increase the odds of one person's selection by having a whole bunch of different companies filing applications. That's gone now, and so it's pretty easy to comply with the lottery rules at this point. Where the only thing that I have concern about going forward is how far USCIS is going to take this bona fide job offer at the time of filing requirement. That's what we don't know. If they're going to say that you have to have a signed contract at the time you file your registration, that would be an absolute nightmare. It's completely unworkable in reality. But if they took that position, if your job is bona fide only if you have a contract signed at the time of the lottery registration, that's going to be a mess. It's going to cause all kinds of problems for people.
Okay. So Trisha, I hope you've understood everything and you got your answer. Thank you so much for your question. Continue posting your follow-ups. But Rahul, also let me take the questions quickly. And Rahul says, I'm in the process of applying for an H-1B visa in 2025, and I've heard there might be changes in how the lottery works. Can you explain what different this year and how it might impact my chances?
Yeah, so again, it's employee centric, right? So an employee can have 20 different job offers, but they only go into the lottery once. Whereas before, if they had 20 different job offers, they could go into the lottery 20 times. And so they would have 20 bites of the apple instead of just one. Now everybody has the same odds. Everybody has that one chance in the lottery. And there's really no way that you can game the system to increase your odds of selection.
Okay. Rahul, thank you for your question. Let me take Bhaveen's question also in the meanwhile. As a current H-1B holder who wants to apply for a green card in the near future, do the 2025 changes to the H-1B process impact my green card application or timeline?
So probably not the application or the timeline. But what I will say is we see USCIS has become very, very aggressive in terms of going through people's histories, especially their initial H-1Bs, right before the adjustment of status interviews. So we see them go through initial H-1Bs looking for any reason that they can invalidate that initial H-1B and take the cap number away. So once they take that cap number away, you have no path for extensions. You'd have to go back into the lottery to stay in the US while you're waiting for your green card. And we see them do that time and time again, where somebody's almost at the finish line, almost at their adjustment of status, and they screw with them by revoking the cap H-1B, and it's almost always, in fact, I've never seen it go another way, based on something the petitioning employer did and not something the individual did. And we're 10 years down the road, and you're not working for that same employer, but you're getting penalized for what that employer did. And so just make sure all of your documents are very, very consistent and squared away. And if you're an H-1B that's working for a staffing company, I would not go to your adjustment of status interview alone. I would take an attorney, and I would take an attorney that's a little more on the aggressive side, just to make sure that they are not just going to roll over and let USCIS mess with you. So I wouldn't do your application by yourself either. I'd make sure that you have an attorney put eyes on that and really scrub it to make sure that your 485 is tight and your supporting documentation is tight.
Absolutely. So make sure that you do that. Bhavin, thank you so much for your question. And who better to deal with USCIS better than John, because John has an experience dealing with them. So make sure that you get in touch with Jonathan Wasden, everyone. You can give him a call on the number 844-592-7336. I would like to repeat the number, 844-592-7336. You can also email him. His email ID is support@wasden.law, support@wasden.law. And you can also visit his website, which is www.wasden.law. So make sure that you get in touch with him. And for your H-1B cases or any immigration-related cases. Now let me move to another question from another viewer. I think Rag was actually back. So Rag said he had this L1. Okay, he has in this also. He says, with the Dropbox changes, will a third country national consular option be invoked again for L1 and H-1B?
Sorry, say that one again.
With Dropbox changes, will a third country national consular option be invoked again for L1 and H-1B?
That I'm not sure. I don't know. I'd have to look into that one, honestly.
Okay. All right. Thank you, John. Let me take maybe ZQ's question. ZQ says, are there going to be ICE raids in schools and offices? Sorry, seeking an attorney's point of view.
So if the schools are complicit, yes, I would say in your red states, it's definitely going to happen. I would not be shocked at all. Keep in mind the way the Trump administration is rolling out their entire immigration enforcement plan is for maximum attention. I mean, Trump is an attention seeker who has to have people talking about him all the time, and there's no better way to do that than do something incredibly confrontational, like sending people into churches, schools, offices. And that gets his base really excited, because they love the idea of ICE going in and arresting people and kicking out illegal immigrants, and it gets him in the news. So it's a win-win for him. So yes, I would say the odds of that happening are incredibly high.
Okay. ZQ, I hope you've got your answer. Let me quickly move on to Empire's question. Empire says, doesn't the administration already have the regulations blueprint how to change the H-1B to a wage base from the last term? I know wage-based H-1B impacts smaller companies, but do you think it's fair? Not fair? I mean, do you think level 1 worker has the same merit as a level 4 worker? What do you have to say, John?
So, really, merit is a question in the eye of the beholder. If you're a small company, or if you're, any company, really, you've got to have people working at every level. You've got to have your entry-level folks that you're developing. You've got to have your senior folks that are kind of more in a advisory management expertise role. And you can't have, the saying is, too many chiefs and not enough Indians. you can't have too many people at the top and not have people at the bottom that you're developing and bringing along. So I think you need a mix in order for the system to work right.
Okay. Empire, I hope you have also got your answer. Thank you so much for your question. We only have 10 minutes. Let me quickly move on to our Facebook questions also, because we have a lot of questions coming from Facebook groups too. So Control, if you can please share your screen and maybe share the Facebook questions. Okay, so we have this question, John, from a viewer or a follower. He says, hello, can I submit the I-539 application online even though I have 2 children applying for F2 status? What do you have to say?
So I'm assuming they're talking about the extension of H4 status. So you can submit that online. If your kids are in college wait, I guess I'm confused about what their primary status is. Are they an F1? I don't know. I need more details on that one. I need to talk to them offline before I can answer that.
Yes, so to this viewer, I would like to say maybe you should directly get in touch with John regarding your case so that he can help you better. And also, like he said, he would need more details regarding your case. So yes, for now, let's move on to our next question. So Saundarya says, hi all, asking for a friend of mine filed for an H4 extension and received the receipt notice, but the renewal is still pending. Their current EAD is valid until March 1st, 2025. Is there a risk that their I-94 will expire after that date, even though they have the EAD receipt notice? If not, what should they tell their employer to ensure their position is held during this time? Need guidance for what are the options they have with the employee, and has anyone been in this situation? What steps can they take? So John, if you can please guide them.
All right, I'm going to read that. There's a lot going on here. So, I mean, it is a common thing, and I think we're going to see a whole lot more of this, that they will be delaying the H4, the adjudication of the H4 extension, which causes a problem for those people that need the extension approved in order to have their EAD extended. The prior Trump administration, the first time around, put the H4 EAD in their crosshairs, and they were really trying to make it impossible for H4s to have employment authorization. Same with L2s. And they were trying to change the regulation to just fully eliminate it. The problem was they couldn't get it through the regulatory process. And so when they weren't able to get it through the regulatory process, they just changed the way they adjudicate the H4 and the H4 EAD. They first split up the primary H1 and the H4. And then they split up the adjudication of the H4 extension and the EAD. And so you had a process that used to take a couple of weeks that now is taking, upwards of a year. And they designed the adjudication process in a way to almost guarantee everybody with an H4 EAD would be without status temporarily and would be without an EAD. And you couldn't apply for your EAD because you didn't have status. I anticipate we're going to see something similar to that again, and we're going to have to go back into court again. The last time when they did this, we ended up suing and getting the process changed. And there's some structural things in the law that we were able to change through litigation, like L2s getting their EADs incident to status, so they don't have to apply for an EAD. But we're probably going to have to be going back into court on behalf of H4s, because these processing shenanigans that they're going to start doing are really going to mess with people's lives. So everybody in that situation really needs to be aware and needs to start taking some some precautionary steps. And if folks want to reach out, we can tell them what they need to be thinking about doing early on to protect themselves.
Okay. All right. Thank you so much for answering the question in so much detail and for that insightful answer. John, let me very quickly take this next question. Navya, hi, I have a question related to document for Dropbox for H1B stamping. I'm working with consulting company. Can anyone please tell me if I should take EVL, employment verification letter from the consulting company with whom my H1B is filed, or the client that I'm working with?
So that's something you'd probably want to have an attorney put eyes on both documents just to make sure, and also on the petition, just to make sure there's nothing that's problematic. But as a general rule, what the consulates are looking for at this point is they're looking for proof that you have a contract you will be working on, that you have a client project. And so probably both of those would be useful to submit, one showing that the employer issued you an offer, and the other showing that the client has a project for you to work on. But again, you want an attorney to look at those to make sure everything matches up and that there's no contradiction or inconsistency. Because if there's any inconsistency in those two letters, that's going to be the kiss of death. And so, talk with an attorney, make sure that you're not doing something that's going to end up hurting yourself.
Okay, all right. Thank you so much again, John, for answering that question. Empire, if you remember, is back, and he says if they aren't going to increase the cap, it's the next best thing is to try to give as much of the small 85K H1B to level 4. What do you have to say about this?
That's a policy decision. That's what they pay the people at the top of the government to figure out. And if they want to do it that way, that's fine. We can work with that. But what is the best way to implement policy? I don't think anybody in the Trump administration is listening to me on that one. So my opinion probably doesn't matter much on that issue.
Okay. All right. So Empire, I hope you have got your answer. Well, thank you so much, John, for being here again. Those were our questions and answers. And thank you so much. It was an insightful episode. I still have a lot of questions pending. But then I would like to do a part 2 of this, and would like to ask those pending questions maybe in the second episode. And we can get into more detail about the H1B and the changes that are going to happen in to H1B in 2025, and we can take more questions because I still have a lot of pending Facebook questions too. So how about we do another episode on H1B and take the pending questions in that episode?
That sounds great.
Perfect. Thank you so much again. And to our viewers, I would like to say that to get in touch with John, make sure that you give him a call on the number 844-592-7336. I would like to repeat again, 844-592-7336. You can email him. His email ID is support@wasden.law. And you can also visit his website, which is www.wasden.law. Well, thank you so much again, John, for being here. It was great having you. And looking forward to seeing you very soon in another H1B episode.
Thank you, Rajni. It's good to be with you.
Thank you so much. And to our viewers, thank you so much for posting your questions. Thank you so much for being here. And I would also like to tell you that we recently launched, not recently, but today we launched our website, imisupport.com. So make sure that you also check out our website, imisupport.com. And if you have any questions, you can also reach out to me. My number is 732-707-9151. But for now, I'll have to take your leave, and we'll be meeting very soon. But for now, like I said, I have to take your leave. Make sure that you like this video, share this video, and also subscribe to Immigration Talk Show. For now, take care, bye, and keep subscribing and keep watching Immigration Talk Show.
Hello, everyone, and welcome to Immigration Talk Show. I'm Napasa, your host for today, and I'm very happy to have you all join us. So, folks, before we have our guest of for today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, a very warm welcome once again to Immigration Talk Show. We have a very important discussion lined up for you. Yes, today we're going to discuss about the March 2025 visa bulletin, which released a couple of days back, and it's bringing updates and challenges for those in the U.S. immigration system. So we're going to discuss about that. And yes, to help us break it all down, I'm very, very happy to welcome back our very well known expert in immigration law, attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. Prashanthi, so good to have you back. How are you doing?
How are you?
I'm good too, Prashanthi. Thank you so much for joining us today. And how has it been lately for you? Otherwise, you must be very busy with H1B season coming in and also so many changes with the new administration as well.
Yeah, it is a challenge. And, I'm on the phone most of the time because I have so many phone calls. People worried about their status, unsure about what the new laws mean to them. So it is a kind of a roller coaster kind of time. So, we just take one day as it comes and hope for the best.
Absolutely. And well, it's been very amazing that and very fascinating that. So sorry. Excuse me, my throat still hurts, but I was going to say I'm very excited to speak about the March 2025 visa bulletin. There are some changes and interesting ones as well. So definitely we have some questions. So I have this first one. How should Indian applicants, interpret the slow movement in the final action dates for family sponsored visas, and what strategies can they adopt, while waiting?
So maybe, Nipasa, we should first go through the visa bulletin for those who haven't had a chance to look at
Sure.
it.
Sure,
I was
Prashanti, you
thinking
can
we
go
should
ahead.
just, okay. So, to start off with, the visa bulletin for employment-based visas, um, USCIS has said that they look at the final action dates. So unless your priority date is, um, before that, the priority date in the final action date chart, you cannot file your 485. For the family-based cases, they're still looking at dates for filing charts, which is good news. That means there's still some scope for forward movement in the family-based case. So that's why they're still looking at dates for filing charts. Dates for filing charts. So with reference to final action chart for employment-based, let's go through the different categories and see how much movement there's been. So for EB2 and there's been a forward movement of 6 weeks. For India, for EB2 China, there's been a forward movement of 2 weeks. This is all for the final action date table, since we can't look at dates for filing. EB2 worldwide moved forward by 6 weeks. EB3 China advanced by a month, and EB3 other workers India also advanced by 6 weeks, and Philippines advanced by 5 weeks. All other countries for EB3 advanced by 2 months. So as you can see, there's been a good amount of forward movement of 6 weeks for EB2 and EB3 India, as well as EB3 other workers India, and there's also been some forward movement for China, forward movement for EB2 worldwide, and Philippines also has moved by 5 weeks. So that's in the nutshell what happened in the March visa bulletin. We can take up the first question, like you said, was
Yeah.
the slow movement for the final action dates for family-sponsored visas. Yeah, I mean, the family-based visas, yes, there has been a slow forward movement, but some categories have shown some promise and a certain amount of forward movement. What strategies can you adopt? I would say stay prepared. Keep all your documents ready so that when your date does become current, you're ready to immediately file your 485 because it may not be current the following month. So you have to be ready to file your 485 in any given month. So make sure your birth certificates you have, your non-availability certificates you have. Make sure you're able to get your medicals on time. So scope out the places that will actually send medicals within, a week or two. And keep watching for your priority date. Look every month in travel.gov under the visa bulletins for your particular month and your particular date and country so that you don't miss out if it does become available in a particular month.
Prashanthi, for giving us an intro to what we can expect. And folks, I would like to tell you that you can also participate in this discussion by calling us on this number 425-436-6335, and the access code is 988-888. Also, don't forget to hit the bell icon and follow us. Our channel is Immigration Talk Show. Subscribe to us at Immigration Talk Show and get in touch with us, friends. Hi, Asim. Thank you so much for joining us on comment. We are going to take your comment very, very soon. But for now, Prashanthi, I have my next question to you. And that is, with the F2A category, which is now marked as current for filing, what does this mean for spouses and children of permanent residents, and how soon can they expect to move forward with their applications?
Well, current for whom? It's not current though for Indian nationals, but it's close to current. It's June, I think June 2024. So pretty good. Very close to being current. You saying it's current for worldwide? I haven't checked, and I will check. But with reference to the visa bulletin in general, once it becomes current, it's important, as I said, for you to file as soon as possible, right? Because it may not be current the following year. So you want to make sure that you file it ASAP. And in order to do that, you obviously have to be prepared. Unless you're prepared with all your documentation, you will not be able to file. So while I was talking to you, I'm looking at the dates for F2A. Even for the dates for filing, it's July 2024 for everyone, for India, China, and all chargeability, all countries. For final action dates, it's actually 2022. But the good thing is, since we can use dates for filing, a lot of you should be able to file your case as long as, you filed your I-130 in July, on July 15th or before July 15th of 2024. So let's presume that your date is current, then I would say that you're able to file, you're able to get your application ready in the month of February, whatever is left of February. So you have, about 10 days in February to get your application ready, and you should be filing your application in the first week of March. In order to do that, obviously, you would need to get your medicals done quickly. You should, if you have not done them already, you should have your birth certificates ready. If you don't have birth certificates, then you should get secondary evidence, such as the non-availability certificate from your hometown, and also you should be getting, your, secondary evidence for birth, which is affidavits of support or school leaving certificate, a letter from the priest, etc. Whatever you have to show to prove your date of birth. This is great news for spouses and children of permanent residents, which is what F2A is, because they'll be able to file 485. They'll be able to, whether you're outside the country or you're in the country. If you're outside the country, you can at least start the process. You know, by hopefully your visa number will continue to be available and you'll be called for your interview. If you're in the country, you can actually file adjustment, which is a 485. And of course, you need all these documents that I just mentioned to file your 485. How soon can they expect to move forward with the application? As I said, if your date is current in March, you can file your application on March 1st. So the sooner the better.
Thank you so much, Prashanthi, for taking that up. And I would like to say hi to Yashwant. Thank you so much for joining us. We'll take up your question. And if possible, folks, why don't you join us on call? Our number is 425-436-6335, and the access code is 988-888. And folks, you can also call Attorney Prashanthi Reddy on her number 212-354 1010, and you can email Prashanthi at prashanthi@reddyesq.com, and go visit www.reddyesq.com to get to know more about Prashanthi Reddy. So, Prashanthi, I have another question, and that is with regard to the F4 category. So, siblings of U.S. citizens. So, has also seen significant delays, and what are the main reasons for this backlog? And do you foresee any improvements in the processing times for F4 category?
No, because there is a huge backlog and there continues to be a backlog for siblings of US categories for all countries, including India and China. And I don't foresee any improvements in processing time because there is so much demand and there's only a certain number of visa numbers available every year. So, as I said, the main reason for the backlog is the high demand and the limited number of visa numbers. So, unless there is some change, and there may be less numbers used up in other categories and they fall down to F4, which seems unlikely, or if there's some legislative new law passed where they increase the number of green card numbers for family based, I don't think we'll be seeing a significant change in the backlog for F4s.
Hello, everyone, and welcome back after the short break on Immigration Talk Show. I'm your host, Nipasa, and with us today we have our guest, none other than Attorney Prashanthi Reddy from the Law Offices of Prashanthi Reddy. So, Prashanthi, it's been a great discussion discussing about the March 2025 visa bulletin so far, and yes, we've taken up some questions. We also have more people join us. So, this is on your channel, actually, Prashanthi. Melly Caldito has joined us, and I think we should take it up. So, how about the F3 category, ma'am? They file August 25th, 2015. My room is City. Hello, ma'am. About the F3 category, please, we file August 20th, 2025. My mom is a US citizen. How long to wait, please?
It's difficult to actually say how long the wait will be. So if you're looking at F3, and even if you look at dates for, if you look at the final action date for India, it's July 2010. And for dates for filing, it's a little better, but not so much. It's July 2012. And for those who don't know, F3 is basically married sons and daughters of US citizens. So it's hard to tell. Sorry, we can't predict exactly how long it'll take. And if it's 2015, then they're working, as you saw, in 2012. And it doesn't move every month. So it's not like every month it moves a month. Yeah, so sometimes there's no movement at all, if you might have been noticing, for 6 months, and sometimes there's a sudden movement of 6 weeks, or 5 weeks, or a few months. So it's very sporadic, and it all depends on demand. And USCIS has said that they have a high demand for this year as well, just as previous years. And they've also said that we will not have as many visa numbers available as last year. So last year we had 160 something thousand visa numbers available, because the basic number is 140 that's available, and then they add unused visa numbers from other categories. So they don't think there'll be much of the unused visa numbers from other categories. So you'll have a minimum of 140,000, but maybe more, depending on how many are unused. And so with the family-based category, it's the same. We're not expecting a large surplus of visas. So I think the movement forward will be slow and sporadic, unfortunately. And not much you can do other than, hope that there'll be some change in the law, which will then speed up the processing time.
Okay. Thank you so much, Melly Caldito, for joining us with your question. If you could call us also, it would be great. And we have RK also. Hi, RK. Thank you for joining us. RK is asking, why can't DOS can't tell us in February, for example, that between October and January, X amount of green card was issued between USCIS and DOS. They have this information because they used to make the VB, visa bulletin.
Right, I don't know exactly why they don't give us that information. They do give us, for example, they have given us the information for 2024 as to, how many numbers were actually available.
Mhm.
But for 2025, they have simply said that what they've said, and I quote, the employment-based annual limit for fiscal year 2025 will be higher than was typical before the pandemic, though lower than in FY 2021 to 2024. We are dedicated to using as many available employment-based visa numbers as possible in FY 2025, which ends on September 30th, 2025. So they always tend to give the information for the previous year, but we don't yet have information for the present year. And I think even with reference to moving the visa numbers, they move them slowly, based on every month what the usage is. So I think they're able to, give us a number only towards the end of the fiscal year, because they are waiting to see how many 485s are filed every month, because that makes a difference as to what the visa numbers will ultimately be. And I can discuss that a little bit more in detail. I do have some numbers with reference to the 485s, that the number of 485s that are pending and have been filed, because that makes a huge difference with reference to what the visa bulletin will look like. So basically, every quarter they release these, USCIS releases these numbers. The last time they've released them is in September of 2024. They've released it for that quarter, and they've basically said for visa numbers that are current, the 485 spending for EB2 are range from 13,000 to 36,000 for last year. And EB3, the pending 485s for priority dates that are available were between 9 and 51,000. So you see, even for available cases, there is a backlog. That's 13 to 36,000 for EB2 and about 9 to 51,000 for EB3 cases. So this shows that even if your visa number is available for that particular month, you can still expect there'll be some delay in processing because there are so many cases that are in the backlog. They seem to be, on the whole, slightly less number of pending cases for EB3 when compared to EB2. So if your visa number is available only, say, for a month, you may not get the green card that month if it becomes unavailable the next month, because as you see, there is a backlog that they have to go through. Now, to your point with reference to visa numbers that are pending right now, priority dates that are awaiting availability, there is a huge backlog. For EB2, it's about 900,000 to 1.3 million for EB2. For EB3, it's about 500,000. So you see EB3 again, the number of cases is less when compared to EB2. So you can expect there'll be more rapid forward movement in EB3 when compared to EB2, from just based on the pending cases from last year. Of course, this changes every month, right? But this is, gives you an idea as to what to expect or what the average numbers are,
Yeah.
for any particular month. So you see that there is a huge backlog, continues to be a backlog. So, that's why we're seeing slow forward movement.
Yeah, and he was also saying, RK was also mentioning our monthly just published of the 140K green cards, how much is remaining, just so they can announce. But of course, we don't know why
Yeah,
don't they inform.
right, right. I don't know either. Maybe there is, it's more complicated than it seems.
Maybe.
I don't know.
Yes, RK, thank you so much for joining us once again. It's always good to have you. So if you can also join us, and Melly Caldito says, thank you, ma'am, Prashanthi. So let's move on now to our next question, Prashanthi, and this is with regard to the same F category only, but F1 and F3. So for applicants filing under the F1 and F3 categories, how do the dates for filing impact their overall timeline, and what key steps should they take while waiting for final action?
I think we kind of discussed this, the F3 category, through a question.
Yes.
What can they expect? I think we kind of discussed this, Nipasa, so we can move on to
Okay,
maybe the
let's move
next
to the
one.
E category, the EB2 and EB3 categories. For India, they continue to experience significant retrogression. So, what factors are causing this delay, and what are the best options, for affected applicants?
As I said, the huge backlog. I just read out a few numbers with pending 485 cases that were published last year, about 900 to 1.3 million for EB2, about 500,000 for EB3. These are cases that don't have priority dates available. And for cases that do have priority dates available, there is still a backlog of about 13 to 36,000 each month for EB2 and about 9 to 51,000. I think for a particular month they had very high backlog. So that's why that 51,000. But about, a few thousands for both EB2 and EB3, even for cases that are pending. So as you continue to see 485s being filed, you will see that the backlog just gets worse because the demand is so high, and the number of the priority date is not available because there's only 140,000, as RK pointed out, every year for them to work with. And if there are 1 million cases being filed, or there's a backlog of 1 million cases, there might be more cases being filed every month. 1 million versus 140,000, you can do the math and figure out why there is a backlog, right? And also in previous years, we had some cases not being like EB1 worldwide, or maybe EB5 or some family-based cases. The numbers were not being used for worldwide, so they were trickling down to India and China. So for last year, we had 160,000 available. That means 20,000 more than the 140,000. That was because of the trickle-down effect from the other numbers. And for 2023, we had 197,000 numbers available. So, that's like 50,000 above the normal level of 140,000. This was again due to, because about 6,000 EB5 visas were carried over from 2022 to 2023. Just giving you an example of what usually happens. And about 10,000 EB5 visas that Congress allowed to carry over for the next fiscal year for EB5. So, these are the reasons why there were more visas available. There was also trickle down from the other visa categories. And so, we had more numbers available in 2023. 2024, we had, as I said, 160,000 available. I think 2024, there'll be less than 160,000 available because they have said that there won't be as many numbers available as they were from 2020 to 2024. So you see, because of the high demand, there is a definite backlog, and we don't expect to see any changes unless the demand reduces for some reason, and we don't see that happening, or there is some legislative action taken. For example, there have been bills in the past, the Eagle Act, where they have asked for, various things. They've asked for the visa number limitations to be removed completely. They've asked for visa numbers from previous used years to be, that were, not used and went to waste, to be put into the present so that the availability becomes more. So there have been various things that have been proposed, but nothing has happened so far. So that's why we continue to see backlogs for EB2 and EB3 as well.
Right. Right, Prashanthi. Thank you so much for updating us about EB categories as well. I think we should take up more comments from our audience since
Yes,
they are very actively participating. So
yes,
this
certainly.
next one is from Sagar and Manisha. Hello, ma'am. My name is Manisha and I'm from Nepal. I've got my PD February 26, 2024, EB3 skilled worker. What's your prediction? How long do I have to wait more? Thank you.
So EB3 skilled worker, and the good thing for you, you're not from India. So if we look at let's go to the EB3 and look at employment-based category 3, all other workers it's 2021 for final action dates, and for dates for filing, it's 2023. Actually, no, it's 2021 as well. So there's not much difference between the two, final action date and dates for filing table. For all other workers, we're not talking about regular EB3, we're talking about all other workers, which is EB3s for jobs which don't require a bachelor's degree. Difficult again to predict when the numbers will become available. Obviously, we're not going to see a jump of 4 years this year unless something drastic happens. And again, we don't see a jump every month of a month, so it's difficult. I can't say that it'll be available in 4 years or 5 years. But something could happen where suddenly there becomes an availability of numbers. I mean, COVID was the last thing that happened, which really drove the dates forward, but we don't want another thing like COVID to happen. So I'm hoping that some legislature, some change in the law happens, which will make the numbers jump forward. Otherwise, I don't see any change in the demand. I think the demand is going to be as it has been in the last 5 years.
Right. All the best to Manisha. Thank you for joining us. Folks, let me remind you that you can also join us on call, and the number is displayed on top of the screen. So please join us 425-436-6335, and when they ask for the access code, dial in 988-888. And also, I mean, Manisha, RK, Meli Caldito, and all you folks out there who've joined us, especially whose questions Prashanthi has already taken up, please do not forget to subscribe to us, hit the bell icon, and thank you, everyone. Next up, we have Nikki G. I have an EB1 with priority date 12 2024. My old EB2 is 12 2018. Now, when I did I-485, USCIS rejected, saying dates are not current. How to fix this?
I have an EB1 priority date of December 2024. My old EB2 is 2018. Now, when I did 485, well, if your visa number is current, then you should be able to file. But again, we have to look at the visa bulletin. I don't know which country you're from. If you are from India, then obviously it's not current. EB1 is still in 2022 for both dates for filing as well as final action dates. But I see what you're saying, that you have a previously approved I-140 and you're trying to port your priority date, in which case then you should inform USCIS. When you got the I-140 for EB1, your old priority date should be reflected in that. If it's not being reflected, then you cannot file a 485. So in order for it to get reflected, you have to file an amended I-140 and ask USCIS to correct the priority date to 2018, that you want to port the old priority date. And that's the way to do it. You have to have an I-140 with the 2018, I-140 with EB1 2018 priority date, and then you file the 485.
Okay. She's currently in India, she says. So does it make a difference?
If you're in India, then you basically are asking for the I-140 to be ported. And then once it's current, then you file an immigrant visa petition through NVC. But for that, you have to show that you have a current I-140.
Okay. All right. Thank you so much, Prashanthi, for taking this up. And Nikki G, thank you for participating. This next one is from Shriva. This is also on your channel, Prashanthi. Can site visits happen for people on GCEAD?
GCEAD, which means 485. You have a 485 pending and you have an EAD based on that. If you're presently on a H1, that's when site visits happen. If you're on the EAD based on a 485, site visits shouldn't happen, because it really doesn't matter whether you're working or even not working. Because if you have a pending 485, you can choose whether you want to work or not. There's no constraints on where you should work, how you should work, terms and conditions, or even if you should work. But if you have a 485 from company A, and if you're not working for that company, then there could be an issue at maybe the 485 interview, where they're asking you if they're questioning whether the job offer in the 485J is valid or not because you haven't started working for that company. But other than that, um, the site visits that you usually see for H1s should not be there for GCEADs.
All right, right. So, do you see EB2 or EB3 PD January 2014 to be current soon?
Uh, January 2014 is a long way off. I don't think it's going to be current soon. I
Thank you
mean,
so much.
in the
Yeah.
sense that I know they are working on 2012, but still, I don't think that EB2 and EB3 um, will move that quickly.
Mhm.
Let's maybe by in the next couple of years. But it's difficult to say, really. I'm just, putting it out there, but it's difficult to say.
Speculating,
For
yes.
dates for filing, it's closer because it's 2013, so you're 2014, but it is January 2013, so there is a long move. For EB3, it's June 2013. So it's about, depending on which month you are, it could be a wait.
Okay. Shriva, thank you for joining us. This next question is from Abha. What are the predictions for F4 PD July to 2006 for India?
Everybody's asking me for predictions. I don't have, I'm not a soothsayer. I don't have a ball which I can look into and predict what the dates are likely to be. And for those people I know people release videos with predictions and they get a lot of likes, but that is, really, I mean, you can't take it seriously because you don't know, bottom line is. F4 is, of course, um, the most retrogressed. That's brothers and sisters, and they're working on 2019 cases for India right now, and 2006, in fact, for dates for filing. And yeah, so it's not 22, sorry, it's 2006 for F4. Uh, that's a long wait. And your priority date is July 2006. Yeah, so you're closer. Let's see. So July 2006, they're working on August 2006. So we've not yet reached, maybe a few months. What are the predictions? I haven't seen a huge amount of forward movement for F4. I know it's only a month, but wait and see. Maybe towards the end of the year, you'll see some more forward movement if they see that not many cases have been filed. Then you see like a jump sometimes towards the end of the year. That is, end of the year is September. So wait and see because it's only a month. I'm hoping that the date will become current. But again, we don't know for sure.
I'm sure many folks out there are hoping that. But yes, we got some more questions from our Facebook group. So let's take them up quickly, Prashanthi. So this first one is from Sagnik. My previous visa was F1. Have scheduled a Dropbox for H1B visa first time stamping at Chennai for March 7th, 2025. Do I need to cancel and schedule OFC and interview? My hometown is in Kolkata. Can I schedule for both offices and interview OFC and interview in my hometown? Can I reschedule the appointments now or do I need to wait till March 7th?
So, first time stamping. Why? Okay. Why, if you have a Dropbox, why do you want to cancel and schedule for an interview? I don't know why he wants to schedule for an interview, but it could be that sometimes with Dropbox, since you can't submit a lot of documents at the Dropbox, they are, sending out administrative processing 221G notices to Dropboxes, and then asking questions or asking for documents. So in order to avoid that, if you go for a personal interview, then you can submit documents, on demand. Go with the proper documents and submit them. Mostly they're asking for end-client letters or contracts, etc. at the consulate. They're also calling the clients to find out whether the job is actually available. They're contacting the employers to find out if the job is still available. So we're seeing a lot of 221Gs. You'd have to cancel one. You have to cancel one visa before you schedule for another visa appointment. So I think that was the only question that they had.
Yes. Thank you, Prashanthi, for taking that up. Now,
And you
this
can
next
schedule
question.
it. You can schedule for an interview anywhere. It doesn't have to be hometown. It could be any other consulate that's close to you.
Okay. Thank you so much, Prashanthi, for taking that up. Control, if you can tell us what's the next question, please. I dropped my passport on January 31st, 2025, and mine is H1 renewal. On 11th February, status changed to refused, waiting for passport to be returned. Is that due to the new rule? What will be my next step? Usually, how many days it will take to get my passport back? Any suggestions, please?
Uh, well, as I said, there have been a lot of 221Gs issued. Refused basically could just mean that it's gone into administrative processing and they're not immediately giving you the visa. But it's possible that they can give you the visa upon conducting their investigation, and doing their background checks, to see if the job is available, client is available, etc. So it's possible that they can still give you a visa. It's just that immediately, they've refused it, at least temporarily. That's what usually refused means, unless the 221G was refused, in which case then the refusal is permanent, and then they might send back the H1 to USCIS, and USCIS might send a notice of intent to revoke, at which point then the employer will be able to respond. They usually have 30 days to respond.
Okay. Thank you so much for taking that up as well. The next question, please, Control, if you can display it. Okay. I am reaching out to seek assistance regarding and I have encountered while to start a new application. It appears that my profile details match existing record and preventing me from proceeding further with the application process. Since I have no longer access to my old email ID and profile, what are options open in this situation? Any guidance?
I think what they're asking here is, I'm not sure what exactly they're asking, but are they asking for filing a new application? They want to get access to my USCIS website.
I think yes,
Maybe
it's the
that's what it is.
Mhm.
You can use a new email address to open a new account. If you already have an existing account with an old email address, you need a new email address to open a new account, which you can certainly do.
Right. All right. So the next question, please, Control. This is from Darsh. Hello, I had H1B Dropbox for 13th February today, and when went there for Dropbox, they denied and told there are changes in regulations on 10th February, and not I would need fingerprints and interview. Is anyone familiar to this scenario? I think he's talking about biometrics. Is it
Yeah, they
necessary now?
denied and told me that there are changes. Uh, I would need fingerprints. Yeah, I've heard this as well. Uh, And I've heard that, Dropbox, I mean, Dropbox is still available. I've not heard otherwise that Dropbox is not available. But, even with Dropbox, the officer has the right to call you for an in-person interview. And I'm seeing more of that happen. So that's what must have happened.
Okay. All right. Next question, please. Or okay, I think that's done. So this is Sarmad. This is on from our viewers. I'm going to submit my perm. Currently, they are processing October 2023. Do you anticipate the process time to increase?
The problem is under the Trump administration, they don't care about, how well they process it. They don't care about adding resources. They're basically against any kind of immigration. And in his last term, we saw processing times really skyrocket because they really cut down the staff. They did not hire new people. This is at USCIS, and the same thing might happen. We're seeing a lot of federal employees being laid off as well.
Mhm.
So from that point of view, yes, I think processing times for labor certs could increase. For that reason, also, DOL usually becomes more strict under certain
Mhm.
administrations, and also they become more strict when there are more layoffs. And when that happens, then audits increase, denials increase, and that also, you know, uh, causes your processing time to go up.
Mhm.
So yes, you can expect in the future that processing times, might go up.
Yes, plus there's so much vetting processes also going on. I think
Right.
things will be held on for quite some time. So, Prashanthi, before we go, if you still have some more time for one more or a couple more questions, I wanted to ask about the religious worker category. It is set to expire in March this year, 2025. So, what would happen to pending applications if no legislative action is taken? And are there alternative visas for religious workers?
Um, I mean, you could use the visas that exist, which is the H-1B, provided that it's a specialty occupation, which it may not be. So that's why religious workers are a niche category because they are very unique in what they do. So they might not be other visas that unless the particular job requires a bachelor's degree in a particular field, and if it's something like that, then it could be a be you could possibly file a H1. If you belong to a different country like Australia or Canada, you could possibly file a TN. Again, if you meet those requirements, which um, may not be for a lot of religious worker um, jobs. So let's hope that they extend it again because uh, it is religious worker is always for a set period of time and then it is extended. So let's hope that it gets extended again.
About the DV visas, the diversity visas category, which remains current for all regions right now. So, what advice would you give the applicants who have been selected in the DV 2025 lottery and, but maybe they are unfamiliar of what to do in the next steps? So, any tips for them?
Um, File for adjustment as soon as you can if you've been selected. That's the only advice I have.
Thank you so much, Prashanthi. Also, what policy changes or legislative actions could help address the ongoing backlog for Indian applicants, maybe across both family and employment based categories? So, are there any potential reforms in the horizon?
We are waiting to see what happens this year. There have been many bills that have been introduced previously, but didn't see the light of day. So let's just wait and see what happens this year.
Yes, we'll really have to wait and watch because there are a lot of changes happening. And also, I mean, you must have heard about the 20 judges who were, fired just recently. Well, how do you think this is also going to impact the immigration scenario? Is it going to add to more backlogs, or you think it's I don't know.
Well, immigration judges, luckily, they don't process USCIS cases. So it will increase the backlog for asylum cases, removal cases, those kind of cases, but not cases that are processed by USCIS.
Okay. All right. Thank you so much, Prashanthi, for your time today, and it was great to have you. So, maybe any end notes for folks out there, especially with regard to the visa bulletin for March 2025.
If your dates are current, please file your 485 immediately. Make sure that you file with your medicals because you can no longer file without. USCIS has said that they will reject all applications that are filed without medicals. So make sure you have all your documentation before you file.
There you go, friends. All the best. And Prashanthi, I hope that I'll see you soon again with another very interesting topic to discuss.
Sure, see you next week.
See you, Prashanthi. Have a great day ahead. And folks out there, thank you so much for joining us. In fact, you can also contact Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. And every case is different, so it's best you email her directly about yourself and ask your questions. So her email address is prashanthi@reddyesq.com. And her phone number, by the way, is 212-354-1010. And you can also go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy. Also, friends, don't forget to subscribe to us at Immigration Talk Show. We are on YouTube, and also hit that bell icon so that whenever we have discussions, you're also notified. Also, check us out on LinkedIn, Facebook, X, and on Instagram. We are there as Immigration Talk Show. Follow us, connect with us, and stay in touch with us. This is it for now. Have a great day ahead and stay tuned on Immigration Talk Show because we will be back with more. Bye for now. Zayed, this is the wrong. Hello, everyone, and welcome to another insightful session here on Immigration Talk Show. And before we head on with our webinar for today and we have our guest join us, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. So, with that said, friends, thank you so much for joining us. We are streaming live right now on YouTube, and our handle is Immigration Talk Show. Don't forget to subscribe to us, hit that bell icon so that whenever we have discussions like these, you are notified. And best thing is that you can also participate in this, webinar today by commenting wherever you're watching us, and also by joining us on call. And to join us on call, all you have to do is dial this number 425-436-6335, and the access code is 988-888. So, yes, with that said, everyone, hi. Once again, I'm Nipasa. I'm going to be your host for today. And yes, today's discussion, we are going to really dive into this critical update, you can say, that could impact many professionals out there who are seeking permanent residency in the United States. US's latest guidance on the EB2 NIW, National Interest Waiver. So the EB2 NIW is a powerful pathway for professionals, researchers, and even entrepreneurs, who seek to bypass the labor certification requirement and even self-petition for a green card. So, but then, we recently had a few updates, and today we're going to discuss on how these changes are going to affect your application strategy and what you need to know to ensure a smooth process, and of course to help us, and guide us through all these complications and necessary points to keep in mind. I'm very honored to welcome back our esteemed guest for today, Ingrid Perez. She is the managing attorney at her firm and a dedicated immigration advocate. Having, personally experienced the US immigration process at a young age after moving from Brazil, well, Ingrid brings both legal expertise and deep personal understanding of the immigrant journey. So, hi, Ingrid. We're really happy to have you back. Thank you so much for joining us today.
Hi, Napasa. Good morning. Thank you for having me again.
Thank you so much, Ingrid. How are you doing? Has it been busy?
Yes, it's been very busy. I also changed offices recently, so that brings a whole bunch of, change. But it's very exciting, and yeah, everything has been great.
Thank you so much. Thank you for joining us today. I'm already looking forward for this discussion that we're going to have, and I'm sure that it's going to be very insightful for everyone. So, yes, our topic of discussion for today, friends, is the National Interest Waiver EB2 NIW, and how will these latest updates impact your green card process? So, Ingrid, maybe you could tell us what can folks out there expect from today's webinar.
Definitely. I think we're going to have a very in-depth discussion about EB2 and IWs, the more recent policy guidance, as well as some clarification, that the new guidance brings about. I think it's also important to have a general overview so that, whoever, maybe there's somebody out there who's listening and maybe doesn't have as much knowledge about EB2 and IWs. I think it's good to also start with the foundation. But I think it's going to be a really great discussion, and we're going to open up to the listeners to ask questions, and so that people can, be more informed as they decide whether or not it makes sense to go about filing EB2 and IW.
Absolutely. So, with that said, friends, don't forget that you can ask your questions, you can participate by commenting. And yes, also don't forget to check us out. We are on LinkedIn, Facebook, X, Instagram, and feel free to join us. So, with that said, Ingrid, I think we will not wait any further. And I have this first question for you to answer, is if you can provide an overview of the latest USCIS updates, to the EB2 NIW policy, and what key changes petitioners should be aware of right now.
Definitely. So I think that, before getting started on that, I think it's just really important to explain exactly what an EB2 NIW is, right? So we have in immigration law 5 employment-based classifications, basically, EB1 through EB5. In the EB2 category, right, it stands for employment-based second preference category. You can typically get an EB2 classification through the PERM or through the NIW, which stands for the National Interest Waiver. So it's a 2-part approach, right? First, you have to qualify for the EB2 classification, and then if you want an NIW, which is a waiver of the labor test, the permanent labor certification, and the job offer, you have to request a national interest waiver. So that is how it works. So I think for the policy manual, one of the things that they really are clarifying, and it's not really a change, it's really just a clarification, is that first you need to qualify for the EB2 classification. And how do you do that? The most obvious way is by having an advanced degree, which is a master's degree or PhD. So that is the most obvious way. The other way that you can qualify is by having a bachelor's degree and 5 years of post-bachelor experience. Now, one of the things that the policy manual clarifies in regards to that equivalency, of a master or of an advanced degree, which is the bachelor's plus 5 years, is that your experience, your post-bachelor experience, has to be related to your field, right? It has to be related to your degree. So for example, if you are a chemical engineer, but your 5 years of experience post your bachelor's degree in chemistry is running a bakery, that's not going to qualify you for the EB2 classification. So that's very important. And finally, the third way that you can qualify for the EB2 classification is through an advanced degree. And that's meeting 3 out of the 6 regulatory criteria for advanced degree. Now, one thing that a lot of people don't maybe realize is that if you have an advanced degree, you don't also need exceptional ability. So, if you have an advanced degree or the equivalent, which is the bachelor's plus 5 years of experience, you don't have to also then show to immigration that you qualify for the EB2 classification because you have exceptional ability in your field. So you can stop right there. So for example, if you are, if you have a bachelor's in mechanical engineering, and then maybe you have a master's in, another, engineering field, you can stop right there because you qualify for the classification by having your master's degree. So that is one of the things that they clarified in the updates. Another thing also that I think is worthy to mention is that the position for which you're trying to qualify for the NIW4 has to be a professional position, right? So, we can think of the more traditional professional positions such as engineers, lawyers, doctors, etc., right? So it has to be a professional position. And this is tricky with the new updates because there are a lot of professionals whose positions don't necessarily fit within, the little cookie cutter box that immigration understands a professional position to be. So think about, entrepreneurs. However, the new guidance does give some specific considerations for entrepreneurs as well, and how an entrepreneur can qualify for a national interest waiver. So those are sort of, the basic changes, or not the changes, but the clarifications in the new policy guidance. I think it's also important to note that, over the last few years, there has been so many EB2 and IW petitions filed by people both inside of the United States and by people outside of the United States. And this really came about after the January 22, guidance that opened up this possibility, right? Or not that it opened up, but it just encouraged people with STEM degrees to apply for EB2 and IWs, right? Because the US government recognizes the importance of people with these specialized degrees to contribute to advancing very important critical technologies. So what ended up happening is that a lot of US companies that would normally go through the perm process started to explore the NIW for their employees, right? A lot of software engineers, a lot of people in IT, cybersecurity, people that perform, these services that are working in a STEM field, but perhaps, the benefit of their endeavor, the benefit of their work is more towards the employer and not necessarily to the national interest of the United States. And the biggest takeaway, I think, from the updated guidance is that your proposed endeavor to the United States has to have broader implications. It has to meet the criteria of national importance. You have to show that it has, implications to that you are advancing an important strategic interest for the United States. If the benefit alone is to your employer, that is not going to work. However, the policy guidance gives us some examples of situations where maybe the benefit is to the employer, but you can still show a broader impact, right? And I think the example that they use here is, for example, if you are working with pharmaceutical drug development, right? The benefit is going to be to your employer, but the broader implications of that is to the health industry, to the health field. You are perhaps, introducing a new solution to a disease or a new treatment to an illness or something like that, that has a broader implication to the field and to the national interest of the United States. So those are sort of like the themes that we're working around. It's really just clarifying that petitioners still need to show that in order to qualify for a national interest waiver.
Right, Ingrid. Thank you so much for that, sneak peek into the recent updates with what the USCIS has brought about for the EB2 and IW. And with that said, I'll just say quickly, folks out there, you can join us with your questions as well. That we will take them up soon or later in this webinar we're having today. So next up, if you can also tell us about what petitioners should keep in mind and how these updated guidance impact the evaluation of professionals who are seeking this NIW based on an advanced degree.
Absolutely. So I think that, a lot of people qualify for the EB2 classification because they have an advanced degree or they have a bachelor's degree plus 5 years of experience in their profession, right? So they qualify for the EB2. But that is not enough. We have to go one step further to the national interest waiver. And I think that, the evaluation of whether or not somebody, qualifies for an NIW really is understanding the impact of their work, right? So understanding what problem does their work solve, right? So I'll give you some examples. And I think that, people may say that automatically a lot of people in tech may not qualify, but I think, painting such a broad brush is, not necessarily the best way to go about it. It is very much an individualized approach. And I'll give you an example, right? For a client whose EB2 and IW petition I had approved that worked in tech. Now, this person developed technology for, the big tech companies like Facebook, Facebook is the same thing, but for Meta, Microsoft, and Amazon. And the technology that he worked on was to screen and identify fake information online, right? So fake information about vaccines or fake information about the election, anything that had to do with the things that end up going viral and fake on the internet, right? That people a lot of times share over and over and over, that actually causes a disruption to our society. And that is what he worked on. That is a technology that he worked on for these specific types of employers, right? And the argument here, the reason why I decided to take that case, even though, he's working for these big companies and the benefit is to the employer, right? This big tech company that could easily do the perm process, it's because the broader implications of his work, right? Having, less fake news or fake information or false, misinformation online is actually in the United States interest, right? We have the Surgeon General that talks about how fake information online affects our mental health and it affects our decision making, right? And it actually, there's a lot of, instances where fake information has caused panic, and once false information is out there, it's very difficult to contain it back, right? Or address it and explain to people that no, this is fake because clickbait is what sells. So we are able to show that it is in the national interest of the United States for him to work on this technology, and we really emphasize the broader implications of the technology, right? Even though he's working to develop these algorithms and using AI and the software and whatnot. So you always have to think about the broader implications of your work. So if, unfortunately, I think for most people who may work in software development or IT, and, they're working on developing, a portion of the cloud or working on something like that, the benefit is directly to the employer. It's hard to answer the question, what is the broader implication of your work? So I think those individuals are going to have a much harder time with an NIW versus an individual whose work actually has, a broader implication, a national level impact that addresses something that the United States finds important. Petitioners should really be aware of this. And, of course, there will be attorneys who still represent, these petitioners that maybe don't qualify for an NIW. But I think that for people who are looking to file EB2 NIWs, understanding this and being able to articulate an argument towards a national interest is really important. And, It is a discretionary benefit at the end of the day, and you want to have the best opportunity to get your case approved. So it's important to keep that in mind.
Thank you so much for taking that up, Ingrid. And at this moment, I would say hi to Richard Coelho. We are going to take your questions very, very soon. Richard, stay with us. And folks out there, don't forget to subscribe to us. We are at Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, and on Instagram as well. Check us out. And do call us, to ask your questions to directly to Ingrid as well. You can call on this number 425-436-6335, and the access code is 988-888. So, Ingrid, now my next question to you is, with all these changes happening, how impactful are these changes, especially with regard to the processing time? Is it going to make it more lengthy, the process, by any chance?
Well, I mean, I think that we started to see a lot of, changes with USCIS and the way that they adjudicate the EB2 and IW petitions sort of, in the middle of 2024 up until now. There was definitely increase in requests for evidence for a lot of EB2 and IWs that were filed. There are a lot of EB2 and IWs that were filed with premium process, and USCIS did not complete the adjudication within the 45 days. I know that in my office, I have a couple of those cases, where we requested premium process and USCIS did not meet the deadline. I also think, obviously, with the change in administration and the things that are going on with, the employment, the federal workforce may cause delays as well. And of course, whenever there is, a policy change like this, on top of an administration change, I think there will be some recalibration that needs to happen within USCIS. I haven't seen or haven't heard of any indication that the Trump administration is going to rescind, anything related to the EB2 and IW, but I do believe that we will have higher scrutiny. I can tell you that last year, I did have some consultations for people who had filed EB2 and IWs, had received RFEs, responded to the RFEs, the cases were approved, and later USCIS rescinded the EB2 and IW approval. And the pattern that I saw was, these were mostly people outside of the United States who were filing EB2 and IWs. And the endeavor, although USCIS found that the endeavor had merit and national importance, they did not find that the professional, that the petitioner was able to advance the endeavor. So they were questioning a prong that I hadn't really seen before, because usually USCIS questions the national importance and the merit of the endeavor, really just the national importance. So it was interesting that I saw these, these cases that were later rescinded. And I think that, a lot of times people who are outside of the United States propose endeavors that are unrelated to their profession, unrelated to their experience, unrelated to what they really do. So I'll give you an example. I had a few process engineers with long careers in the industry submit endeavors that were about opening a business, right? A business that was going to hire employees, and maybe the business was in their field, but they did not have any experience as an entrepreneur. And they submitted a very elaborate business plan that had financial projections, stating that the company was going to make, millions of dollars and hire dozens of employees. And USCIS started to question, can you really make this happen? What do you have already going, to show that you are well positioned to advance this endeavor? So I think that, having a degree alone is definitely not enough. You have to be very thoughtful with the endeavor, and you have to be very thoughtful with all three prongs of the NIW. So I thought that was very interesting, that I saw these trends. And I think that, it'll be interesting to see what happens over the next few months with the EB2 and IW adjudications. For sure, every case that is pending is going to be adjudicated now based on the new guidance. So, you can expect more RFEs perhaps, but I think eventually it will sort of settle down a little bit. People will be more cautious with the types of cases that they submit. Perhaps big companies won't be filing as many EB2 NIWs and reverting back to a more traditional route like the perm. So I think eventually it will sort of settle. I like to say that USCIS had buyer's remorse from the 2022 guidance, encouraging a lot of people with STEM degrees to apply. And that's why they issued this new guidance in January 2025. So, we have to wait and see, but that's my prediction.
Thank you so much, Ingrid. Yes, I think seems like it as well. So we'll just have to wait and watch what happens. But nevertheless, folks out there, here's wishing you all the very best. Everything is going to be fine. All you need is an immigration attorney to guide you in the right path. So why not contact attorney Ingrid Perez as well? Her information is scrolling on the screen. You can check it out. And at this moment, I'll also say hello to Yash Patel, Imran, Fawad. Thank you so much for joining us. And we should just quickly address a few questions from the audience as well right now, Ingrid, if you don't mind.
Absolutely.
Let's take up Yash's question. How does civil engineers in infrastructure industry stand with recent updates?
I think that civil engineers, in infrastructure perhaps have good cases, right? Because infrastructure is an industry that is very important to the United States. The United States has been investing billions of dollars to upgrade our infrastructure. And when you think about the United States infrastructure, there are so many aspects to it that needs work, right? So bridges, our water systems, right? Perhaps public infrastructure, highways, all of these things, right? And I think that for a national interest waiver argument, right, I think it's really important to focus on the niche and understand the benefits that the work of the civil engineer is perhaps bringing to the community, right? Bringing to urban planning, bringing to the United States. Maybe what types of methodologies and practices are they implementing that are new and advanced? Are they helping address an important environmental consideration, right? Because every time we build, there are environmental considerations as well. Are we building our buildings in a way that they will, withstand natural disasters? Extreme weather or things like that? Are we building the buildings of the future, right? And the infrastructure of the future. So I really enjoy working with various types of engineers, civil engineers, definitely, for sure. And there's so many specialization and there's such a niche, that people can really focus on. And I think hyper focusing on that niche and the importance of that niche and that expertise and the overall benefit that the work of the civil engineer brings about to important interests of the United States, right, is the key. So I think that for civil engineers, if they're working on something like that in the United States, I don't think that this policy guidance affects them too much, right? We just have to, again, hyper focus on the broader implications of the work and not just focus on the fact that this, is going to be perhaps creating economic movement for the employer or, having attenuated benefits. I think we have to focus on the direct benefits of the work, right? And also not focus too much on the fact there may be shortages, because that is not what the NIW is for. The NIW really is focused on the importance of the endeavor. And that is a conversation that I have with, everybody that comes to me is, what problem are you solving? What are you improving? How are you making America better? In what specific way? And that is what we have to explain to USCIS.
Very well put, Ingrid. Thank you so much for taking that up for Yash. And Yash, I hope you've gotten your answer. If you have more questions, you can keep commenting. And also, don't forget to subscribe to us if you haven't already at Immigration Talk Show. All right, so, with that in mind, whatever you just said, answering to Yash's question, my next question is also about individuals, who are claiming to have exceptional ability. So, how does USCIS access whether their ability is directly related to their proposed endeavor?
Absolutely. I think that's a great question. And it reminds me of a conversation that I had yesterday with a potential client. When we got into their qualifications, they worked in this very specific field in the finance industry. And when we started talking about the types of evidence that they would have to show, they definitely qualify for the classification by having an advanced degree. But I also like to delve into those exceptional ability criteria because I use that evidence to argue that the person is well positioned, right? So when we started talking about the different recognition, the different accolades, and the different achievements that this person had throughout their career, they started talking about more of unrelated aspects of their specific profession. So, for example, this person worked in finance, but they were leading an initiative within their organization to hire more women, and people in finance. That was very unrelated to her endeavor, right, of working in this very specific niche of finance. Or perhaps, you do a 5K to benefit an organization or a charity or something that is related to the company. That, again, is unrelated to your field. So those things should not be considered when you're talking about exceptional ability. The exceptional ability really needs to be related to your field of endeavor, right? So if you are a person with exceptional ability, let's use the civil engineering case, for example, right? Recognition for the projects that you have done, right? Have you received, contracts that, you were able to maybe outbid, or maybe you have received recognition from the city or the municipality that you've worked in, right? Has the bridge that you've built or, the school that you helped build received some type of recognition in the press or something like that, right? It has to be directly related to your profession and your endeavor. So I think those are the specific considerations that USCIS will, address, and they are not going to consider things that are unrelated, right? Things that I guess, in the real world we call more of like the soft skills, right? Or those things that you do to build culture or something like that. So that's what you have to keep in mind, and that is what USCIS is going to do. And it's always how they've done things, right? It's nothing new. It's just clarification for future petitioners, because again, like I said, I really think that USCIS had buyer's remorse, right? And they are now kind of tidying this up a little bit and telling people, wait a minute, hold on, don't just dump everything and expect to get approved. You really have to narrow your focus and present a case that, complies with the regulations and the requirements.
Thank you so much for taking that up, Ingrid. And folks out there, stay with us because there's so much to speak on today's topic. And we are speaking today about the latest updates on the EB2 NIW by the USCIS and how it is going to impact your green card process. So, folks, also, if you want to contact attorney Ingrid Perez directly, you can give her a call on her number or email her. Her number is 407-906-0068. And you can also email her about your case and maybe ask for her guidance by emailing your information to info@ibplaw.com and go visit www.ibplaw.com to get to know more about Ingrid Perez and IBP Law. So, with that said, we are going to take a short break right now and we'll be right back to speak more. And Yash says, thank you. Thank you, Yash, for your question as well. Keep commenting and keep watching. Stay tuned, everyone. It's me, Napasa, and Ingrid Perez right now on Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. I'm Napasa, your host for today, and we are having a very, very interesting and insightful webinar with attorney Ingrid Perez from IBP Law Firm. And the topic of discussion is how will the latest EB2 and IW updates impact your green card process? I hope that you are having fun, listening to all these new updates and what to keep in mind. I hope you're also noting down the most important points. So, yes, with that said, Ingrid, I hope you're also having a good time answering our questions and also, answering to folks out there. Yash says thank you once again. So, here they are. Richard, just stay with us. We are going to take your questions, Fawad as well, and also Imran. Stay with us, all right? So, Ingrid, my next question to you is also if you could tell us what factors, does USCIS consider when determining whether a proposed endeavor has national importance under the new guidance?
Absolutely. So I think just going back to what we talked a little bit about before, right?
Yeah.
I think the simplest way to understand and to, present this to immigration is what problem are you solving or what thing are you improving? What innovation are you creating, right? And how are you impacting your industry, right? How are you impacting your field? So those are the questions that petitioners should be ready to answer when they are preparing an EB2 and IW petition and discussing the national importance of their endeavor. And how do you prove that, right? So, obviously a petitioner's words are great, but, us just saying that an endeavor has national importance is not enough. We need to back that up with documentary evidence, right? And I'll tell you how I do it in my office, right? Of course, I always start any case with an in-depth discussion with my client. And before I have a discussion with a potential new client, I do a little bit of research on their field, right? If it's a field that I'm not necessarily familiar with. I'm very familiar with engineers and researchers, so those cases come a lot natural, much more naturally to me. But for fields that maybe I'm not so familiar with, I start with always doing a little bit of research, right? What are the trends in the industry? What are the problems? Where are the gaps in the industry, right? And how is this person helping to address those things, right? So starting from that. And then really trying to understand, from the client's perspective, what is the impact of their work? How do they go about doing it, right? Like, what is their day-to-day like? What does their team look like? How is the decision-making process, in their profession, right? How do they, perform their tasks and their activities? I really like to understand every single aspect of my client's work so that I can understand it, say it back to them in a really easy way. And if I feel confident that I can, explain it to my client in a way that they say, yes, that's exactly what I do, I'm able to then explain that to the immigration officer. And I always do my cases assuming that the immigration officer is a blank slate. I assume that they don't know anything about the industry. And I also assume that they are overworked and overburdened. So I want to make this easy for them to understand. And I want to make this simple for them to understand as well, right? So I think that having a very clear theme throughout an NIW proposed endeavor is very important, right? Always hitting that theme, starting with your topic sentence and having that theme discussed throughout the endeavor, right, is really important. And having corroborating evidence to back up what we're saying, right? So at this point, I am doing research about, the specific problem that my client's work is addressing. So maybe I'm looking at, studies or government reports, or maybe articles from, credible sources that talks about where the industry is going, what are the gaps, what are the failures, and, maybe, information that I can find that talk about a specific aspect of my client's work and how that is helping solve a problem, right? And then that way I can make the connection to the immigration officer. Look, I have all of these credible sources that talk about how, this solution is one that is being widely adopted, or this solution is what is going to drive the industry forward. And this is exactly what my client is doing, right? He's doing this, he's been doing this, or she's been doing this for years and years. And here are a bunch of examples of him or her doing this exact same thing that the industry is saying is needed. So that is how I tell this story and how I bring this theme throughout an NIW petition. So I think that is what USCIS has always considered and will continue to consider, right, in determining whether or not a proposed endeavor has national importance. They want a detailed plan of the endeavor, right? It doesn't necessarily need to be a business plan. It doesn't necessarily need to be an elaborate document that you invest money in purchasing. You can create this document itself. You just have to understand how to structure, how to tell the story. It has to be simple. You have to explain it in simple, clear ways. And the evidence that you submit has to back it up, right? It has to be relevant. So I like to, assume that the immigration officer has maybe an hour to read your case. What are the things that you want him or her to come away knowing about your case? You don't want to have them confused. You want to be super clear, direct, and succinct with everything that you submit to USCIS.
Right, right. Well, thank you so much. These were such important points, and I hope that it's going to be very beneficial, folks out there who are watching us, and that you have taken notes because they were very important points that Ingrid just gave out. So, with that said, Ingrid, also if you could tell us about the documents that are most important. How should petitioners strengthen their applications, particularly in providing letters of support and business plans as well, to demonstrate that they are well positioned to advance their proposed endeavor.
Absolutely. So I'll start with business plans because I have a lot of opinions about business plans, at least in how I do cases. I don't submit a business plan unless the endeavor is entrepreneurial. That is just how I approach the cases, because to me, a business plan is very specific. It has very specific information. It has financial projections. The considerations about the business that you're going to start, where the business is going to be located, who is going to be your target client or your target customer, how are you going to expand the business, how many employees are you going to hire, what is going to be your role in this business. So I think a business plan that has all of those things, and those are the exact things that USCIS in the new policy guidance has a special section, has a section just devoted to entrepreneurs, right? I think that is important to discuss, especially if you're thinking about an entrepreneur endeavor. Creating lots of jobs is something that could be in a national interest, right? And I'll give you some examples. I'll give you an example of an entrepreneurial case where I've submitted a business plan. I had a client who started a business in his country, and the business was buying used industrial equipment that maybe was not working from the government, or maybe from businesses that went out of companies that went out of business. And he would buy these equipment, he would refurbish them and resell them into the secondary market. And he had years doing this, and he was able to grow his business, create lots of jobs in his home country, and he wanted to replicate this business here in the United States. From his country, he hired someone in the United States, and he set up an office, and he started doing just that. And from his country, he was able to manage the operations here in the United States, grow it to some 7 or 10 employees at the time that we filed. And he was operating for some time. He was entirely remote, and the business was thriving here in the United States. And he was doing the exact same thing, right? And the argument here was that he was adding to the secondary market, right? He was adding to our circular economy, helping to keep these machinery parts, these equipment, all these things out of our landfills and available to perhaps new businesses, new manufacturers, new factories that are just starting out and maybe don't have the money to be able to buy brand new equipment, right? It's also very important to have these secondhand machines and parts available in case of a supply chain shortage, right? So he's supporting the industry in so many ways. And this was a legitimate business. He had plans to grow and expand, and he showed a history of doing exactly just that. right? And I had even his bookkeeper write a letter on his behalf. And that was a case that I think really warranted a business, because his endeavor was truly entrepreneurial in nature, and he had the proof to back it up, right? So that's my feeling about business plans. I really only submit them when the endeavor is truly entrepreneurial in nature. As far as letters, right? Letters is an interesting one, because letters are very important to a case. However, a case cannot be, a case is not going to, stand on letters alone. You still need corroborating evidence, because immigration kind of snubs its nose towards letters, because letters are created for the purposes of a petition. So instead of calling them letters, I started calling them testimonials, right? Because testimonials are more objective. So I've been writing, these letters in a way that are very objective, very descriptive, right? We're not writing character references. We're really writing testimonials about the client's work. I like to tell my clients to include a lot of quantifiable information in these letters, right? To describe what was the situation before and what was the situation like after, the client stepped in to work on a specific project or handle a specific, solution to something, right? So I think letters are very important. The guidance also talks about letters from government agencies or quasi-government agencies that are interested in one's work. And those letters are very powerful because they can hit all the prongs, right? Depending on the information that's in them. And, USCIS also says in the new policy guidance that the letter should be from experts in the field who are familiar with you and your work, right? But at the same time, they always, they often snub their nose at letters. So I think the letters need to come from a mix of individuals, a mix of experts who are familiar with your work and that know you, so that you're not just, submitting a case that is full of letters from your employer or your colleagues or your managers. I think it's really important to have a mix of letters to show broader impact. So I would say, for people who are going through the EB2 and IW process, tap into your network, keep those connections alive. Keep the connections with your professors. I think letters from professors are a great way to get a letter from an expert, right? Professors are in academia and they have a lot of expertise. And if you can get a letter from your professor that can say that your work is important, that professor will be some years removed from your work, but they know you and they know the industry and they know what you're doing. And I think those letters can be very powerful if done the right way.
Thank you so much. So, testimonials, as Ingrid calls them, I think they're very, very important. So, thank you, Ingrid, for taking that up and for answering to our question. We also have RK join us. Hi, RK. Thank you for joining us on YouTube. He's asking, can you speak to the timeline from start to finish, green card, for these applications? Maybe briefly, if you can just give us the timeline, Ingrid.
So definitely. So if you're starting and you don't have a prior petition that has been approved, right? So the date that you file your petition with USCIS is the date you get in line for your green card. So let's say, today is February 28th, 2025. Your petition arrives today at USCIS. Today will be your priority date. Today is the date you get in line. Now, that petition may take, anywhere from 45 days if you're requesting premium process to maybe a year for a decision, right? And that timeline doesn't really matter so much anymore because the visa bulletin is so backlogged, right? So the visa bulletin is the other thing that people have to keep in mind when thinking about the green card timeline, because your priority date, right, in this case, February 28, 2025, has to show up on the visa bulletin before you can even apply for a green card, right? So timeline is kind of like one of those things where it's just, depending on what's happening in the world of immigration, it's very relevant, right? So I would say that right now, average, if you're not, born in a country like India, which has a significant backlog, if you're with the rest of the world, I would say 2.5 to maybe 3 years, right? Premium process, I think, is important to note that premium process only gets you a decision faster. It does not get you the green card faster. It does not get you the ability to apply for a green card faster. So I don't recommend premium process to most of my clients unless there is, a necessary reason for it, Like, for example, maybe they're running out of H-1B time and they need to have a decision on the I-140 so that they can keep extending their H-1B. Or maybe they're just really curious, or maybe they have an earlier priority date that they want to capture. Those are the situations, the circumstances that I think premium process could be a good idea. Otherwise, I would say save your money and just be patient and wait.
Thank you. Thank you so much, Ingrid, for taking that up. And yes, the premium processing is very expensive, but good to know that you don't just suggest that to anyone and everyone, Ingrid. So, RK is also asking another question before we can move out to our Facebook questions. Here's one more question. Also, what is happening with premium processing for EB2 and IW? Do you see them temporarily discontinuing it to clear regular processing backlog?
I don't know if that's why they are, maybe not adhering to the EB2 and IW premium processing timelines. I just had an EB2 and IW approved yesterday or the day before for an agronomist, and we filed a premium process, and it was approved close to the 45-day mark. No RFE, thank goodness. I also have a few cases that I'm working on right now that we filed premium process. We received RFEs, and now we're working on responding to these RFEs. And then the clock is going to pick back up, right? USCIS has then additional time to decide these cases. But I think that, because so many people were applying for EB2 and IWs, they naturally wanted to go with premium process. And a lot of these companies that perhaps can afford these very expensive fees were filing premium process just to see what would happen. I think it definitely created a demand for premium process that USCIS simply does not have the supply to meet, right? So I think that's what's happening. USCIS does have the authority to discontinue premium process. If they do, I would assume that it may be to, clear the regular processing backlog, which I think is significant, right? I have cases right now that are pending quite some time, even beyond the normal processing times. So for sure, if they decide to do this, I think it may be for that strategic reason.
Right, right. Thank you so much, Ingrid, for taking that up for RK. And RK, thank you for participating with your questions. And Ingrid, we also have some questions from our Facebook group, so we'll quickly address to them. This first one is already on the screen. My employer is not sponsoring me perm EB2, EB3 skilled. I am on H1B and my wife on H4. Can we apply EB3 unskilled for my wife as a principal applicant? And if approved, will it have any impact on my H1B status? Or can my wife get EAD till we both get the green card?
Okay, so to answer the first question, will your wife's EB3 unskilled have any impact on your H1B? No, because it just doesn't. It's completely separate. You can continue to have your H1B. It's not going to have any impact on your H1B status, right? Can your wife get an EAD till we both get the green card? Well, if your wife is on H4 and she has an EB3 visa petition available for her, she's not going to be able to get the EAD until she files for the green card together with the work permit application, right? So she'll be able to get the work permit after you file for the green card, and you presumably have filed the work permit application as well. But having the petition in and of itself approved for her in your specific situation is not going to give her an EAD. However, if you on H1B, if you were able to get an approved I-140, then your spouse on H4 would be able to get an EAD, right? So if the role, or if the I-140 was reversed, right, then your wife would be able to get an EAD that way. I hope that helps.
Thank you, Ingrid, for taking that up. And now we have this next question. This is from Duda. Is there a possibility that the Trump government will expedite people with an EB3 visa who are document qualified, being able to have the right to go and work in the US before the interview? My PD is 7822. You guys think will be current until middle next year?
Incredibly hard to tell. I mean, there are so many changes going on with, the Trump administration. We're still within the first 100 days of the Trump administration, and we know that, as of day one, he instructed the Department of Homeland Security and the various agencies to look into immigration processes and everything that's going on and make recommendations. So this is one that I really I can't, unfortunately, I just don't know the answer. I can't look into the future, but, my inclination is that no, I don't think that he's going to be doing anything to really make it easier for people. I could be wrong. I hope I'm wrong. Maybe, in the employment-based context, I will be wrong. But just knowing how the administration operated, during Trump 1.0 and what's going on right now, I don't think he's going to make it any easier for people, unfortunately.
Okay. Thank you, Ingrid, for taking that up. I got this next one. This is from an anonymous member. My PD is November 2021. Anyone have how long it will take more?
Nobody knows. Nobody knows. I wish I had a crystal ball. If I did, I would, be very popular. But nobody knows, and I think it also depends on the classification. We'll see what happens because we do have a new fiscal year in October, and every quarter these things sort of recalibrate, right? It may be that with the less premium process cases, USCIS has the ability to adjudicate more green card, petitions and therefore make at least a green card application more available for people. I mean, that is one possibility, but we'll see.
Yes, we will. Well, thank you so much. It's really hard to predict, but thank you, Ingrid, for taking that up. And now I got this next question. This is from Anil. Hi, everyone. I am F1 student in USA. I applied to EB3 unskilled worker. My priority date is December 18th, 2023. Do you have any idea how long will this process take to apply change of status from now on?
I assume that you are asking how long it's going to take to apply for adjustment of status, because if you're in the US with F1, you can change your status. There's just a terminology just to make sure. So I assume she's talking about adjusting her status to get a green card. And again, it's just impossible to know.
I know it's so hard when they ask about dates and priority dates. It's just hard to tell. So, yeah, thank you, Ingrid, for taking that up. And this next one is, hey, I am an F1 student and my I-140 approved, and my PD is March 2023. How long will it take for the next step? It's almost similar to
I I don't know. Watch the visa bulletin.
this next one again. This one is from Bangladesh. I have applied EB3 unskilled from Bangladesh. My PD is December 2023. I hope in the upcoming April, my LC will be approved. Now, after receiving my LC, if I change my sponsor and company and go to another sponsor and company, then will I be able to complete and continue my process from there? Is it possible? Also, if I change sponsor and company, will my PD be the same? Please let me know.
I can't tell if you have, I assume the LC means the labor certification. You don't have an approved I-140, so you're not going to be able to keep that priority date. I would say talk to the attorney who's doing this for you, but I assume that that's what's happening here. It doesn't seem that you have an EB3 yet. You're still in the labor certification process.
Yes, thank you, Ingrid. I think those were my Facebook questions from our groups. So thank you for taking that up and addressing them patiently. I think we should quickly take up a couple more from our audience here. So let's go with this first one, which is from Richard, asking, I'm an engineer with 10 years of experience in renewable energy. I've been working on sustainable infrastructure projects, but I don't have a PhD. With the latest EB2 NIW updates, how do I prove my work has national importance strong enough to qualify?
I would want to know the types of projects that you're working on. Renewable energy is, I think, very important to the United States. There's a lot out there that will help you discuss renewable energy and the importance of the field. The next step is the importance of your work. So understanding exactly what you do as an engineer working renewable energy. Are you developing new technology? Are you installing renewable energy technology? Are you designing? So I think understanding exactly what your day in, day out work is very important to be able to argue that not just the industry is important, but that your specific endeavor, your specific activities are important to advance this field. So I would say that, when I talk to engineers, what I like to know is, just that. What exactly do you do? What are the types of projects you're working on? What types of documentation do you have to show that you have been successful in your career, that you have had an impact? So perhaps you can share work orders or designs, or maybe there's some, press releases about the different projects that you're working on, or maybe there are some scientific studies that must be done before, you implement a renewable energy sort of, machinery or whatever, right? Whatever it is that you're working on. So maybe there are some quantifiable information that you can show that, this renewable energy has had XYZ impact in whatever town or location or people, whatever, right? And I think sustainable infrastructure projects are important because there's a lot of studies out there that I think you could use to show the impact and the quantifiable impact, right? Specifically about different sustainable infrastructure projects. I don't think you necessarily need to have a PhD. If you have a bachelor's degree with your 10 years of experience and you qualify for the EB2 classification through the equivalent of an advanced degree, if you have a master's degree, you also qualify for the classification. You don't need a PhD. I do cases for people who are industry professionals all the time, and it's all about understanding what they do and how to best present that information to USCIS.
Thank you for taking that up. Richard, I hope you've got your answer. I'd like to take this next one. This is from Imran, and this seems very important as well, to get to know will it impact or not. I started my EB to NIW process last year, and my case is still pending. Will the recent policy changes impact my application, or will USCIS evaluate my case based on the previous criteria?
They're definitely going to evaluate your case based on the most recent criteria. So if you believe that your case was maybe, not presented in a way that best addresses the new criteria, I would recommend go online, print it out, study it, read it, maybe start preparing for, a response, an RFE. I mean, that's worst case scenario. I don't want to like scare anyone, but in the event you do get an RFE, you need to be prepared because you do have a limited amount of time. And I think, learning and reading about the new policy guidance and, maybe talking to the attorney who did your case for you could be a way to help you at least prepare, right, for in case you get an RFE.
Thank you, Ingrid, for taking that up. Let's take up Fawwad's question. He's saying, I am in academia working on biomedical research and I have several published papers. Given the latest updates, how much weight does USCIS now place on publications and citations when considering an EB2 NIW case?
USCIS has always given consideration to publication and citations. I think that researchers, especially for a person who's working biomedical research, I would really like to look at this case. This is one where you are advancing healthcare, right? You're advancing biomedical research in the United States, which is an area that is very important to the United States. If you are a researcher in this field, right, you are researching innovations, you are coming up with new solutions, you are, coming up to answers to problems. So I think that for researchers, those are still really great. Most researchers, I would say, right, probably have great cases for EB2 NIW. Actually, matter of Danosar, which is a seminal case that deals with the NIW, that was for a researcher. So I like researcher cases. I like them a lot.
That's very nice. Fawad, thank you for participating with your question, and Ingrid as well for answering to Fawad. Next question that I want to ask is Ingrid, what are the implications of these, updates for STEM professionals and entrepreneurs, given USCIS's previous guidance in these areas?
I think that for STEM professionals, for many STEM professionals, the EB2 and IW is still a viable route. A lot of STEM professionals work on advancing technologies that are critical to the United States, right? We have the critical and emerging technologies list. People who are working to advance those technologies, I think, may have still, great NIW cases. It just very much depends on who is the ultimate beneficiary of your work. What are the broader implications of your, innovation? Who's your work for, right? I think that is the differentiator. For, STEM professionals, if you're working with a company, an employer, and you're developing technology for that employer, you still need to show that technology is in a national interest, right? That technology has broader implications, and then perhaps the advancement of those technologies are important for the field. So those are the implications that you have to keep in mind. So again, just think about, how to present a more whole case where the evidence is not just coming from your employers, right? Where the letters are not just coming from your managers. And I have my dog here in the office, which is why you're hearing barking. But, think about that. How can your work really have that broader implication? And I think that, I do like working with STEM professionals as well. And I think a lot of people may still have good cases, just about understanding the requirements and what USCIS wants and best presenting that information, the evidence.
Yes, absolutely. And I think you, as attorneys, you know best and how to impress. So, I would say, folks out there, it's always best to, consult an attorney with your case so that you are guided in the right direction, and you know what to do. So yes, attorney Ingrid Perez's information is on the screen. You can note it down to contact her. You can email Ingrid info@ibplaw.com, and you can also call Ingrid at 407-906-0068, and go visit www.ibplaw.com. And Ingrid, before we leave, I would like if you could tell us if there are any specific filing tips or strategies that applicants should follow, to improve their chances of approval under the updated guidelines.
That's a good question. I think that, I'm always impressed with the people that I talk to about EB2 and IWs, because I think they're usually very knowledgeable. I think knowing what USCIS, is looking for. I mean, obviously, you don't have to be an attorney to read the guidance, but I think that becoming familiar with what immigration is looking for is really important, right? And I think also having a very niche and focused approach to an EB2 and IW will help improve your chances of approval, right? So focusing on the endeavor, focusing on the work that you do and how you're well positioned to do that specific endeavor. Be strategic with the types of evidence that you're including, right? And be strategic with the letters as well. A case should not be filed with, many letters. I don't think you need that many letters. 7, 10 letters, it's too much, because the letters are going to be repetitive, and USCIS is not going to give those letters a lot of weight. So I think narrow down your focus, identify the people who will write the testimonials on your behalf, and be very strategic. And each person should say something different, right? I don't think that having multiple people say the same thing is good for a case. I think it becomes redundant. And think about the immigration officer who's going to be reading your petition. They have no idea, you have to assume that they have no idea what you do. So, be able to explain in very simple terms, be able to be very clear, and have evidence and documents and documentation that backs up what you're saying, right? Especially if you are talking about how your work will bring about a specific benefit. I think it's really important to be able to cite to sources that confirm that, credible sources, right? And this gets us back to college days when we were writing reports and we had to do research to back up what we're saying. So my approach to EB2 and IWs is to keep it narrow, keep it simple, keep it easy to understand, and really just have a theme and discuss that theme throughout the case. And that is, the final thing that I want the case to that's what I want the immigration officer to come out with knowing the theme of your case and understanding your case and understanding what you do.
Sweet. Thank you so much, Ingrid, for those tips to keep in mind. And yes, very well said. I think if testimonials were the same, talking about the same thing, it wouldn't make much sense. But if they're all different from one another, speaking good things about you, that would make a lot of sense. So that's one good point, Ingrid. And thank you so much for today. It was a very insightful discussion. We got to learn a lot from your expertise and your knowledge that you imparted in today's webinar. It was great to have you here today.
Likewise, thank you for having me.
Thank you so much, everyone, also for participating. And do not forget to contact Attorney Ingrid Perez. Her phone number is 407 609, sorry, 407 906 0068, and her email address is info@ibplaw.com. And go visit ibplaw.com to get to know more about Attorney Ingrid Perez. So Ingrid, also, we it's a busy season. So maybe if you have anything else to say to the audience, an end note maybe before we leave.
No, I'll just say that I do really enjoy working on these cases. If you'd like me to review your case, I do have a link on my website where you can go in there, send me your case information. It's a very detailed questionnaire that I ask people to fill out, and I do take my time reading those and sometimes researching the field before I invite somebody to come have a conversation with me. So if you want me to review your information, please visit my website, click on the link to get a free evaluation, and I will do that for you.
Thank you so much. And folks out there, yes, with that said, thank you everyone for joining us today on today's session here on Immigration Talk Show. It was great to have you. Do not forget to subscribe to us if you haven't as yet already. Hit that bell icon so that you get notified whenever we have important discussions like these. And absolutely, you can also contact me with your questions and whatever queries you have. Dial this number, or you can even WhatsApp me in this very same number, 408-335-6444. And my email address is nipa@staffingly.com. And also you can check us out at www.staffingly.com. So thank you so much, Ingrid, once again. It was great having you. Here's wishing you a happy Friday ahead and also a happy weekend that's coming up.
Likewise.
Bye-bye.
Bye.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared, including user comments and replies from users, is not a legal advice, So, use of information is at your own risk. All right, friends, after this very important disclaimer, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. And don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. With that, folks, today we are here with another very exciting and very important topic because H1B season is here. And if I'll ask you a question that are you fully prepared for the H1B lottery 2025, then I'm sure you're not confident enough to say yes. But after the show, I'm sure you will be. Because today we are going to explore a very timely topic that about H1B registration system that is recently a very new change has come up over there. What it is, how is it going to increase your chance for the lottery system in 2025, and also how is it going to impact everyone, the employer, the employee, and what will be the outcome for that. We are going to have a great discussion on this webinar, and to help me out and to make this session even a wonderful one, we have a very special guest with whom we have shows on every Wednesday at 12 p.m. A very well known expert in immigration law, attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. So, thank you so much, Prashanthi, for being here. And it's our first time that we are connecting together and having a show together. And I'm really excited. So, thank you so much for being here.
You're welcome, and I'm looking forward to this show.
Absolutely. It will be wonderful as your every shows go with. All right. So, Prashanthi, before diving into our questions, that we have prepared, I would also like you to let us know so that, our viewers can get a better understanding about the change that happened in the H1B registration system.
So I guess just to give you a background about what to expect this year with the H1B registration system, the biggest change is that the registration is now $215. It was $10 earlier, so that's a big change. The registration fee has gone up. We were expecting that last year, but by the time the law was actually passed, it didn't come into effect last year, but we knew that it would come into effect this year. So that's the biggest change. The registration fee is now $215 as opposed to $10. In addition to that, we've seen some changes that took place last year as well, and that will continue to this year. Those changes are that we see a new account, an organizational account, which is in place for you to do your registrations. That organizational account is updated. It allows multiple people to log in at the same time. It allows you to prepare your registration seamlessly, allows you to check for duplicates. So this is a new system, the organizational system, which was not there the year before. It was there last year, but not the year before. In addition to that, last year we saw that a huge change, which was that they made the registration system beneficiary centric, which means that no matter how many registrations you file as a beneficiary, you will get only one pick in the lottery based on your passport ID. So even if you file duplicate registrations through different employers, you don't get a better chance of being picked in the lottery. You have the same chance of being picked because it's only one. You get only one entry into the lottery, no matter how many registrations you've done. So that's a huge change as well. And of course, this year, we will see changes in the H1B process itself. But I think with reference to the registration, these are the changes that we can expect.
All right. Okay. So I think this is the brief that our viewers are getting to know today about the latest changes that happened in H1B registration system. Also, Prashanthi, as you mentioned some changes, I would also like to know about this, I would say, the beneficiary centric topic. Because earlier, what used to happen if three companies have registered, three companies can register the same individual, right? And that same individual have more chances to get selected as compared to the others who only had one chance with a single registration. So don't you think the person who got chances, three companies getting registration from those three companies are better performing as compared to the other one? So don't you think this is, do you think is it really going to make the system fair enough?
I think so because what was happening is our people, people tend to game the system. So the more leeway you give, the more opportunity you give, the more likely it is to be misused. And that's what happened last year.
Okay.
I mean, the year before, we saw 780 uh, thousand registrations, right?
Mm-hmm.
And there's only 85,000 H1B numbers. So, and that we saw like 400,000 of them were duplicate. Like more than half of the registrations were duplicate. And we also heard reports of one person filing 100 registrations,
Oh.
150 registrations
Mm-hmm.
to, so trying to game the system.
Yeah.
So it's not, I can't believe that one person had 150 job offers.
Absolutely.
So it's more likely that there was collusion,
Mm-hmm.
which means that, um, sister companies, so companies are colluding with each other to file the registration for the same person, um, resulting in, them getting one of the companies getting picked and then the company sharing the profits, etc. So this was called collusion. This is not allowed even now. It's not was not allowed earlier. But of
Mm-hmm.
course, when if it's an independent job offer, one beneficiary can file more than one registration
Okay.
as long as the job is different for each employer and
Mm-hmm.
there is no relationship or no collusion between the companies. But of course, now with the beneficiary centric system, there is no longer an incentive for the beneficiaries to file more than one registration. They're still doing it because they're not sure that that one company will, file their H1 even if they get picked. So they're just to make sure that they have a backup. Maybe, beneficiaries are still doing, more than one registration, but they're definitely not doing 100 registrations. So I think this was needed for the registration system to remain intact.
Mm-hmm.
Otherwise, they would have to remove the registration system because it was not working. So
Yeah.
to protect the integrity of the registration system, they came up with a beneficiary centric selection process, which I think was key if they wanted the registration system to work moving forward.
Mm-hmm.
So we didn't really have any choice because of how the system was being used. How will this impact companies that previously submitted multiple registrations for the same candidate? Um, so multiple registrations were not allowed at any point of time, right? So if you file multiple registrations for the same candidate, then most probably you were not picked in the lottery. You were not even included in the lottery process because they reject the registration as soon as they find the duplicate. So if you filed by mistake even for this beneficiary twice from the same company, then immediately your registration itself does not get submitted. It gets into a rejected status due to duplicates. So it will not even be put into the registration. So that's what happens if you file multiple registration for the same candidate. Now, on the other hand, if you collude with some other company, maybe USCIS will not come to know during the registration process. But I've seen RFEs even for last year's registration, even though it was beneficiary centric, people did still colluded. I don't know why, because there's no usefulness in it anymore. But maybe out of old habits or by mistake, there was still collusion, and USCIS still sent notice of intent to revoke and finally revoked those cases or sent an RFE asking for an explanation. So don't do it, even though there's no usefulness in doing it. I don't know why companies are persisting in continuing to do collusion.
All right. I think that's wonderfully explained. And I was about to ask how is it going to impact the different companies and different also how is it going to impact. But you already answered that. So thank you so much, Prashanthi, for making us understand this whole change and also the impact in a very simple way. And with that, I have another question for you, Prashanthi, that the new beneficiary centric selection process aims to reduce the duplicate registration. That's what you said right now. So now I would like to know, how does this affect the candidates with multiple job offers?
So it shouldn't affect the candidates with multiple job offers. If they still want to file, several registrations, they can. And whichever registration, I mean, it'll only be one chance at the lottery. And then if they get picked in the lottery, then they can decide which H1 that they want to go with, which company they want to go with. So that's how it works now. If you have filed for several companies, then you can choose which company that you want to file the H1 with. So it becomes up to the beneficiary to choose. Of course, you can't file more than, I mean, you can even file more than one H1 and then decide which H1 you finally want to take and withdraw the other one. But there's only one lottery, one number that goes into the lottery system. And if you get picked, if you have several job offers, you can choose to file the H1 with all of them, or you can choose which ones you want to file the H1 with. But finally, you're allowed, you obviously will work only for one company unless you're filing concurrent H1s. And then in which case, then it does not have to be, it's not subject to the cap because a concurrent H1 is cap exempt. So you would, under the cap, work for only one employer. And you choose which employer you want to work with.
All right. Okay. And here's another question, Prashanthi, that USCIS has indicated a stricter oversight on fraud and misuse in the H1B lottery. And so, what additional documentation should employers and applicants prepare to avoid these issues?
So, yeah, I mean, under the Trump administration, they are focused on combating fraud and abuse of the H-1B visa program, and even previous administrations did. But the present administration seems to be of the opinion that there's a shortage of qualified workers, that the H-1B is to, target the shortage of qualified workers in the country. So if there is a shortage, then the H-1B program is useful. But they seem to think that there are a lot of American workers who are qualified, willing and deserving to work in these fields, but they're being ignored or unfairly disadvantaged due to, because of the H-1B program. So to start off with, USCIS has come up with a statement that they think that the H-1B program is not important and is not as useful as, it was meant to be. So starting off with that, if you start off with that angle, then obviously you see that they're going to discourage people from filing H1s, and they're going to try not to approve cases, and there's going to be extreme vetting on H1s because their mindset itself has changed. The present administration's mindset has changed. So what they're basically saying that employers who abuse this H1B visa program, they are negatively impacting the US workers. And so in order to combat fraud, they want, anyone who reports this kind of H1B fraud. So if you're an employee and you report the fraud that your employer is doing, they want to make sure that there is some option for you to remain in status because your H1B will then be withdrawn by the employer. So they are trying to find some protections to help those H1B workers by allowing them to extend their H1 status or change to another immigrant status, under the extraordinary circumstances rule, which has always been there. It's like a catch-all phrase which allows people to go back into status once they're out of status, provided USCIS agrees. So it's a nunc-pro-tunc petition that has to be filed. Under humanitarian grounds, or extraordinary circumstances, they approve these cases. So what kind of H-1B fraud and abuse indicators are they going to be looking at? And they've given some indicators in their, latest press release. H-1B worker is not or will not be paid the wages certified in the LCA. So if you're not being paid the prevailing wage, there's a wage disparity between the H-1B workers and other workers performing similar jobs to the detriment of the US workers, meaning the H-1B worker is being paid more than your other, say, US citizen workers for the same job. That is abuse.
Yeah.
H-1B worker is not performing the duties as listed in the H-1B petition. And the H-1B worker has less experience than a US worker that you're hiring for a similar position. So they're making sure that there is no unfair advantage to your US worker, and you're not giving any advantage to the H-1B worker as opposed to the US worker. So with reference to wage, with reference to hiring someone with less experience, and also the H-1B worker is not working in the intended location where they're supposed to be working, then it's also abuse. So they've, listed a few examples of where H-1B fraud or abuse would be found. And they have increased H-1B site visits. Starting, they said, as of January, they've increased those site visits. And so that is how they're also kind of preventing fraud or vetting, doing extreme vetting on H-1B employers, especially consulting companies. So they're doing more vetting, or they have said that they're going to do more site visits for H-1B dependent employers, that is your consulting companies who have a high ratio of H-1B workers as compared to other US workers. Cases where they cannot validate the employer's basic business information through commercially available data. So if they can't find your company they can't find a website for you, they search and they can't find you on their Vibe database, then most probably they'll do a site visit. So important for employers to be part of the Dun and Bradstreet employer database, because that's where they get their Vibe information from. Also, employers petitioning H-1B workers who work for other companies offsite. So we're talking about the consulting company scenario. So they're going to be increasing or expanding site visit for consulting companies as well. So this is what they're doing. They're targeting site visits for these kind of companies. They're, trying to. They're kind of giving you a list of who will be a H-1B fraud or what will be a H-1B fraud, and they're seeking to protect US workers in this way.
That's right. And I think that's a good step. They can only try these steps and these changes to protect the US workers. After all, we have been seeing a lot of misuse and lots of abuse that's happening in the system. But I think absolutely that's how they can make the system work fairer and also more flexible. So with that,
Which,
Prashant.
which Sam, would be a good thing if it was just being done for the purposes of being fairer and flexible. I agree with that, and everybody does, I think. But I think the reason that they're doing this is to prevent even companies that uh, do H1s properly, prevent them from filing H1s or creating a fear in their minds
Yeah.
in order to not to file H1s. So I think it also creates fear uh, and prevents even those people who are actually using the system properly from using it and filing H1s,
Yeah.
in my opinion.
I think that's a wonderful opinion because that's what President Trump's administration has also come up with, by deporting so many people back to their home country. And that's how they are setting an example that they are not going to tolerate any illegal immigrants and any abusing things that may destroy the immigration system. So that's the main agenda, to create the fear in every illegal, I would say, not only immigrants, but also the frauds, the scammers, and especially the agents, those who are promoting these H1B, fraud things. So I think,
Which again, Sam, is fine if they're only targeting people who are not following the law. But I'm just hoping that they don't target people who also follow the law by
Mhm.
making the law harder than it actually is. For example, if they're sending out RFEs and they're asking for contracts for, all 3 years. If you're
Yeah.
filing a H1 for 3 years and asking for contracts for 3 years, then that's not in the law. But there's still USCIS is still, if they still ask for it like they did under the previous administration, then that is not fair. Then you're shutting down the H1B system or finding ways of shutting down the H1B system. No one is complaining about uh, cracking down on fraud, because that is extremely important. But in the guise of cracking down on fraud, don't shut down the entire H1B system or make it more difficult for people who qualify to apply for a H1. That's my point.
I'm loving your point. Yeah, absolutely. That's very well said. If we are seeing one side is growing, then another side is also bringing up more challenges. But I think, Prashanthi, that is why we are here to make our viewers aware about the new changes and how they can also protect themselves under, I would say, a very tough time that's happening right now in 2025. And the great thing is that our viewers are really engaging with us, and I can see a lot of viewers who have joined us. So let me take some comments. I can see Vishwanathan is here. So he's asking a question that got my L1 129 approved with work location as NJ office, but today got an additional client option from another city in TX. I will manage both, but which state can I reside? NJ as per petition or TX? Yeah.
Well, if it's an L1B petition, um, it's not like it's not the same criteria that they use for the H1, where the work site is mentioned in an LCA. There's no LCA, so it's not as important as in a H1 where your prevailing wage is based on your work location. The LCA mentions the work location. Your I-129 mentions the work location. So if you don't work at that work location, then you are violating your status. In the L1B scenario, which I think maybe that's what it is, because you just say L1, you don't say L1B or L1A. The work location is important in the sense that they want to make sure that you have a bona fide job offer, which you've mentioned in the L1. So you want to make sure that there's no fraud there, but that is the extent to which the work location is important. But I would say still stick to New Jersey location, because that's what has been said in your L1.
All right. So I think Vishwanathan, thank you so much for being here and participating in this webinar. Let us know if you still have any follow-up question or would like to uh, know any other topic about today's webinar. We would love to hear from you. And let's take Prateek's question also. I got selected in last year's lottery, but my application was denied due to a specialty occupation issue. If my employer registers me again this year, will my denial from last year impact my chances?
No, but you have to learn from your mistakes, right? So if you used a particular job title last year and USCI said it was not a specialty occupation, it's likely that you'll have the same problem this year. But if it's with a different employer, um, but there's another problem there. If it's the same employer and now they're using a different job title, USCIS might question what the job title actually is and whether they're making that change just to circumvent the specialty occupation issue. But if you're filing through a completely different employer, then of course, the previous issue will not impact you as long as you're using a different job title.
All right. So Prateek, please let us know, is it the same employer or the different employer, so that we can have a more conversation into that and can really help you out in your problem. So thank you so much, Prashanthi, also for answering Prateek's comment. And let me take Kritika's question. I'm outside the US and my employer wants to register me for the lottery. If I get selected, how does my visa stamping process work? I am hearing delays in consulates. Could I get stuck for months waiting for an interview?
Well, if you're outside the country, you're already, you're not waiting for anything. You're just living your life, right? So if you do get picked for the lottery, which there's a 30% chance of that happening, um, I mean, yes, there could be a delay in visa processing. Your visa could get denied, H1 could get denied, anything can happen between the time that you file the registration and, after that. So I would say don't give up your job right just yet. Wait to actually get the visa stamped. Then if you're working somewhere, then you do the resignation, because there's so many things that can happen in between. And yes, you're absolutely right. There could be delays, and uh, the visa processing under Trump is also will you will experience again more vetting. They are asking for client letters, etc. So that could cause delays due to administrative processing um, happening. So yes, you couldn't, or nothing, or your visa might just get approved, very quickly. We can't say. So I'm just saying, be prepared for the worst, so that you will not be caught by surprise.
That's right. Okay, thank you, Kritika, for asking this question. And let's take Supriya's comment. I'm currently working on OPT, and my employer is sponsoring me for the H1B lottery this year. But I'm worried if I don't get selected, what are my options? Should I plan for day one CPT, or is there any other way to stay in status?
Unfortunately, no. A lot of students face the same predicament, as there's only a 30% or 25% chance of getting selected in the lottery, and there's no duplicate. And there's no point in filing duplicate registrations anymore, so you can't increase your chances. But your chances kind of are increased if you are a master's degree holder from the US. So that will improve your chances, because then you have two picks in the lottery, one under the master's cap and then the other under the bachelor's cap. So hope for the best, but if you don't get selected, then you have to continue your F1 student status, or you move to a different status. But there is no other work status that you can move to if you're an Indian national. You could file a green card, but again, the green card numbers are not available, so there's no purpose in doing that. So I don't see many options for you. You could try for a J1, but again, J1 is not available for all jobs, and it's complicated, and you might need a waiver, etc. So I think the best option would be an OPT if you're an Indian national, if you want to continue working.
All right. So, thank you, Prashanthi, for putting these very important pointers with us. And Supriya, if you still have any follow up question or would like to know more about it, then why don't you go ahead and contact Attorney Prashanthi Reddy directly to her contact number? And it's not only Supriya, I would say that everyone, the friends, those who are watching us, whether it is Vishwanathan, Kritika, or anyone, Prateek, please go ahead and give a call to Attorney Prashanthi Reddy, because it's really high time. And taking decisions, not relying in a very credible source, is really going to make your visa process more complicated. So to smoothing it, I would suggest to take expert advice. And the contact details are on the screen. That is 212-354-1010, with the email ID prashanthi@reddyesq.com, and the website is www.reddyesq.com. So, with that, friends, we have completed our first session of this webinar. But, Prashanthi, I think now it's time for us to take a quick break so that we can get more engagement from our audience. So, friends, don't go anywhere. We'll be coming up with more insightful answers from Attorney Prashanthi Reddy. And go ahead, put up more questions as possible. And we are here for half an hour more. So thank you everyone for joining us. Keep watching Immigration Talk Show. We'll be right back. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are having a great discussion on the topic H1B season is here. Are you fully prepared for 2025 lottery? And today we are having really wonderful insights from none other than attorney Prashanthi Reddy. And till now, we have covered a lot of different perspective into this conversation. But with that, Prashanthi, I would like to go ahead with my very next question. And this is about increased scrutiny on employer-employee relationship. So, how could employers structure contracts and work arrangements to align with USCIS expectations?
So actually, I hope that there will not be increased scrutiny on employer-employee relationship. As per the new H-1B regulation, they're certainly moved away from the employer-employee relationship issue. The only thing that they want to see now is whether you have a bona fide job offer for the person that you're hiring or not. So I don't think employer-employee relationship is an issue unless USCIS somehow makes it an issue by filing a new regulation. But as of now, it's not an issue. So the only thing we need to worry about with reference to contracts and work arrangements is whether they show that there's a bona fide job offer or not. And for that reason, we might have to submit them, but not for the employer-employee relationship issue.
All right. Okay. I think that's a good news. And also, Prashanti, my next question is that there are reports that USCIS may prioritize wage levels in future lotteries. So, while this hasn't been implemented yet, do you think that it will impact the fiscal year 2025 selection process?
No, because the registration process for 2025 um, for the 2026 fiscal year is still based on the lottery system. It's a random selection process. It's not being based on wage levels. Of course, the Trump administration has said, in pending Judiciary Committee bill, that they want to use either an auction system or prioritize people who have higher wages for the lottery. But they haven't, that is only a proposal. We're waiting for the bill to be formalized, introduced. Nothing has happened yet. They've said that that might be introduced in March, but that's too late to affect this registration this year, because the registration is already starting on March 7th.
Yeah.
And ending on the 24th. So it's unlikely that that will affect this year's registration process.
Okay. All right. That's great. And also, Prashanti, if you let us know what are the key differences in how USCIS is assessing specialty occupation roles this year as compared to the previous year.
So there's a new H-1B regulation in place which talks about a couple of things about specialty occupation. It's not a major change because the regulation basically says that it's reconfirming what USCIS has been practicing in the past few years. But what they've said is that, number one, the specialty occupation, the job should be directly related to the major. But they've also said that the job doesn't have to require just one major. It can require a range of majors as long as each major is related to the job. So what is a specialty occupation? A specialty occupation is an occupation which requires a bachelor's degree in a specific field. And how do they know if a bachelor's degree in a specific field is required? Of course, they look at the industry, they look at Google, they look at a website called the Occupational Outlook Handbook, which is published by the Labor Department every year. And that has positions and it shows what is the educational qualification for the position. So usually USCIS will look at that and they'll say, okay, software engineer, as per the Occupational Outlook Handbook, requires a bachelor's degree in math, physics, computer science. So it's many majors, right? So we have to show that each of the majors is related to the position to show that it's a specialty occupation. So it has to be directly related, and if there's more than one major, you have to show that every major is somehow related to the job description. So it's useful to have a table to show, how it's related. So that's two things that have changed. I mean, which have not really changed, but they've clarified it. The third thing they're saying is that, and again, they're clarifying this, is that even if the, for example, Occupational Outlook Handbook says that mostly a bachelor's degree in computer science is required for this position, but some employers don't require a bachelor's degree. This can still be considered to be a specialty occupation because it doesn't have to be always, it has to be most of the time. So they have clarified that because in the past they were denying cases based on these points, based on there not being one major, based on the fact that all employers don't require it, only some employers require it. So this is in a way good for H-1Bs, but it can be twisted and used in a different way by the present USCIS administration to also deny cases and make it stricter. So it all goes based on interpretation, right? How you interpret the regulation. So they can interpret it differently. So that's about specialty occupation and how things have been clarified in the present regulation.
All right. I think that's wonderfully explained the difference between the two. And with that, Prashanthi, we have another viewer. Vishwanathan is back again with another question. So I would like to take his comment. Vishwanathan is asking that L1A managerial role petition as NJ office work locations. Can I file amendment to the petition from NJ to remote?
I don't think it really matters whether you're working remote or in the office in a managerial role. I don't think for L1A that is really important. They don't care whether you're working in person or remote as long as you're working. But I think it's a good idea to live in New Jersey so that not too many questions are asked when you file your extension. But otherwise, I don't think it matters that you're working remote. It depends on what your office wants you to do or what your office procedures are, processes are with reference to working remote.
That's right. I think this is the question that Prashanthi, most of our viewers have, regarding working from office or working from remote. But actually doesn't matter, right? For the
That's only
L1.
for L1. Only for the L1, it may not matter, but for a H1, it definitely matters.
All right, all right. Okay. Thanks for clarifying that. And I can see a similar question from Samuel's side. I work remotely for a US company while living in Canada. They want to sponsor my H1B this year so I can move to the US. If I get selected, will I need to be in the US for the petition approval or can I do everything from Canada?
You can do everything from Canada. You can apply for consular processing, and then once your H1 gets approved, selected and then approved, then you can go for a visa. You can go in Canada to your closest US consulate and get a visa, and then come into the US on a H1 visa, and then start working in the US.
All right. Okay. Thank you, Prashanthi, for taking these questions up and also answering them in a very great way, in a very detailed way. Rekha is here, and Rekha is asking I work for a small startup, and they are sponsoring me for the H1B, but they don't have an in house immigration team, and I'm worried they might miss something. What are the biggest mistakes startups make in the process, and how can I make sure that everything goes smoothly?
Well, they don't need to have a in-house immigration team, but they do need to have an immigration attorney. So as long as they're using an immigration attorney, I don't think there is an issue. The attorney will take care of everything. But in general, for a startup, the problems that they face is maybe they don't have physical offices yet. So make sure they have a physical office. Make sure that they are able to show that they have a job available for you. Make sure they use the proper job title, proper job description, which shows that it's a specialty occupation. Pay the prevailing wage, after the H1 gets approved. Work from the location as mentioned in the LCA. So these are the things that have to be done, before filing and also once your H1 gets approved.
That's right. Well, Rekha, we don't know whether they have the immigration attorney or not, but we definitely have. And we have one of the finest immigration attorneys. So please go ahead and reach out to attorney Prashanthi Reddy. The contact details are displayed on the screen. So go ahead, dial the number, call her. You can also email her and surely visit her website. So that would be great. And with that, I think I have covered all the comments that we got from our viewers. So now, Prashanti, I would like to shift our focus to our Facebook question. So, with your permission, I would like to reach out to Facebook question. Will that be okay?
Sure, go ahead.
All right. Before Facebook question, Prashanti, this is the comment that we got from our viewer on YouTube. So he's asking that my girlfriend has her B1, B2 visa appointments in 2 weeks from now. We have all documents completed except for the travel health insurance. Does she have a better chance of being approved for the visa having the insurance, or it makes no difference in the eyes of the embassy? Thank you.
I think everything makes a difference, and you have to prepare as much documentation as you can to get that B2 visa because, B2 visas are often rejected. So by showing that you have travel insurance, it shows that you will not be a burden on the systems in the US. So they're more likely to give you a visa if they see that, you're not going to be burdening the US economy. If you get sick and then, go to an emergency room there.
All right. Let's move ahead to our next question that we got from Facebook. I'll be traveling for H1B stamping to India. I'm working for ex employer but switching jobs and have my I-797 with the new employer. I would start with the new employer after coming back to the US. Would there be any issues? Also, should my DS-160 reflect the new employer as a current employer?
I'm traveling for H1 stamping to India, working for X, but switching jobs and have so so if you're traveling for stamping, then you obviously have to go with the employer that you want to work with. Unless you don't plan to work with that new employer as soon as you come into the country. You first plan to work with X, then after a while change to the new employer. But if you're planning to work with the new employer as soon as you come back, then you need to definitely go for a visa with the new employer and show the new I-797 when you're entering into the US.
All right. Thank you, Prashanti, for putting those answers. And let's move ahead with our next viewer's question. And this is a bit long. Hi, all. Could you please advise me on this situation? My H1B extension was filed on February 7th under regular processing. My perm date is November 30th, 2023, and I expect to receive approval soon. My current H1B is set to expire in May 2025. I'm debating whether to upgrade my H1B to premium processing since my company is not covering the cost. I assume they will also not OPT for premium processing, opt for premium processing for the I-140. Since I need to apply for an H4 EAD, I'm considering paying out of pocket for premium processing for my I-140. However, I'm unsure if upgrading my H1B is worth the expense or if it's better to wait. My main concern is ensuring that this does not delay the H4 EAD timeline. Yeah, Prashanti.
Well, there's a lot of information in there, but the question is very simple whether to do H1B premium processing or not. That is, of course, an individual choice. You have your H1B is expiring in May, so March, April, May. That's 3 months. I would say go for premium processing because, if you don't, then I don't know when you actually filed. You filed it in February, so only recently. I don't think you'll get. Uh, you'll get a response by May, because that's only 3 months away. So, and then you might see that your I-94 is expired, and then if something happens, then you will be left without status. So in order to avoid that kind of a situation, I think you should go with premium processing if you don't hear from them soon. And I don't think regular processing, you'll hear from them before 4 to 6 months. So yeah, premium processing is the way to go.
All right. I think our viewer, we don't know your name, but do let us know your name and go ahead with the premium processing. Let's move ahead with the next question that we got from our viewer. And it's about change of passports in middle of 221G process. Hello, my H1B petition was under 221G for last 6 months, and yesterday they asked to submit the passport here in India. It still shows refused as of now, but another concern is my current passport is within 6 months of expiration. I have already applied for a new one. I don't know if I can update my DS 160. Shall I take both my passports and explain them my situation?
Yes, that's a good idea. If you have a new passport as well, then you should submit the old passport and the new passport as well, showing that you received the extension. That's a good idea, because if your passport is expiring within 6 months, then they may want to see that new passport.
That's right. Okay, I think he got his answer. And with this, let's move ahead with the next one. Hello, I am on my fifth year of H1B through employer who is CAP exempt. I have my master's degree and work as a research assistant in psychology. I'm trying to see what my options are since my employer is not willing to sponsor because they only sponsor tenured professors. Any suggestion on what can I do? Trying to get into a PhD, would there be any paths there? Any help would be appreciated. Yeah.
So he's on his fifth year of the H1, which is CAP exempt, has a master's degree, working as a research assistant. If they're not willing to sponsor for the green card, then you are running out of options, because your H1 will only be for 6 years. Then yeah, you'd have to either change status, like you said, to an F1, and update your skills, and perhaps go into the academic field. Maybe then you'll qualify for an AB1, or find an employer who's willing to sponsor you, for the green card. So that's the only two options you have: either change your status or find an employer quickly who's willing to sponsor you for a green card.
All right. So I think these two options are
I mean,
the
you
only.
could try to file for a change of status to an O1 if you qualify, based on your research. But, I think it's important to file a green card at some point. And so if your present employer is not willing to do that, it's time to look for a new job.
Absolutely. Okay, I think this is a very understandable answer that we got from Prashanthi. Thank you, Prashanthi, for taking these questions. And I think these were the questions that we got from Facebook. With that, I would continue with my questions that I prepared from my end because we have already taken a lots of questions from our viewers. So let's also talk about the premium processing timelines and that have faced delays recently. So, should employers expect any slowdown in H1B adjudication for fiscal year 2025?
Well, if the present administration is hell-bent on kind of slowing down the H1B process, then the best way for them to do it would be by slowing down their processing times, which is what they did during the last Trump administration. The processing times really skyrocketed for a lot of cases. With premium processing, they are mandated to process within 30 days, but right now they don't even take 30 days. I mean, usually if you do premium processing, the case gets approved within a week. So if they want to delay premium processing, then they can certainly delay it by either sending out RFEs, which will automatically delay the process, because then there's no 30-day mandate.
Mm-hmm.
Or they can wait for the 29th day and process it on the 30th day, thereby delaying premium processing, which was now taking about a week or 2 weeks to, using the full 30 days to, process the case.
All right. Okay. And with that, I have another question regarding RFEs issued. So, with more RFEs issued for third party worksite placements, what proactive measures should consulting firms take to strengthen their petitions?
So right now, as the H-1B regulation, new H-1B regulation has stated, USCIS will be looking to see if there's a bona fide job offer and there's bona fide specialty occupation work available for your employees. So if you happen to be a consulting company, then that would mean having to submit proof that the person will be consulted out to a third-party worksite. And the proof would usually be a master services agreement, a purchase order, work order, letter from a vendor or a client. Those are the kind of documents that they're looking at. So if you don't have a job, then you should not be filing the H1. Only file the H1 if you do have a job available for that employee of yours. And this is consistent with what was being done in the previous years. Only recently, companies are filing H1s without POs and work orders, etc. But this has always been the case where they've needed it, for many years. So it's coming back to, square one, where we're again submitting contracts and work orders. The only difference is they're not requiring you to submit contracts and work orders between all the parties involved, number one. They're just seeing if there's some bona fide employment available, and if they're happy that if they're satisfied that the letter from a vendor or a PO from the vendor shows bona fide job availability, then they may not ask for letter from the client, contract between the vendor and the client, contract between all the parties. But they can certainly start doing that if they want to, because they can interpret it any way they want. But in the actual comments to the regulation, they said that they're not looking for that. So let's see if that changes. But as of now, what we're asking clients to submit is at least something, vendor letter or a PO, even if it's from the vendor, to show bona fide employment. Also, one thing I forgot to mention, that with reference to specialty occupation, they want to see that it is a specialty occupation based on the end client requirements. If you are a consulting company, not based on your requirements. So in that case, if there is a question about specialty occupation, if you are using a job title which might prompt an RFE asking whether it's a specialty occupation or not, you'll have to submit a letter from the end client saying that the job requires a bachelor's degree in computer science, for example. Or maybe advertisements from the client website, when they advertised for that position, that the requirement was a bachelor's degree in computer science. So that's another thing to keep in mind, where an end client letter might be needed, or other information from the end client might be needed as to show that it's a specialty occupation position.
All right. Okay. And also another question, Prashanthi, that I would like to know it from you regarding what are the major takeaways from last year's H-1B gap season that employers and applicants should learn from to improve their chances in fiscal year 2025?
What we noticed last year and the year before that, they're asking for evaluations for even if you have a foreign degree, even if it's like a basic computer science engineering degree, straightforward, they're still asking for evaluation. So I would prepare in advance, because if you prepare in the last minute, it's difficult to get evaluations from the evaluation companies. So as soon as you get picked, I would at least get the evaluations done for all the cases that you have, so that you're sending them out with evaluations. Otherwise, by getting RFEs just for evaluations, and that delays the case, increases the cost of the case. It makes no sense, and also increases the chances of denial. So evaluations are a must, and in order to do that, you need to prepare well in advance so that you can get the evaluation in advance. So you can't file the case in the last month, because in the last month of June, which is the last month to file, nobody's going to give you an evaluation. So keep that ready. And the other change is, of course, we've seen changes from last year to this year. Last year, we didn't really submit vendor letters or client letters or contracts. This year, I think you need to get those ready and submit that with your application to avoid an RFE. So that's the other major change that I see. With reference to specialty occupation, use job titles if possible that are recognizable as specialty occupations, which USCIS is comfortable with, rather than using job titles that they're not comfortable with. Even though it's the job description that is important, not the title, the first thing that they look at is the title, and then they look at the job description. So which leads me to the job description, which makes sure that the job description is detailed, the job description shows sufficient complexity, and sufficient details to show that a bachelor's degree is required in computer science or in any other specific field to show that it's a specialty occupation. So these are a few pointers that I have for this year.
All right, that's great. Okay, so friends, I can see more viewers have joined us right now, and let me take Pratap's comment here. So thank you, Pratap, for being here and participating in this webinar. He's asking, I went to the US with H-1B visa on September 4. After that, the project went on hold, and I came back to India on November 24. I was in US 50 days only, but did not run the payroll. Will they ask pay stubs at immigration? What are the mandatory documents should I carry with me?
Carry for what? Are you going for a visa, or um, went to the US? You already have a visa. Are you returning back into the country? What is the context here? What are you planning to do next?
Yeah, I think Pratap, we are lacking some information. So please let us know what is the context here, so that Prashanthi can help you out regarding your question. And we are here for, okay, it's almost time, but don't worry. We are here for 5 more minutes. So please post your question as soon as possible before the live show ends. And Prashanthi, I have one more question for you about Department of Labor has updated wage level data. So, how do these new prevailing wage figures impact the H-1B salary compliance and petition approvals?
Let's take Pratap's question first. I think he's answered it, and then, because this is a little long, so let's take Pratap's
Sure,
question first. Sam?
sure. Why not? I think he said that I'm planning to go to US now.
If he's planning to travel to the US now, are you planning to travel with the same employer, or you're filing with another employer? If you're going with the same employer, then it's definitely going to be questionable as to what you did in the US for 50 days, because that is pretty much shows that you're out of status, unless you should have applied for a social security number and gotten onto the payroll in that 50 days, or at least after you got the social security number, even if you came back, they should have given you back wages. So if you're planning to travel now, they're definitely going to ask you what your status was when you were in the US. So that payroll is important, so that you don't get into trouble at the port of entry.
Okay. So I think Pratap, you got your answer, and thank you so much for participating here and for asking this question. I think Prashanthi, let's end our session with the question that I have, mentioned. This one, the Department of Labor has updated wage level data. So how do these new prevailing wage figures impact H-1B salary compliance and petition approvals?
So yes, they have updated the wages, and they continue to update them every year. So every year they update wages and they increase a little bit. but the important thing is, another important thing they did is last year in July, they switched from one system to another. So they decommissioned the FLCA data center and they switched to the flag system. So this has improved the way we search for wages, because now we can search for wages based on the ONET code and not based on SOC code. What this means is that there are many more positions opened up for us where we can search for the wages. Before, the positions were not there, and we had to basically look for the closest position available and use that position. So now a lot more positions have opened up because they're using ONET directly, and ONET has many more positions in their database. But with reference to increase in the wage levels, we've seen increases. Some changes that I wanted to point out, which were unusual, is that, for example, software developers, the wage level went up by 21% in San Francisco, whereas in New York it just went up by 12%. That's something that I wanted to highlight. But otherwise, if I look at some common job titles, for example, software developer job title, for level 2, it's 123,000, and that's gone up from 2023, where it was actually, let me check. The wage levels for 2023 to 2024, it's gone up again by a few thousand. If I look at the hourly rate for level 1 and level 2 and level 3, and comparing the different years, for 2023, it was $40 an hour, and now it's become $45 an hour. So you see it went up by $5 an hour. And in 2024, last year it was 42. So it went up by $3. So every year it goes up by $2 or $3 an hour, a few $1,000s a year. And the same thing happened this year as well. So yeah, wage levels have been continuously going up. In some instances, it hasn't gone up, but that's unusual. But usually it does go up. For managers, for example, it's been steady for all the years. In fact, it went down in 2023 and then went up slightly again in 2024. But in the IT positions, usually it goes up marginally or to a great extent, by 10, 20,000 every year. So overall increase, 2% increase in H-1B jobs for all data, for all data, on all cases, sorry. For example, data analyst cases, it went up by 19%. And as I said, software developer went up by 20%. So as you see, there has been an increase overall in the prevailing wages over the years. And you can expect that to continue.
All right. Thank you so much, Prashanthi, for taking that question up and explaining us in a very detailed way. I'm sure our viewers are really, getting a lot of new information about this topic. And with that, it's almost time. We have I come across 1 hour, and we didn't even realize. So thank you so much, Prashanthi, for being here. Any last message that you would like to share with our viewers?
Just that with the prevailing wages increasing every year, and I don't know how realistic that wage increase is, whether it is actually mirroring the actual wages that people are getting paid. People who are not on a H1 are getting paid. It should, but I don't think it is. I think the prevailing wages for H1 candidates are more than the wages that are usually being given in the market for non-H1B candidates. So this, puts employers at a distinctly disadvantageous position, and they will, obviously hire less H1B workers, and then what will happen is then the work, if there are no US citizens, permanent residents available for this job, the work, all these jobs will go out of the country. So I don't think what the present administration is saying is true, that the jobs are not available for US citizens. I don't think there are enough permanent residents and US citizens available for these kind of senior IT position jobs. Maybe for entry level positions, they might be available given the year, because every year is different. But for senior positions, there's definitely still a dearth in talent in the US. So if they don't allow H1Bs to um, kind of make up for that dearth, then all these positions will go outside the country, and Microsofts and Amazons will hire people in India or in Mexico or Costa Rica, and then the economy of those countries will benefit as opposed to the US.
Absolutely. I think that's wonderfully explained and, putting up, I would say, such a different information to us also. I am sure our viewers are learning a lot of things from this webinar. And before starting the show, I asked a question that are they fully prepared for the H1B lottery 2025 or not? But I said that after the show, they are definitely going to be. At least they will have, more knowledge. They will have more data, how to prepare. They'll get the way. So I'm sure, Prashanthi, with your insights, with your expertise, they have filled themselves with lots of information. So again, I would say it was really wonderful having show with you. I really enjoyed that. Thank you so much for being here, and I'm really looking forward to have more shows with you.
Thank you, Sam. Take care.
All right, that's great. Friends, the great thing is that you can also contact Attorney Prashanthi Reddy on the given number. That is 212-354-1010. And the email ID is prashanthi at reddyesq.com. And visit our website, that is www.reddyesq.com. And with that, friends, I would like to take a leave now. Don't forget to like, share, and subscribe to Immigration Talk Show. Our handle is at Immigration Talk Show, and we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So follow us on these many platforms and ask as many questions as possible regarding your immigration journey. We come up here with very different topics on every week so that you guys can get a clear concept about your problems. So keep watching Immigration Talk Show. Meanwhile, I'm Sam signing off for now. Goodbye, everyone, and take care. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are here with another very exciting webinar that is lined up just for you today. So make sure to watch this session till the end, and you can also ask questions. That is the best part of our webinars, that you can participate by asking as many questions as possible. And with that, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So check out us there, and also like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared by our experts and attorneys, including user comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And today, the topic that we are going to talk about is another very important and very essential, especially for E2 visa applicants. And that is, what should investors know about the E2 visa changes in 2025? So, to help me in diving into this discussion and also to make this webinar a wonderful one, I have a very special guest who is joining us for the very first time in Immigration Talk Show, none other than attorney Jessica Weiss. But before inviting her to this webinar, I would also like to tell something about her that Attorney Jessica Weiss is a nationally recognized immigration lawyer with over 2 decades of experience and remarkable list of achievements. She was honored with the prestigious Immigration Services of the Year award from the Global Chamber for her outstanding achievements and exceptional services in the field. Jessica also serves as national mentor for the American Immigration Lawyers Association, guiding fellow immigration attorneys in the areas of adjustments of status and also on E2 visas. The great thing about her that she takes the time to understand each client's case in a very unique way, and she also guides them every step on the way. And whether it's coming to the US as a tourist, moving to a green card, or one day becoming a US citizen. So I'm really thrilled and honored to have a show with her. So, Jessica, thank you so much for being here. We are really honored and we welcome you wholeheartedly to Immigration Talk Show for the very first time.
Thank you so much. That was quite an introduction. I very much appreciate that. And I can't explain it, but I love doing E2 visas. I've done them for more than 2 decades, and I really, really enjoy them because it's such a great way for people to come to this country. So I look forward to this show today with you.
Absolutely. I'm sure our viewers are really excited for this session, and that too, it's a very important topic. So I think without any further ado, I would just like to know it from you, Jessica, that what our viewers would expect from today's webinar.
So I think what they can expect is a better understanding of where are we going with E2 visas. Is it going to be the same story as the last, what I mentioned to you a little bit earlier before we started the show was 1815 is when E2 visas started. That's over 200 years of E2 treaties. And do we think in the next year with President Trump in command of this country, is it going to change drastically? So I want you to understand, what are the changes? Will there be any changes? Are we in for another several years of a great ride with E2s? And I think you'll get that from this presentation today, a much better understanding of that.
Absolutely. I think that's great. Our viewers are going to know a lot of things in today's webinar. So, Jessica, let's begin with our very first question. What should investors know about the E2 visa changes in 2025?
Okay, first thing is, I don't think there are going to be a lot of changes. I think we're in for a great ride. If you look at the last time that President Trump managed this country, we didn't have a lot of changes. In fact, we had 2 countries that were added to the list of E2 treating countries. We had Israel and New Zealand. And I think we're in for more countries may get added on, which is very exciting because there are so many countries that want to be part of this E2 treaty that we have process, and they're left out. I don't think every country like mainland China, I don't see that one happening so fast. It just depends on our relationship with a country and how much trade we have and how much we want to benefit each other's countries by allowing them to do this E2 treaty. So I think we're in for could be some more countries added. There are a few things that actually very recently something changed, that it used to be that you could have a waiver of your interview, let's say for an E2 visa, if you got it within 48 months of the last one. They just changed recently that it has to be within 12 months that you got your visa, that they will waive the next interview for an E2 visa. So a lot of people are out of luck now. So there are probably going to be way more E2 visa interviews, which also can slow the system down. So that's what's going to be, that's happening right now. That just changed. In terms of if there's going to be a larger investment, like right now, substantial investment, we'll talk about what figure is substantial investment. I would say that figure is not going to change too much because that's the beauty of the E2, that it can be a small investment, could be $100,000, $150,000. Could be less even. I've done them smaller. Could be $1 million E2. But I don't think that number is going to change so much. I do think that the Buy American, Hire American policy that Trump puts in place could affect some of the E2s. It could be that when you apply for an E2, they want to hear, tell me about all the American workers you're hiring, because we want American workers to get jobs. So the E2, if someone says, I'm going to hire a lot of foreign workers, non-immigrants, green card holders, but not a lot of American citizens, I'm keeping an eye on that to see where the Buy American, Hire American policies will go. And I also would say that scrutiny of the cases, I think there'll be plenty more scrutiny of the cases. Sometimes I'm shocked what they scrutinize over. One gentleman, we just refiled his case again. Why did they scrutinize it? They said, well, you never ran a dry cleaning business before, and you wanted a dry cleaning business to run in the United States. So I'm thinking, for an E2, you never have to have the exact experience in the business you're going to be buying, but you need to have, let's say, managerial experience or, some business background. Just depends, but it's never so precise. Exactly. This man said I didn't have dry cleaning experience, but I have management experience. So he refiled it because we were like, this is ridiculous. And he just got it approved today, actually. So he's really excited. So some more scrutiny could be out there, but we deal with it as it comes. If we know what the rules are, we push on the rules. We know what the regulations are for E2s. So that's some of the stuff I think coming, some more scrutiny, maybe some more E2 treaties, which could be exciting. More American workers they're going to look for in some of these companies. The visa waiver, the being exempt from the interview, that's basically taken away. Everyone's going to be interviewed for extensions, for renewals, for brand new E2s, all that. So those are some of the changes that I could see coming.
All right. That's great. And I love the energy that you're putting up and, beginning our session.
I love this stuff. I don't know why.
Absolutely. I think everyone is loving, and that too, that's so great that you have put up so many different pointers, that too in very first answer. And I'm too getting a lot of questions in my mind, but I have to be very much particular about the topic. But with that, Jessica, I have just a random question from my side that you put up about trade and tariff from President Trump's administration. So, do you think that putting up tariff and trade, all these things, may hamper the relationship between the two countries, majorly the US and the other one? Do you think they will have a hostile relation, or whether the relationship will increase and become better?
It's a very interesting time for that question because half of my clients are Canadian, and we see what's going on in Canada. Trump is taking a very tough approach, putting more tariffs, saying, look, we don't want to give you as free a ride as we gave you before, but they're our neighbors. Mexico's our neighbor. And I still believe that we'll work this out somehow. But I do believe that it does factor in. I think because it's a treaty, an E2 treaty, the reason for it, the basis of it is because we have ongoing trade with another country. And we want to give our citizens and their citizens an opportunity to benefit, to build a business, to create jobs in the various, respective countries. So I still believe, I'm telling you, I've been doing this 27 years. It is a great way to come here. And even though there's tariffs and even though there'll be, more restrictions, I still think it's going to keep going because it benefits both countries. And it's all about, how can the U.S. get ahead? The U.S. has benefited so much by having all these E2 foreigners come here, create jobs for American, bring their capital here. That's all good stuff. For, to build an economy, that is all really good, what we want here. So I still think even with the tariffs, it's still going to be good. It's good news. I am so positive about E2s. I love them. Besides the fact I love them, I think it's just such a great way to come here. And it's not just for the investor. It's for the spouse, too. It's the children. It gives everyone an opportunity to come here. So it creates a whole life for a family in this country.
Wow, that's great. All right, I'm sure E2 E2 visa applicants are really looking forward to this session, and they are going to have a lot of different information with this. So thank you so much, Jessica, for putting up those very important pointers. As we are not having much changes, so I would like to know it generally that how is it going to affect foreign investors who are seeking to establish or expand businesses in the US?
So one thing you have with foreign investors is the currency. They have to see the currency. Like I've had clients, because I deal with a lot of clients from Canada, that say to me, well, I don't want to pull all my money out right away because of the currency difference. And right now our Canadian dollar is not as good as the American dollar. So they're slowed down a little bit of like, if they're going to do it, maybe they'll wait a little bit, see what happens with the economy or whatever. But overall, I think that the changes, because there's so few changes and because they still believe that America is a land of opportunity, I know it sounds cliche, but they still believe that they will keep coming. Even some of the changes that we see, like, will there ever be a higher investment figure? They say substantial investment for an E2. They never give us what is the figure. So it's based on, they look at the whole picture. They want to see, what does it cost to run this business? And years ago, I had a case of someone who invested $40,000 in an E2. It was a little one, because I usually like them closer to 100, 150,000 investment. They invested 40,000. It was an administrative office. They would use their administrative office staff at different offices. They had very little overhead, and they only need to invest $40,000 in cars and computers and advertising, attorney fees, and that was it. And it worked, and that was like all they had. So will they look at the investment number and say, well, 40,000 is so little, maybe we want it to be higher? They haven't changed that yet. It's still out there. Your investment can be little. We like it bigger because we want to show that gross sales are strong and their net income of the company is positive. So it's very hard to show that the workers are going to be paid minimum wage, 35, 40 hours a week. We need 2 of them for the E2. It's hard to show that if you buy a company that's so tiny and the gross sales are so tiny. So they look at the whole picture, and they're going to look at the finances, and they maybe even scrutinize it a little bit more to see, do we want to bring this foreigner here? Are they really going to have a productive company? They also look at job creation. They look and see, so you committed to 2 full-time workers, which is required for an E2. How soon are you going to get them on board? I like the workers on board right at the beginning. Even if I get 1 full-time worker on board, within a couple months, I got the next one on board. But I really like the workers on board. And then the documentation. I mean, I had a client once, they were from Pakistan, and they had to prove every bit of where that money came from to invest in the U.S. company. Not only that all taxes were paid, but also where did it come from? So they had to show their bonuses, their paychecks. They had to go back to the very beginning, and we had to get a letter from the employer confirming exactly what they paid them. And that was pretty specific. I usually don't have to get that specific, but it's out there. I mean, we go back to the origins. We really want to know who gifted you that money. Where did the source come from? Years ago, a client said to me, I'm so happy I got money out and I put it in a bank account in Switzerland and I never had to pay taxes on it. And I said, that's ridiculous. I can't help you with an E2. You have to pay taxes on the money that you're going to use for the E2 business. So these are some of the, the little nuances that, we were going to look for, and they may look for more as these E2 cases, and they're becoming more popular because as other categories max out, like H-1B. Some of the H-1B people say, well, I missed the lottery. Let me try to create a business. So the E2 system can get, there's still plenty of E2s available, but it definitely, I think it's going to get busier, actually.
All right. And also, I would like to know, Jessica, that how much money do investors need to invest to apply for an E2 visa? This is the most demanding questions that most of the investors ask.
Yes, it's a very good question because they don't have an answer out there. There's no specific answer. Substantial investment they look at. So you could have, like I said before, I had a business, $40,000, that's all they invested. I tell people to stay around $100,000 to $150,000. So what does that mean? Let's say you find a business that cost $80,000 to purchase. Well, that's not $100,000, $150,000, but there's so many other expenses that are involved in making that business happen. Attorney fees, travel expenses, maybe you buy a car, other fixtures, any renovations. So now we're getting it over the 100,000 mark. So the contract itself doesn't have to be exactly 100, 150,000. If you're creating a business from scratch, you're going to keep track on a spreadsheet. Every time you pay something, and you're going to show proof that you paid for it personally as the investor. And you're going to keep track of all that till you get to a substantial figure. But what is substantial? I would say, look, as close as you get again to 100,000. But I have clients that say, look, all I can do. One gentleman, he was creating a painting business. I have some great stories, by the way. I've been doing this a long time. But one gentleman, he was creating a painting business, and he hired 2 painters. Only needed so much money for all the painting supplies, advertising, overhead, office location, whatever. And that was it. He said, I can't get higher than 60,000. That's all I have. That's all I need to run this business. Another gentleman, he bought 2 trucks. Each truck cost over $100,000. That got him to over $200,000 his investment. He bought 2 trucks, had 2 full-time truck drivers, and he had plenty of opportunities to, use the trucks to bring products to different locations. He ran the business as an E2 investor, and that was it. So, it just depends. What does it cost to run this business? And the other thing I'll just mention is that when you're going to buy a business versus creating one from scratch, you can create what's called an E2 contingency clause, where you say to the seller that the whole entire deal is contingent upon me getting an E2 visa or a change of status by immigration in the United States. And either way, so then you're not putting all your money down. All of a sudden you're like, what? Why didn't my case work? You can, if it doesn't work, you get your money back because it was a contingency clause. The seller has to be willing to do that. And sometimes the seller wants a non-refundable deposit, a small amount, could be 5, 10,000 something, but it holds them for a few months while you're waiting for this case to get approved. And sometimes that's what the buyer needs, because they're nervous. This is like, could be all their money that they've saved up, and they're throwing it into a business and they don't even know if it's going to get approved or not. But thank goodness, I have a very, very good track record. I mean, I'm telling you, I do one E2 probably every week for the last 27 years. I'm always doing E2s. Always. And my track record is very, very good. In fact, one of my cases they used to educate their staff at the U.S. Consulate in Toronto. So that's pretty exciting. My client was like, they asked for permission to take that file and show it to the staff. I'm like, yeah, sure. Why not? So
That's lovely. That's lovely, of course. With that, Jessica, here's another very interesting question that most of our viewers are waiting for. That how do you see the future of E2 visa under the Trump administration?
I see it as great. I see it as great. I'm telling you, this is what Trump wants. He wants to bring in more capital into the country. He wants to create jobs for Americans. He wants industries to thrive. There's certain industries that are very popular with E2s, like salons are popular. I'm not saying Trump wants all the salons to thrive, but he wants it definitely can build up different areas in our country. And it's a win-win. It's a win for everybody, because there are people in countries, they just can't wait to get out of there. They don't see a future for themselves. And coming here, it also doesn't take that long. And E2 can be done either E2 visa at the consulate, which takes usually a few months, the whole process, or it can be done in the United States. If you come in as a visitor and you do a change of status, and you can expedite it. So you can get an answer very quickly in 15 calendar days. So it works. I see a great future.
All right, that's great. Most of our viewers were really worried, the Trump administration, because we are going to hear a lot of executive orders nowadays. So they were really worried. But I think, as per your expertise, they shouldn't be, right?
Look, they can worry if they want, but that's what our job is as immigration lawyers. We hold their hand. We try to make the most successful case we possibly can. We look at the regulations, we look at what they have, we try to make it work, and then we give them the confidence they need to go to the interview, or before we file the case, we make sure everything's there, and then that's it, we file. So we don't take cases that we think have a very difficult shot of working. I really want this to work for them, because this is everything. Sometimes this client, it's all the money they have, and we know that. We feel that. And we work with them on that. And I'm telling you, it's like immigration is a little bit like social work, because you're dealing with somebody that this is everything to them. And I literally have clients say to me, do you understand? This is all my life savings. I had one gentleman tell me, my house burned down in this location, my house burned down in that location. This is all the money in the world I have, and everything I do, nothing ever works out. And I'm like, we're going to make this work, because this is important to you. Yeah, that's how we do it.
That's lovely. I'm sure you are filled up with so much positive energy when any client comes to you. They are just quickly becoming so happy, right? Just by
I'll tell them the truth too. If they show me how we do it, usually is a business broker gets involved. And a lot of times if they want to buy an existing business, and I have to see the paperwork. I have to see, what are the gross sales, the net income, the employees, are they legal? And I tell them, look, so far things look good. Let's keep going. But if I start to see red flags right at the beginning, I tell them, do you really want to commit to something that's probably not going to work? Because you don't want to be going to that interview at the consulate and asking for a favor that, like, sorry, my case isn't fit so well, but please give this to me. We want to have a solid case when we go. And then they don't have to be so worried about, what Trump going to do, whatever. But we always ask them right from the beginning, is there something in your background that prevent you from getting an E2 visa? Because they do. We have to know anything criminal, any, bunch of DUIs, we have to know. So we don't get to that point where they need a waiver at the interview and we're like, why didn't you tell us that you smoked marijuana and were arrested for it and it's in your record? Like, we need to know these things up front.
All right. Okay,
Yeah.
that's great. And here's another question, Jessica, about the key requirements. So, what are the key requirements for obtaining an E2 visa, and how can investors ensure that they meet these criteria?
Okay, so key requirements are number one, substantial investment. Okay, we discussed it a little bit, 150,000 roughly, can be less, can be more, but substantial investment. It could be gifted to you. It could be your parents want you to have this opportunity to come to this country and they gift you $200,000, but it has to be a gift. It cannot be a loan. So substantial investment, you want to make sure you hit that around that range. You have to play an active role. So if years ago a gentleman said to me, I bought a gym, it's a 24-hour gym, everyone just goes in with their key and I don't have to do anything. I said, that is not a need. You have to be there to run it on a regular basis. You don't have to be there 9 to 5, but you have to be there regularly and know what's going on with your business. Also, you want to buy something that you're not hiring your whole family. So I have clients to say, if I'm going to invest in an E2, I'm going to bring over my sister, my aunt, and everybody. I'm like, that's not going to work for an E2. You have to create jobs for people other than your family. So there's something out there called marginality. And if they deny your case because of marginality, it's because they feel that you do not make enough gross sales to cover the expenses to run the business properly. And they call it marginality, and you don't want that. You also have to have intent to depart. So I had a client once went to an interview and said, yeah, I sold everything off, my house, my business and everything. And I'm just waiting for my E2 to get approved. And I told him, you don't do that. You have to always show in the interview at the consulate that you have intent to return to your home country, that you have something to come back to. So it's important that you have that too. So these, and also that all taxes are paid and the money was received legally. That's another thing. I usually don't have this issue, but if you got it through drug sale or something, terrorism or something crazy, like it's going to be a problem. We have to know really the legit source of that money. And then a strong business plan is key to these cases. They want to see over a period of time, over 6 months, 1, 3, and 5 years. They want to see, how are you going to build this business up? Who are you going to hire? What are your gross sales going to be? And we do strong comparative market analysis in the business plan to show similar businesses and how yours is going to thrive like theirs. And we put all that together, and usually it's several hundred pages, and then we have to shrink it. If you file with the consulate, you have to shrink it to the amount of pages they require. And for example, Canada is 50 pages. So my clients are going to be like 200 pages, and I have to spend time just shrinking the case to like 50 critical pages. And then the rest they bring with them to the interview. So those are the keys. And when you hit them, that's it. You hit these requirements, you can have a great case. I also want to share, though, sometimes you see a case and it has potential to be a great case, but it's not a great case, meaning like the numbers aren't so great, but you're going to build it up. So immigration says, show us in a strong business plan. We want to see how you're going to build it up. So if your gross sales are good, but you have a negative net income, even if it's 10,000, 100,000 gets harder to justify. But let's say there's a lot of deductions on the tax returns or whatever. If we can explain what happened, what went wrong, and this is how you're going to turn it around, sometimes those cases can work nicely too. So I wouldn't say every case has to be really strong net income, really amazing gross sales. We look at each and see, can we turn this into an E2?
All right, that's great. Also, here another question, Jessica, that have there been modification to the minimum investment amounts or the types of investments considered eligible for the E2 visa?
So there hasn't been changes to the minimum investment amount, but the types of investments considered eligible for an E2, I would say now with a lot of remote work taking place, they've opened up themselves a little bit more E2s to some more remote, like remote offices, but you still have to justify, why do you need to come to this country? So if you have a business that all runs remote, like it's a sales business, you sell a product online, maybe you have a factory in the US, and maybe we could show how you have to check on it regularly or something like that. But when they come to me and they say everything's remote and I just need, workers in this state and another one in that state, and I'm like, it doesn't work so well. Like I had a woman years ago that she had a facility in California that made facial products and for skin and stuff, but her headquarters were in New York. But I explained that she has to go back and forth. And she really lived in New York, but most of the activity of her business was California. But we explained she had to go back and forth regularly, so she needed to be in the United States. But with so much remote work, people try to say, well, it's just all remote. And I'm like, you got to create a little bit that's not remote to work for an E2. But other than that, the types of investments, well, the thing is, people always call me up and say, I bought a house and I want to flip it. And I'm like, E2s, you flipping houses does not work for E2s, but let's get creative. There are ways to do things with the house, a house business. For example, you could have joint like apartment complexes, several of them, and say, look, I need to hire a manager, renovation person, et cetera, and turn into an active business. When you buy one house and you flip it, it's not active. They don't like that. But there are a lot of ways to. I had one lady who she would buy the houses, she would create financial mechanisms for people to live in the houses, and then eventually they would buy the houses from her. So her business was the financial part of it. And that was the active part, even though she owned all the houses. But you can't just, one guy's like, I'll buy a house, that's my business. I'm taking care of the house. I'm like, no, that does not work for any two. It still doesn't work for any two. So
All right. Okay, that's really interesting. Also, Jessica, why is the E2 visa country specific? We know it's obviously a country specific, so we
yeah.
want to know the reason. And why is it available to citizens all countries like other visa types?
So the beauty of the E2 is we say to another country, you have so much trade and interaction with us at a business level. We want to continue that. And this is another way of continuing that by having E2 treaty that we have, and they have something similar in their country. For example, the country of Israel, we didn't have it for so long, and now we have it because there's a mutual agreement that they have an equivalent that if our American citizens want to go there and build businesses and hire workers, whatever, they have something equivalent to our E2. So that is why, because we have these ongoing relationships, and this just continues that relationship. But there are certain countries we don't have relationships with, like Iran. We have no relationship, no E2 with Iran, but there are other countries that who knows what'll happen maybe that will get it. I mean, New Zealand just came on board a few years ago, and there's a lot of talk about Greenland. We don't know what's going to happen with that. There are countries out there that are very interested in this relationship. So, but it's not with every country. That is true. And as I mentioned a little bit earlier, that it's very interesting the date that the treaty started can be 1850s, can be early 1900s. These relationships have gone on for a long, long time. So that's another reason why I don't think they're just going to go like that. There are changes that have come between the agreements that we have with countries, like France originally had an E2 visa, it was a 5-year one. Then they took it away and made it a 2-year visa they issue. Now we're back to 4 years. So sometimes the agreements that we have for the E2, there are adjustments that come about, but they give a lot of notice if it's going to happen usually.
All right.
So,
But Jessica, talking about the country's relationship, if we specifically talk about India, then India doesn't count in the E2 visa, right? But
right.
similarly, we have seen President Trump and Prime Minister Modi, they are having a very good relation. And not too in the second term, but also during the first term also. So, is there any chance that India can also count under the list of E2 visa, maybe after having good relations? Or what's your call?
Right. This is a good point that you make. The issue also becomes there are certain countries that the population is huge, like mainland China, India. If you look at the visa bulletin, where they're seeing, the certain amount that we issue of green cards to certain countries like Vietnam, India, Mexico, there are so many people wanting to come here. But I think there are a lot of factors that play into which countries we have the E2 treaty with. And I think India would be flooded with candidates if E2 visa came about. This is just my own personal thinking of this. Or mainland China, we would be flooded with them. So part of it is the ongoing relationship we have. And part of it is we have to look at the numbers. What would this do to our country if we open the doors to certain very large countries? Look, we do have it with Mexico. Right? We have an E2 treaty with Mexico. That was a long time ago it was established. Our relations are tenuous right now with the border and all the issues there, but it hasn't really been talked about that we would get rid of it. So there's probably a lot of factors that go into why do we have an E2 treaty. I'm only mentioning a few, but there could be behind the scenes things like, for example, with Israel, there was a lot of visa waiver overstays. So that was delaying it. They were like, Israelis need to stop overstaying on their visas. They respect our laws. And then, they were working out all the little details. So I don't know what ones are on the burner, so to speak, right now, but I'm hopeful that there will be more countries that we do have it with.
Absolutely, because nowadays we are seeing that we don't know whether the relationship are being very friendly or not with USA, but at least with India, we
Mhm.
have been seeing a better relation, and as compared to Mexico, Canada, the other countries who have the E2 treaty. So I think let's hope, and if you are saying, then I'm sure our viewers would be hopeful, and they should also be positive about it because most of our viewers are really looking forward to the E2 visa. So
I hear you. And I love the E2 visa. I don't care what country it's from. I'm happy to help any country. I've done some very interesting countries, E2s, and all the requirements are very similar, usually all the countries except for the UK. UK requires that you have physically lived in that country for 1 year before you file for your E2. Yep. And now it looks like Grenada and Portugal. These two countries, there's a way to become a citizen, and then you have to wait a certain amount. If you got it through a financial investment and you became a citizen, you have to wait a certain amount of time before you can apply for the E2. It's sometimes a 2-year waiting period or a 3-year waiting period, but that's another path in. If certain countries do not have E2 visa and you become a citizen of these countries, within a matter of a few years, you can apply for the E2. That's what some people do if they don't have a country that has E2 treaty. It's an unusual way to do it. You want to be a citizen of those countries, then go for it. You know,
all right, that's great, and I'm loving that. But Jessica, I really don't want to take a break, but I think it's almost 30 minutes, and we didn't
oh,
even realize that. So, friends, we are just taking a short break. That will be 2 to 3 minutes break, not more than that. So don't worry, we are not going to keep your wait for long. But till then, you keep on posting questions, keep on commenting, and ask as many questions as possible. And we are here definitely, and we will try our best to ask and as I mean to answer all the questions as possible. Till then, you can also look for the contact detail of our today's attorney, attorney Jessica Ways. The contact number is 888 and the email ID is jessicaw@waysIPlaw.com, and the website is www.attorneyjessicaways.com. So please go ahead, and you can also contact her, and you can let her know about your immigration journey, about your concern, what process you are going through, or what complexities you have. And I'm sure she is going to give you the best advice. So, with that, friends, don't go anywhere. We'll be right back. So, keep watching Immigration Talk Show. Hello, everyone, and welcome back once again to Immigration Talk Show. And now we are going to have a second segment of this episode. Till now, we have been going through a great discussion with none other than, I would say, wonderful and great attorney Jessica Weiss. And today, the topic that we are discussing is very important. What should investors know about the E2 visa changes in 2025? So till now, we have gone through a lots of information. What will be the future under Trump's administration? Then, what are the key requirements? How the investor should invest? What are the key pointers? And also about minimum money. So till now, we have gone through a lots of information, and now I think let's pick up our viewers' question. But with that, Jessica, before diving into our comments, I would just like to ask one more question because I think that is very important to answer. And that is, what are some common problems that investors face when they apply for the E2 visa?
Okay, so some of the common problems I would say is that the investment amount is too small. You have to watch that. That they don't have the hired workers properly. So, meaning like if they have one full time worker, they don't have any plans to hire another worker. That's a problem. That there needs to be a role for them and need to clearly have a role, and it cannot be hands on. So, if you own an ice cream shop and you say, I'm going to be scooping the ice cream at the interview, that's a problem. They have to understand they are CEO, they're overseeing the operations, and they have to make that clear. In terms of, I would say during due diligence, the whole due diligence process while they're buying an existing business, a lot of them don't have the financial background. So they rely on a business lawyer to help them understand, but they have to make sure it's a legit company they're buying. On paper, everything can look legit. Some of my clients literally like park their car outside the business and see what the foot traffic is like and stuff. Because this is something I always tell them, buy a business you like and buy a business that you think is going to last, because we need this to last. Because as long as you're here in your E2, you've got to keep your business going. And they joke around, people say that E2 is like the retirement visa, because you could buy it, you could be 70, 80 years old, and you could buy an E2 business, but you know what? You still have to take care of it. But a 70-year-old can check on their business on a regular basis, and they do. And so it is like the retirement kind of E2 business, because snowbirds want to come here and eventually they love it here. And so I'm in Florida, so snowbirds. So eventually they love it here and they're like, how can we stay here longer? So that's buy business, and they run it, for the rest of their lives, or they turn it into, they find it somehow switching into a green card. And I know we didn't talk about that really too much, but there are ways to go from E2 to green card and not just EB5. I do that. A lot of my clients, we go other ways to come here. It is possible. And I get that question a lot. Like, okay, now I'm here on an E2. How do I stay here long term? And I tell them, as soon as you get in here, let's talk, because let's set it up the right way so you can have, a long, long time in this country. So.
All right. Okay. So I think we have come across with lots of questions. And
Great.
I can see, Jessica, we got really a great amount of engagement here. Vihan, Trizer, then Arpita, Vihan. I'm really confused whom to take first, but let's take up Vihan's question. Vihan is here asking, looking ahead to 2025, which industries or business sectors do you believe will be the most attractive for E2 visa investors, considering the potential changes? Yeah.
Restaurants are coming back. During COVID, it was very difficult. E2 companies really suffered, but they're back. Restaurants are back, salons are back. A lot of the services that people need to go into to get those services, they're all coming back. I find even a simple coffee shop does very well for an E2. You have two workers, a certain amount of income coming in. So that whole industry, restaurants, I think very nice for an E2, and can slide you sometimes very nicely into an EB5 too, a green card. I would say other areas, I think real estate will come back, not flipping houses, but could be all sorts of things related to real estate. It could be property management companies. It could be any kind of renovation business, like window wiping business. All those areas that are related to real estate can come back too nicely. And it could be something completely like, who would think like a dog grooming business? Well, there's never a shortage of dogs. So those kind of like narrow, even newspaper, like, I don't know, some people have newspaper routes and stuff, and that, like, we get creative. The point is, like, there are certain industries that, yes, I think will be more popular now, because now that COVID's long gone, they will be better. But we don't care what industry it is. Like, we'll try to help you. If you have a dream, I always tell people, if you have a dream and you want to make a business in the United States, let's help you, because I want you to buy something you like. I have clients call me up, they're desperate, just find me anything, whatever. I'm like, no, you really should find something you like because you're going to spend your time building it. So
Absolutely, that's very well said. Thank you so much, Jessica, for putting up this very interesting, I would say, information. And Vihan also, thank you so much for putting up this question. In case if you have any follow-up question or would like to know more from Jessica, then please go ahead and ask those questions. Santosh is here, and Santosh is asking, are there any expected changes to the process for renewing or extending an E2 visa? For example, will there be more leniency or stricter evaluation process after 2025?
So there's two ways, as you can see here, renewing or extending, you said. If you do what's called a renewal of your E2 in the United States, you get 2 years to stay here. Those cases, I believe, are scrutinized more, and you don't get a chance for an interview. But there are situations where people just want to renew here and they don't want to go to a consulate to get another E2 visa. So when you have that, they're going to scrutinize them, and they could scrutinize them more, meaning they're going to look at, tell me about your gross sales. Let me see your tax returns the last few years. Were they positive? Do you have a positive net income? Do you have 2 full-time employees? Did you have a gap and you didn't have 2 full-time employees? Why do you have a gap? So these things are going to get scrutinized, I believe, more if you do it as a renewal in the United States. In terms of going to a consulate, again, it's so based on what officer is interviewing you, right? So you could have an officer that knows their stuff and knows exactly what to ask you, and one that's clueless, and you're just like, why are they asking me this? My attorney prepared me, and it makes no sense, but they have the power. So they have the power. They can ask you whatever within the requirements of an E2 to evaluate it for the strength of it. But I think the E2 visa interview is your chance to address any questions, any concerns they have. And I think, will they scrutinize it more? I would say the general trend is right now that everything's getting scrutinized more, but I don't see it to the point that it makes it so difficult. E2 visas overall, it's very, it could be 80, 90%, like a huge number get approved. It's a very high number of the approval rate for E2 visas because we don't file them unless we think you have a very good shot at it. We're not going to waste everybody's time and everybody's money. So that's where I see, will there be more leniency? I don't see leniency. No, I don't think we're going in that direction. But I don't see it's an impossible situation. But I do think consulate processing still is a little bit easier than doing a chain extension of status in the US.
All right, all right. Okay. Thank you so much, Santosh, for putting that question out. And let's move ahead with Ananya's comment. Hi, Ananya. Thank you so much for being here and participating. Ananya is asking, with the potential changes in the E2 visa policy in 2025, do you anticipate that there will be variations in eligibility for investors from certain countries?
So, as I work mostly with Canadians, or at least half my clients are Canadian, when I saw in the news all the things with the tariffs and restrictions, and I thought, oh, I wonder if they'd stop their treaty. I still think they're very close, and I don't see that happening. I mean, don't quote me, whatever. But where do I anticipate any variations or changes? It's really, the regulations are codified and there's certain set criteria. So if a consulate wants to be more specific, like the UK is like, okay, we have a 1-year physical presence requirement in the country, consulates can do that. But the overall requirements, I don't see that there's going to be a lot of variation. Even in countries, I've done E2s in so many different countries, it's the same criteria and it hasn't changed. I could just see maybe like what happened in France. Like a country says, no, we don't want 5-year visa anymore, with America. So they change that. So some of the terms of the agreements, the amount of visa, also the filing fees can change. They could increase them. You could have a larger filing fee when you apply for an E2 visa in certain countries. So some of that stuff, but not the basic criteria. No, I don't see that. I don't see changes in that.
All right. I think that's a good thing. If not, the basic things are being changed.
It is, because it's a great way to come here, and people they think, oh, it's $1,050,000. It's not. They get confused because EB5 is the $1,050,000. E2 is tiny, it's way tinier. And even though $100,000 is a lot of money for people where they make so little per year, 100,000 is a very big figure. So, but it's not, you don't have to hit the 100,000 for an E2. You just has to be. It makes sense. What you've invested makes sense for what you need to run your business.
Absolutely. And that's the main important thing that everyone is noticing.
Yeah.
All right. And okay, so here's another question from Ananya, that are some countries expected to benefit more than others from these changes? All right. Okay.
Well, see, there aren't a lot of changes taking place, except some of these to not have to have the interview for the E2 visa, that it was waived. So certain countries, then things would process a lot faster. So now, if they have to have interviews all the time, every time you want another E2 visa, certain countries, the E2 visa is not 5 years. Sometimes it's 6 months. Sometimes it's 1 year. So you have to, every time you want to come to America, you can come in, you get your 2 year stay, but when you leave, if your visa is finished, you got to go get another visa. So some of these countries, they don't qualify for a waiver of the interview for the E2, it's going to get backlogged. Do I know all the countries this is going to happen to? No, I don't know precisely which ones, but it could cause some delay in some of these countries. But there's always expedite request. If you need it, if there's a real emergency, you can try to approach the consulate and ask for an expedite. And it's up to them.
Absolutely, I'm sure. All right, the contact details are on the, I would say, the end of this bar you can see. And with that, thank you so much, Ananya, for putting up this very important question. And let's take up Raghav's comment here. So Raghav is asking about, can you explain how the revised E2 visa requirements will impact the duration of the visa and the possibility of renewal or extension for investors?
Well, there aren't a lot of revised E2 visa requirements other than the waiver interview has changed. That just changed. The impact of it, well, right now, some of these consulates, it's 2 or 3 months, right? They have to review the file. They take like 2 months to review it, and then they schedule you for the interview. So will it get worse? So then they could take longer. Some consulates could take 4 or 5 months, so it could cause a delay in that sense. In terms of it says extension. So extension's different because that's in the United States if you're extending the E2. So when you extend the E2, what are any of the revised changes or anything? Well, again, if they're going to see that you have employees and there are very few Americans that you hired, they could come down tough and say, please explain your strategy for hiring more American workers. We'd like to hear it. So we don't know how that's going to filter in to the cases in the queue or the ones that are just going to get filed. What we do know is that if you have strong gross sales, usually if it's a small company, we see a couple $100,000 in gross sales. We see a net income with, even if it's 10,000, it's a positive net income. And we see over the financial statements look good. You should be okay. You should be okay for your extension. And we tell them, you got to work on it. I have clients that they have problems, that their financials don't look right, and it comes time for the E2 visa renewal. So what we tell them is, if you have a 5-year visa and you have, let's say, 6 months left on it, we tell them, leave the country, re-enter. That gives you another 2 years to stay here. Because every time you leave and re-enter, you can stay another 2 years. Yeah. So the E2 visa, although it's going to expire while you're in this country, you still get to stay another 2 years, which gives you maybe another 2 tax returns possibly to fix the problem. Because if they can see that your most recent tax returns look good, then that's what helps get you that extension or the renewal. And so that's what we tell them. We have to strategize sometimes so that they can have the strongest case. And sometimes we can't. Sometimes we just tell them, it's a mess. Your E2 is a mess. You're not going to get a renewal or an extension. It's time to close up shop and do something else. And if we can transfer any of the assets and they start another E2, we try to help them with that too. Because we don't want to give them a dead end. We want to find a way for them to stay here. That's what they want. That's our goal. The worst thing an immigration lawyer has to do is say, I'm sorry, there's nothing I can do. Please leave. You have to leave the country. That's the worst. If we have to say that, it's like, it's so sad. I spend all day, because I do all different types of cases, marriage cases, telling people, okay, you're getting married, congratulations. I have to tell a guy, fly to Vegas to get your marriage certificate faster than whatever. I tell people all the time, leave, stay, when are you getting married? Are you buying this business? These are critical things for people's lives, but we do it because we want to make the best case for them.
Absolutely, that's beautiful. Thank you so much, Jessica. For putting these very important pointers, and that too in a very positive way. Our viewers are really filled with lots of positiveness, and because they learn about two visas, and
it's a stressful time for me, so I'm glad that I can give that positive over because our field. I just attended an immigration conference last week. There were 2 classes on happiness. And I'm thinking, what do you need to give us happiness classes for? But our field is so stressful because we want to help everybody. And the Trump administration has so many laws and executive orders and things coming our way that we just have to digest it all and just try to do the best we can. We have clients, yes, we have to tell them it's over. There's so many things going on right now in our field. But we try to give positive. Positive is that E2 is still a great way to come here. That's the positive.
That's great. All right. Thank you so much, Jessica, for putting that up. And Raghav also, I hope you got your answer. In case if you still have any follow-up question, then please go ahead, and we are definitely going to answer that. Arpita is here. Arpita has another very good question: that what is the potential for increased scrutiny in E2 visa application due to the 2025 changes, and how can investors navigate these challenges?
So we are like a surgeon. We go at the case like everything that there is a gap or something that doesn't seem right, we're like, fill that gap in. Okay. So we start with, where did the money come from? Tell us all the sources. One
Mhm.
guy says, "Oh, I didn't have to pay taxes on it." I said, "Give me an accountant letter explaining why there was no taxes required, because immigration doesn't know your tax laws and how they work." Then the money's transferred. We show the proof of that transfer. We explain where it came from. We have them sign a detailed statement of the source of the funds. We deal with every issue of the E2 case as precisely like a surgeon as we can, so we can leave no gaps. And that is what we're doing more than ever. That's one of our bigger changes, is that we always filed strong cases. We did our best. But based on my experience and what I know now, when my clients give me feedback after interviews and things, this is what we have to do now. We have to make it even more precise. We don't want a client coming back and saying, "We hired you, you had all this experience, and what happened?" We're like, "No, we're covering." And even when a client pushes back and says, "I gave you enough stuff, why are you asking for more?" We tell them it's 2025. Trump's our president. We have to be even more precise. So that's what it's done. That's what 2025 will be more about. A lot more precision than what we do.
Right. All right. That's great. Okay, thank you, Arpita, for asking the question and participating in our webinar. Pooja is here with another question: that what are the most common challenges that investors face when applying for the E2 visa? And with the anticipated changes in 2025, do you foresee any new obstacles for applicants?
So obstacles is something that's negative. I want to say E2s are there's a path. There's a way to come here. There are great opportunities to come here. So I wouldn't say I foresee obstacles. I foresee opportunities. There really are opportunities. I mean, I have clients that search and search and search for businesses, can't find anything that exists, and they're like, "That's it, I'm creating my own." That's an opportunity. They're creating their own business. And then we talk about how being very precise of all the things that we need, and they have to get their funds in order. But sometimes they'll contact me like a year before they even start the E2, because they just want to make contact with an immigration lawyer before they start the whole process. They want to understand, what are the challenges, what are some things I need to be aware of. Like, I'll have a client call me up and say, "Well, I have $100,000 and I gave it to my friend in the United States and he's going to put it into the business." And I'm like, "That's not how you do it. It has to be in your name, and the transfer has to be from you. You can't just give it to a friend for an E2." So they'll call me if they made a mistake, and I'll be like, "You should have contacted me 6 months ago." I've had clients have to redo deals because they don't set them up right. I've had a client that said, "Look, it's $1 million. I'm going to put 200,000 down. I'm going to do a seller carryback note for the other 800,000." I said, "Well, look, it's not really going to work, because substantial investment, they look at what it costs to run the business. But tell me about the business." So he says, "Well, it's really a building. I'm buying a building, and the active part of the business is really 200,000. 800,000 is the building." So I told him, "You know what? Break it up. Have a contract for the building, 800,000, and pay 200,000 and buy the active part of the business. That's your E2." And that's how we do it. Because otherwise it makes no sense. You can't really do not like you securing a loan from the business that you're buying, because they're afraid they give you the visa. And then all of a sudden you're like, "Oh, company didn't work out, but oh, I still have the visa." They don't like that. So.
Absolutely. And I think those are, very important guidance that our viewers should really know about, because just for the sake of friendship, they are being into such a big obstacle. But I think that's not how it should work. So I'm sure that these pointers are really being going to helpful for them.
Sam,
So
I
yeah.
would just tell you one other thing also, that I feel like sometimes people are discouraged because they need it to fit into a precise box in order to work for an E2. But we don't do it that way. We look and we see what you've got and what you want to build and what's going on right now. We try to make it work if we can. We
Yeah.
try, because they bring us their dream businesses, and we're like, if we can make it work, we'll try.
Mhm. All right. Okay. Let's move ahead with another question that I got from Vihan. Vihan is here asking, what are the specific legal and financial risks that investors need to consider with the revised E2 visa guidelines in 2025, especially if the investment does not meet expected returns?
So on your business plan, you have the projections. In 6 months, what you're hoping to get from the business, in 1 year, 3 and 5 years. They do not lock you into those projections. Those are just rough estimates. So if you can't bring in what you thought you'd bring in, they're not looking at your case every year. Only when you do your E2 visa renewal or you do your extension of E2 status. And then they're not going to say, by the way, you said in year 3 you were going to make this kind of money. So what happened? Case denied. It's not like that. Those are just projections. What's really important is they want to see, do you have enough money to pay your bills? And let's say you don't. Let's say 1 year you don't have enough money. So let's say you're a wealthy individual and you're going to put more of your money in to help the business grow. Well, you're going to have to explain that. If it comes time for the renewal or the E2 extension, you're going to have to explain, look, I had difficulty. It could be an industry that suffered, or you could have been, let's say it was a hurricane or something happened and it's explainable why your business suffered. Then you can explain that when you file your case. And usually with a valid explanation and to show the potential for growth that you're coming out of that rut, you should be okay. So it's just very case specific. If there's really financial loss or risk and what happened, we have to explain it.
All right. Okay. I think let's take Trizer question here. And Trizer is asking that, hi, I have a business partner. We are in the process of starting an offshore IT and production studio. Now, during the E2 application, which should we focus on as a company works on both aspects?
So I will just wonder where this business is located. Okay. Because if it's offshore and they also have a production studio. So I'm wondering if the production studio, I assume it's in the United States. So this is where we talk about how much time does the person physically as the investor need to be here. We want to make sure we build something here that they have to come and check on regularly. Otherwise, it becomes everything so remote, it doesn't work. But the focus should be on the sales, the clients, the employees that they have. That's to build it up. That's what I would say. And make sure that there's enough activity going on in the US. It's not all offshore.
All right. Trizer, you could let us know from which location you would like to have a business on, so that we can give you a better advice on that. Next, I would like to go with Srujit's comment. Okay, and Trizer here also had a comment that your show popped up on my feed. Found it interesting.
I tried.
It's really interesting. Okay, we are based in India.
Oh, India. Okay, yeah. So that's pretty far. Okay, so he just needs to, the production studio, I assume it's in the US? That's why he's wanting to come here. And by the way, this is all about E2, but don't forget there's something called E1. So if he has a majority of the trade or services are between the US and their home country that they're providing, then that could be an E1. And majority means substantial, means at least for 1 year, there's been trade or services. And substantial is usually $150,000, $200,000 in sales, but it could be anything. It could be services like IT services. It could be trade, it could be a product that's made in, let's say, India, and they're selling it. Majority of their sales worldwide are with the United States, and they're substantial. That's E1. I didn't say anything about the amount of investment. There was no substantial investment. It is an easier way to come here actually than an E2, but you have to fit the box. It doesn't always fit for people. So it's out there though, E1. And we have to have a treaty, of course. So
that's right. All right, Trizer, I hope you got your answer. And in case if you still have any follow-up, then please let us know. Meanwhile, Jessica, we also have some questions from our Facebook group as well, because there also we have a lots of viewers over there. So I think let's take some questions from there as well. So here's another question: that can we travel on B1, B2 if we have applied for EB2? Any issue in it?
Okay, so EB2, employment-based, that's the second preference. So that's green card application. So B1, B2 is temporary. That's a way to come here as a business or a visitor. So the question is, what ties do you have in your home country? And when you're coming in as a visitor, does an officer who's seeing you when you enter America, does CBP really believe you're going to return? So just having an application in the system doesn't mean you can't come in on a B1, B2. But if the officer sees it and feels you don't have enough ties to return to your home country, then they don't have to let you in. So we do entry packets. We put together a whole packet showing what your ties are there, what you're doing here, and then we prepare you. So hopefully you can get in, because the process can take a lot of time. It can take several years before you actually get the green card.
Yeah, that's right. Okay, let's go ahead with the next question. Hi, I'm an E2 dependent spouse, currently pregnant, due on March. Will the birthright citizenship removal take effect that soon, or will it be on hold due to 22 state lawsuits contradicting it?
It's on hold. They're waiting right now. It's being litigated. So I don't know what's going to happen. We don't know if it'll
Mhm.
take effect. Yep, stay tuned. But anyway, March is pretty soon. So it's on hold. So having that baby in March, it sounds like you'll be okay, but who knows what if the courts speed up the case or not. But yeah, we don't
Mhm.
know.
Absolutely. Let's see what comes at the end decision, and we all are hoping for the best. All right, let's move ahead with the next comment.
It's the same thing, the birthright issue, right? It's a problem. Non-immigrants who have kids born here, this
Mhm.
is what it's about. They don't want to give them citizenship. Trump doesn't want them to have automatic citizenship. So yes, they are affected by this if the rule goes into effect. And then there was going to be a procedure. There should be something in place of how they turn into an E2 dependent, right? Because if the kids were born here right now, they're probably not E2 dependents. So there has to be some procedure in place to get them the proper paperwork.
That's right. Okay. I think we got this another question. And Control, if you could let us know about that question, please. Okay. I think we might have. Okay, I think Jessica, there might be some technical issue regarding the FB questions, but not to
Oh,
worry. We do have still a lot of questions, from our viewers. And okay, let's take up one or two questions lastly, and then okay, here we have Yash question. How will the 2025 E2 visa changes affect the ability of foreign investors to hire employees from abroad, especially from their home country? And are there additional steps they must take for this?
so I think that they're referring to the E2 qualifying employees, right? So you can be an essential worker, you can be a manager executive. So the criteria, again, everything will be scrutinized. We need to be more precise, but same criteria. You have to have the same citizenship as the E2 investor. You have to be coming here to work in a capacity as a manager executive or someone with specialized knowledge and skill. And you have to show that you have that experience to do that. So, and then they issue you the visa. And depending on our treaty, how long that visa is valid for, and the dependent spouse can work while you're on your E2 qualifying employee visa. So, yeah, that's the process.
All right. Okay, next up, let's take up Kunal's question. Kunal is here asking, are there any new pathways or benefits for investors looking to transition from an E2 visa to a different permanent visa or green card options following the changes in 2025? Yeah.
It's a very interesting question because right now, the EB5 is the most popular way. And it was not the most popular way because it was such a long process. It was like 4 or 5 years. Now it's a 2-year process because if you're an E2 and you file the first part of your EB5, you can file the second part, which is called adjustment of status, together, which means you can apply for a work permit and travel document. The whole thing can be filed together. Some of these other categories, you can't do that. EB2, EB3, you can't do it all together if your priority date's not current, which it's not for these categories, but EB5 is for certain categories. So this is becoming popular. And what's also becoming popular is the regional centers. So regional center says you need to invest $800,000, not $1,050,000, and put your business anywhere you want. You invest in a regional center. So I asked one of my peers, I said, what if you don't have $800,000? And he says, you would be surprised that people either take equity from their house, they have relatives that are wealthy, they are gifted money from friends or whatever, and they make it happen because they want that EB5. And this right now, we see that EB5 is getting very popular. And I used to say EB3 was the way to go, but it's backlogged. And EB5 really is, even though it's a 2-year conditional green card you get, if you've invested the money, the regional center helps you create the required jobs, and then you have to remove the conditional status after 2 years. But people are doing it. They're finding ways to get that money. But that's what I see for 2025. EB5 is very popular.
Absolutely. That too. Thank you so much, Jessica, for taking all these questions very patiently and answering them in a very detailed way. So, again, I would say thank you so much. It's really appreciating. And I think, Jessica, we already crossed 1 hour. So, with your permission, I would just like to know, would you like to answer more questions or should we put an end to it?
I think a lot of the questions are a little bit similar, like because they want to know in 2025 what are the changes, how will it impact them, and I think we addressed a lot of them. So I
Yeah.
think that's good. I just want to share one other thing that I offer a free brief consult so people know to anyone who is thinking about doing an E2. It's usually 10 minutes or so, but it gives them a little bit of direction because a lot of lawyers just they get on the, they're going to have a consult, charge right away. But a lot of people just want to get some of the foundation. And also my website is very helpful. I made charts talk about the E2 process along with other processes, and it shows the steps and stuff involved in the requirements. And I think that's really helpful too. So if people are thinking about, okay, this E2 sounds interesting, that's where I would start. And they can always reach out to me. But I think for now the questions, because they're all a lot similar questions, that I think we've addressed, like what changes 2025 and how concerns and any financial concerns. And they just have to like find that right business and just call an immigration lawyer or me and you know just get started.
Of course, they will because I can see a lot of questions here, on our webinar, and because viewers are really loving this episode and they are having a lots of queries regarding that. But don't worry, friends, keep on posting as many questions as possible. We are definitely going to take them up, maybe if not in this session, in our next session. But with that, Jessica, thank you so much. We have come across 1 hour. We didn't even realize. So it was your first time with us, and it's not only me who enjoyed. I think everyone enjoyed this session a lot. So we are really honored that you are here. Thank you so much for taking up this time and investing it here. So we really enjoyed, and thank you so much for being here.
And thank you so much as well, because I love educating people. And without education, you cannot make the decisions. So
Yeah.
that's what I do. I give you all the information, and the client makes the decision what's the best for their family and their lives. So thank you very much.
That's lovely. We love the energy that you bring us in this show, and also the insights were that too very helpful and wonderful, I would say. So again, thank you so much, Jessica, for being here, and we are looking forward to have more shows with you.
Thank you.
All right. Thank you so much, everyone, for being here and asking a lot of questions. I'm sure if you guys are not very much happy that we didn't take your question, but don't worry. We have asked all the questions, and in the next show we are definitely going to take them up. So till then, don't forget to like, share, and subscribe to Immigration Talk Show. We'll be coming up with very exciting webinar, and that will be lined up just for you. So make sure to press the bell icon also so that you can get notification whenever we come live. Until then, everyone, take care. Don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. It's me, Sam, signing off for now. Goodbye, everyone, and take care.
Hello, everyone, and welcome to Immigration Talk Show. I'm Napasa, your host for today, and I'm happy to be back. So, welcome once again, friends. We have got a very interesting webinar lined up, and before I introduce you to our guest for today, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. With that said, friends, today we are going to have a very familiar face who has been a part of Immigration Talk Show for quite some time now. And he is an immigration attorney from Dallas, Texas, from SPB Law Firm. So without further ado, help me welcome attorney Chand Parvathaneni. Hi, Chand. How are you doing today?
Hello, Nipasa. How are you? Pretty good. And thank you for inviting me again on this show. Hopefully, we'll have a very good discussion today about some of the current topics on the immigration side as it pertains to the employment based immigration.
Absolutely. And it's the H-1B season, so nothing better than our topic of discussion for today. Yes, friends, today we're going to discuss about H-1B RFEs on the rise this year, 2025, and what it means for the March lottery. And of course, Chand is going to be here to answer to all of our questions, mine, yours, and you can participate in this webinar by commenting. So wherever you're watching us, you can put your questions in the comment or even join us on call. Actually, you can call us on this number 425-436-6335, and the access code is 988-888. There is 8 5 times, so 988-888. Join us and it'll be very nice. So Chand, what can folks out there expect from today's discussion on this topic today?
Sure. So we have a new administration since January, and a lot of things are changing because, again, anytime a new administration comes into office, because they do things a little bit differently. And right now, the Trump administration, they're kind of refining all the processes, not just in immigration, but across all the federal agencies. And what that means is we will see things a little bit different. And on top of it, the Biden administration, while they were leaving office in December, what they have done is they have changed some regulations. They came up with strengthening and modernizing H-1B regulations, and they came out with a final publication of a rule where things from January 18th, they got changed a little bit. So now we have these new regulations that the previous administration finalized that started in January. And then on top of it, we have a new administration where they're revamping and re-looking at their own processes. And what that means is we are seeing different kind of RFEs. We have started seeing new RFEs, new ways of USCIS adjudicating things. And on top of it, based on the current administration's priorities, we know that a few things will change. And we will use this opportunity to see today, discuss what is changing, what are the new kinds of trends we are seeing in terms of new requests for evidences for H-1Bs. And since the new H-1B lottery will start in about a few days, it's starting on March 7th. So we're just a few days away from March 7th. So we'll also talk about what people can expect once the lottery starts and once the lottery is over, what they can expect and how we can do things to make sure we are in compliance with the rules and regulations of USCIS. We are in compliance with the requirements, and people do things the right way. And by doing things efficiently, they can at least try to aim for an approval, because this process is pretty expensive. The whole application for H-1B, the employers have to spend a lot of money. They have to pay a lot of money to the government. And on top of it, the employers also have a burden of ensuring that they comply with a lot of federal regulations.
Right. And so, friends, thank you so much for joining us once again. You can follow us and don't forget to hit the bell icon. We are on YouTube and our handle is at Immigration Talk Show. So, yes, subscribe to us at Immigration Talk Show. Also, check us out on Facebook, LinkedIn, Instagram, and also on X. All right, so now let's not wait any further. So, my first question to you, Chand, is that there are so many reports out there saying and speaking about the increase in RFEs for H-1B petitions, especially this year. So, what do you think are the main reasons behind this trend?
Sure. So in the last 1 month, we definitely saw a little bit of uptick in increase in RFEs. I would not say that we are drastically seeing a huge increase, but I definitely can say that at least for the H-1B petitions, we are seeing new kind of RFEs, and we are seeing a little bit increase in the number of RFEs. And I think the primary reason for that is definitely the new H-1B rules that came into effect in January. So this stemmed from the final rule. the final rule where they published these regulations, uh, stating that they're strengthening and modernizing the H-1B regulations. And a part of these rules, what they've done is they're focusing more on the bona fide nature of the job. So in terms of focus on added focus on that, nowadays they're requesting for contracts. Now you have to show the contracts, you have to show the purchase orders, you have to show the content of the purchase orders, and client letters, vendor letters. So this new requirement, I think, is causing USCIS to issue new kind of RFPs. So they're coming back and saying that the old memo, the memo that got issued in 2020. So in the RFPs, they're stating that this memo has been rescinded, and now they are asking for some additional evidences. So that is where we are seeing some increase in RFPs. And then we're also seeing increased RFPs for proof of maintenance of status. So if a company has applied for a H-1B in the past and that same employee is getting filed for an extension, one of the things that USCIS will say is whether that employee has been maintaining his prior status. So there is a lot of focus on USCIS's side where they're actually looking and asking us to prove that the previous petition, the employee has followed the terms of that petition. And what that means is, if it's a transfer, the employee has to work with the previous employer. He has to have pay statements. He has to be in that particular role. Or if amendments are required, amendments have to be filed timely, and so on. So USCIS has been definitely scrutinizing what employee has done in the past. So before applying, so the previous H-1B petition, has the employee been working as required, and so on. So we are actually seeing a lot of scrutiny on that. And the reason for that is this new rule, the regulations that went into effect in January. They actually talk about ensuring that the employee has maintained his prior status. So that's also is contributing to this trend. And on top of that, the new administration, because of the new administration's way of looking at things. So again, they are looking at employer-employee relationship in a different manner. They're looking at wage level discrepancies in a different manner. If it's a wage level 1, so we are seeing an uptick in RFEs where USCIS is questioning the wage levels. And in general, because USCIS, as they kind of look at their own data, they want to prevent fraud. So there are increased fraud prevention measures, and a part of that, what USCIS does is they have something called VIBE check, validation instrument for business enterprises. So it's their database where they cross-reference employers' information. They look at their data. They look at the data that's coming out in the I-129. They want to make sure employer is legitimate, the number of employees, the revenue of the company, and so on. So they have their own internal database, a VIBE database. So they check against that database. So as a part of increased fraud prevention, we are seeing RFEs which specifically talk about VIBE, where they say that things don't match up, things don't line up. So they ask for more information. And so this is another reason why we are seeing a little bit more uptick in the number of RFEs. And then overall, I think I would say this whole H-1B modernization rule and the codification that went into effect in January. The USS officers, they're also having to look at this new modernization rule and look at things in a different manner. So initially what that means is, because even the officers are new to this rule, so sometimes the likelihood of RFEs increases, which I think is what has happened. And all these factors have contributed to the rise in RFEs in the last 1-2 months.
Exactly, and I think it was 17th of January, right? Many new updates started, and these new rules also apply. And the lottery is going to start up in about just a week or so. So there's a lot of
Yep.
changes and things that you have to keep in mind. So maybe you could give out a few tips, Chand, for folks out there who are going to participate in the lottery.
Sure. So again, the good thing about the lottery this year is it is beneficiary centric. And what that means is 2-3 years back, we had a lot of issues with multiple registrations. And multiple registrations means some companies are colluding together because the companies are owned by the same set of individuals or their relatives, and the companies are colluding together, and they're trying to increase the chances of somebody in the lottery. So that was giving some people unfair advantage. And what USCIS has done is they went back and forth. They changed the rules last year. So now it's a beneficiary centric process, and a beneficiary centric process means even if an employee has multiple legitimate job offers. Say Microsoft is filing for him, Google is filing for him, Apple is filing for him. Whether a person has one job offer, has multiple job offers, the chances are exactly the same. So this is a good thing. So what that means is, no matter how many job offers somebody has, the chances of getting selected in the lottery is exactly the same. And what that means is, it will definitely prevent fraud. It will definitely prevent collusion. So that's a good rule that went into effect last year. And after that rule went into effect last year, the number of registrations dropped dramatically. So they almost came down 50%. That's what happened last year. So that's a good thing for all the folks out there who are getting the registrations ready by their employers, because nobody's going to get any unfair advantage. So everybody is on the same level field, which is a good thing. The only drawback this year is the registration fee. Last year, the employers were paying $10. This year, the employers have to pay $215. So that's a big hit. So employers will have to pay a lot more for the registration this year. In a way, that's really bad, because some employers might be discouraged even if they have a good employee, because if the employee does not get picked up in the lottery, the employer will not get that money refunded. So the money is gone. So whether somebody gets selected in the lottery or not, that $215 that they have to pay to USCIS is gone. So for that reason, some employers might not really be willing to spend that money unless they know, hey, my employee is going to get selected in the lottery, and it's a good use of money. So for that reason, I do think that the number of registrations might come down. But the other side, the positive side, is that anybody who's just trying to register just because it is cheap, they will not register. So at least the good thing about $215 registration fee is, only if the employer is really serious, they know that the employee is highly qualified, they would not get them into the lottery. So there are positives and negatives about this new $215 rule. But in reality, what I think would happen is, you will definitely see a decrease in the number of registrations. Last year, because of the new rule, we already saw the decrease in registrations. But last year, I think it was a good rule because it eliminated the multiple registrations problem. This year, we have to wait and watch. But one thing I can say based on my discussions with our clients is, this year clients are going to, I mean, the employers are going to file only if they're really serious of that employee, because it's an expensive process this year compared to the $10 they were paying last year. And in terms of suggestion, employers, I think, should file only if they have a bona fide job offer. If they don't have a bona fide job offer, they should not be getting into the lottery, because it's an expensive process. And not only that, they're going to waste somebody else's slot. Number one. Number two, people have to make sure they have a valid passport. And not only that, they have to make sure they're entering the right passport, the right information. If there are any typographical mistakes like date of birth or passport number or anything, tomorrow USCIS could come back and cause a problem when you finally apply for the H1B. For this reason, people have to be very, very careful when they are doing the registration. Make sure the data is accurate, the passport number is accurate, the names are accurate. And if somebody's passport is not valid, has expired, or about to expire, make sure that you apply for a passport renewal right away, because for a lot of countries, there are ways to expedite passport. So people can, if somebody's passport is expiring, there are ways where somebody can quickly get a passport. Like, for example, in India, there is Tatkal. So people can get a passport in about a week. So anybody whose passport has already expired or is about to expire, it's a good time, well ahead of the lottery deadline, they should go ahead and get their passports renewed. And one final advice is, there is something called master's quota and regular quota when they apply for H1B registration. People have to be cautious. And if somebody marks it inaccurately, they make a mistake and they put somebody's quota as master's quota when they don't qualify for master's quota, that H1B registration will be invalidated. So always make sure that if somebody is getting put in the master's quota, verify the name of the university, make sure the graduation date, and so on, before putting somebody in the master's quota. Okay. So again, the registration part is pretty simple. Again, if things are, the data is accurately input, it's a very simple process. And before March 31st, the lottery selection will be done. And then the actual filings will start.
Very, yes, thank you so much for those wonderful tips, Chand. And I'm sure that folks out there are liking all these tips, since, H1B lottery is really knocking at the door, almost the season now. And talking about the fees, $215, it's a huge hike. 200% almost or more. So, what do you think is going to happen with the money, that US is going to accumulate with this? I mean, the registration process.
Sure. So USCIS is a self-funded agency, and what that means is they're not really relying on the government for the funds. They are self-funded. So basically, they generate their own revenue and they use it for immigration purposes. So what that means is, again, the money is not going into private hands. It's going back to USCIS. So hopefully that money is required to be spent for USCIS purposes. And what that means is they use it for hiring, they use it for making the processes more faster, more efficient, and so on. So normally when we hear about any government shutdowns, typically USCIS is not impacted because they have money. So the $200, it's a huge money, and hopefully USCIS will use that money to refine their processes and make things a lot more smoother for others. But again, even if they get 200,000 applications, which I think they will definitely get this year, because last year they got 400,000 registrations. So 400,000 registrations at $10 for each registration, that's equal to about $4 million. This year, $215 times the number of registrations. So it'll be a couple of millions of dollars. It's a huge amount that USCIS will be getting, but hopefully that money is being spent for modernizing their computer systems, making things more efficient, which is what eventually will happen with that money.
Absolutely. Thank you so much, Chant, for taking that up. And, at this moment, I would just like to say hello to all our folks who have joined us with their questions as well. And also everybody out there who are watching us. Thank you so much for joining us on Immigration Talk Show. Please don't forget to subscribe to us if you haven't as yet already. And our handle is at Immigration Talk Show on YouTube. We are also on LinkedIn, Facebook, X, and on Instagram. So check us out, follow us, connect with us. All right, so hi to Nandini, Rag. Rag says hello, Nipasa and Chand. Hello, Rag, one of our very frequent viewers. Always good to have you. So, Rag, if you have any questions, also please feel free to comment. Also, hello to Geeta, Reddy, Abha. We are going to take up your questions. Please stay with us. All right. So now, Chand, my next question to you is, you know, there are probably certain job categories or industries who are seeing a higher rate of RFEs compared to that of others. So, if so, why is it like that?
Sure. So when we talk about H1Bs, the majority of the H1Bs go to the IT and the tech industry because the tech jobs are or who use the H1Bs on a large scale. So when we talk about just the numbers in general, normally the IT and tech industry is where we typically could see more RFEs. The other industries that use a lot of H1Bs are nowadays a lot of the pharmaceutical industry, the semiconductor industry, healthcare industries. They're also using a lot of H1Bs. And normally, my uh, experience is healthcare occupations typically have very, very low rate of RFEs. And the reason for that is since COVID, I think the general consensus has been that healthcare is pretty, pretty important. And USCIS normally they tend to do healthcare petitions a little bit quickly, and healthcare I typically don't see issues. And after COVID, a lot of focus has come down to bringing industries back to US, which means the pharma industry and the chips, the semiconductor industry. So we're seeing a lot of jobs come back to US, at least a lot of validation engineering, the pharma jobs, and the semiconductor, those kind of jobs coming back into US. Those also we typically don't see a lot of RFEs in general. And even within the tech industry, if it's a staffing kind of a company where you have an end client, so basically you have a situation where employee is an employee of a certain company, and through a vendor they're working for another end client, and the end client is somebody else. So those are the kind of areas where we tend to see a lot more RFEs. And I mean, again, historically, anytime you have a consulting or a staffing kind of an arrangement, they definitely face higher volume of RFEs. And the reason for that is for the last 15-20 years, always USCIS goes back and forth with this employer-employee relationship. If somebody is a full-time employee, the employer-employee relationship is pretty easy, very easy to establish. But when you have this situation where you have in the consulting world and the staffing world where somebody is working at the end client, the employer-employee relationship is a little bit difficult to establish, because who's giving the direction for somebody's work, who is directing and supervising somebody's work, and so on. It becomes a little bit hard. And then in 2020, we had a lawsuit, and USCIS came out with this memo. And ever since, employer-employee relationship became a little bit easy. But again, in the new modernizing rule, again, things are a little bit different, because that old memo was rescinded. And what that means is consulting and staffing companies can anticipate RFEs even going into the future. And again, the lesser used industries like education positions, research positions, a lot of universities use research positions, creative positions. So those kind of fields, I do think that we will not be seeing a lot of RFEs. And staffing kind of roles, and even within the staffing roles, so there is something called own it. So every H1B that gets filed, you have to map it to an own it occupation, you have to map it to an own it code, you have to also give the wage level. Normally what happens is, when the wage levels are low, or some particular occupation, some particular own it occupations who don't really have a bachelor's requirement, when you look at the occupational outlook handbook and look at their requirements, those are the ones you typically will always see a lot of RFEs, because specialty occupation is something you have to prove on every H1B petition. And some own it codes, by the nature of their data, by the nature of their occupation and how it is in the occupational outlook handbook, the USS will routinely come back and say that is not a specialty occupation. Okay, so high level, some industries are always a target, and even within the industry, some own it codes are always going to be problematic.
Okay, Chand. Thank you so much for taking that up as well. And I think we should take up a few questions from our audience right now so that they do not wait too long. So let's take up Nandini's one. Nandini is asking, I have an IT consultancy offering me an H1B, but I heard that USCIS is increasing RFEs for third party placements. How can I prove that I have a valid employer employee relationship for the entire duration of my visa?
Sure. And so again, ever since we have this H1B modernization rule in January, so the way USCIS is looking at third party placements has changed a little bit. So they even modified the I-129 form. So now you have to actually put the end client name and a few things about end client on the I-129 itself. So this is a new thing, and it was not there prior to January 18th. And how do you prove? So again, because we have done a lot of filings in the last 1 month, and what we are seeing is, so the way you would prove the employer-employee relationship is, you have to initially prove what your assignment is. And what that means is, if it's a third party assignment, like in your case, you have to produce the purchase order, you have to produce the statement of work, or you have to produce the vendor letters, or you have to produce the client letters. One of these documents. I mean, again, USCIS does not say this is mandatory or that is mandatory. It is the company that has to prove the bona fide nature of their assignment. And if they're able to establish the nature of their assignment, USCIS does not have a problem, because staffing is allowed, consulting is allowed. And the purchase order, even if it is not for 3 years, because it's very hard for every employer to have a 3-year purchase order. So even if it's a short-term purchase order, at this point of time, we are not seeing any issues with USCIS. However, what USCIS wants is, do you have an assignment on the day of filing? Whether it's a 6-month assignment or a 1-year assignment, as per the purchase order, that's okay. But you do have to prove that on the day of your filing, you do have a valid bona fide assignment with a third party, with the end client. And how do you prove it? The easiest way is the company will sign a purchase order or a contract with somebody, and you use that to prove that you have a valid assignment. And if you're able to show that, we are not normally seeing any issue. So if somebody comes to us and say we don't have any contract, but we want to place somebody on a project after we do the filing, that cannot be done. On the day of filing itself, you need to have a bona fide assignment, which means on the day of filing, you need to have the contract signed. So if that is the case, in general, you should not have any problem with employer-employee relationship, even in the current new rules.
Okay. Thank you so much, Chand, for taking that up. And Nandini, I hope you've gotten your answer. Thank you for participating. Now, next up, we got Geeta Reddy asking, I heard USCIS is scrutinizing specialty occupation criteria more than ever. So my H1B job title is Market Research Analyst, and I have an MBA in marketing. Could this raise red flags, and how do I prepare for potential RFE?
Sure. So, market research analyst, that particular ONET code, historically it had a lot of problems. And if you Google, you'll see a couple of lawsuits filed for USCIS denials on marketing research and analyst positions. And in 2000, I think it was like 2020 or 2019. So there was a lawsuit where the court said market research and analyst. I mean, it is definitely a specialty occupation position, and in general, it is prone to RFEs. But again, we are not seeing challenges in the last couple of years if the duties require a bachelor's degree. So again, in your case, you said you have a degree in marketing. Your position is market research analyst, and if you look at ONET, market research analyst on an entry level also requires a bachelor's degree in a specific field. So more than likely you'll be fine. But historically, we did have challenges with that occupation previously, a couple of years back. So even now, as long as the job duties are detailed and there is a nexus between your degree, your qualifications, and the job duties, and the job duties do require a bachelor's degree or above, and in your case you have a master's degree with focus in marketing, so more than likely you should be good. And this is a field that is prone to RFAs, but again, if you're able to prove, you should not have any issues.
Okay, thank you so much for taking that up for Geeta. Geeta, thank you for participating. And well, Rag is also here with a question. So, Rag is asking, with the current state of RFEs, will it be better to go for a blanket L1A instead of the individual N1A, provided the company is eligible for both?
I mean, I would go with individual L1A rather than a blanket L1. The reason is, if you go with an individual L1A, if you get an approval and everything looks good, tomorrow, normally what companies do is the companies explore the EB1C option. So I would say, if the company has a blanket L1 and you're also qualified for individual L1A, L1 can be done in premium. So to me, it's always worth taking that extra effort and trying for an individual L1A, because if you get an approval for L1A, you're able to prove, you're basically proving that you're a manager on the offshore entity side. You're coming here to work as a manager on the US entity side, and tomorrow you use that to explore EB1C options. And EB1C option is a great option to explore. Not a lot of people qualify. So when you have the chance, I would always say that, like, maybe you should take the harder route, look for the individual L1A. The good thing is it's possible to do it in premium. So you'll get a quick answer. And if the company has L1s, blanket L1s, I'm pretty positive that the company is a huge company. It's a big company. So based on your role, definitely, I think I would say try for L1A, and if you get through, EB1C becomes a great option for you.
Thank you. And Rag, thank you for participating as well. I hope you got your answer. And next question, this is from Abha. Somebody with family preference AOS already filed. Can their employer apply for H1B? Things that need to be kept in mind given the pending AOS. And when you say staffing companies and consultancies, does it also include consulting companies like EY, McKinsey, etc.?
Yeah, yes, technically, even they are consulting companies, and in the past, before 2020, even they had denials for H1. And if you look at, like, just Google Infosys or TCS, Infosys got a huge penalty, I think, last year for immigration. TCS, I think there is an issue about TCS. Recently, I think it's in news about some issue that they had with immigration. So even big consulting companies could run into issues. That being said, it's not about uh, the consulting company or not. In general, whenever you have a consulting company and you're saying that your employee will work at a third party location, the rules are a little bit different. The analysis is a little bit different. So, a small company, I have seen lots of small companies with one or two employees not have any problems with their H1B. Sometimes big companies could have a problem, or big companies might not have a problem. So the whole thing is, it is what exactly is the assignment. So the big companies, if they're able to prove the assignment, they'll not have a problem. And even if it's a big company, if they're not able to prove what that assignment is, they will have a problem. So, but again, in general, whenever you say it's a third party kind of an arrangement, in the new rules, in the new I-129, they are actually asking for that information on the I-129. And what that means is whenever they see that it's a third party kind of an arrangement, the analysis will be a little bit different. But again, if it's a big company like E&Y, McKinsey, normally they have a valid assignment, they have valid bona fide assignment. So it's a lot easier for them to prove when you're a big company. But again, in terms of USCIS officer looking at things, yes, even big companies get RFEs. Even again, it's just a part of their job. So every case is different, and the occupation for the case is different. The salary they're providing for that case is different. So all these things will contribute to the H1B. And going back to the other question, so you have a pending AOS. Pending AOS means based on your family relationship, somebody has filed for a green card. You can always pursue a H1B even if you have a pending AOS. So even if you have a pending green card application, H1B is a dual intent visa. So you can have employment based H1B non-immigrant visa processed simultaneously along with the pending family AOS. It's completely legal. And what I advise is it's always better to maintain your own status until that other AOS application gets approved. Because if something were to happen to that AOS, H1B is your backup. So legally, you can pursue both. So you can stay on H1B while the pending AOS application is in progress. The only thing is, if you're on H1B, you have to make sure you're following the terms of H1B, which means you are working as required, you're getting paid as required, you're staying in the same metro where you're working. So all these requirements about H1B. So as long as you maintain valid H1B status, you comply with the rules of H1B. Having a pending AOS will not cause you any problem, and it's actually a good idea. If you have a pending AOS, pursue it in a legal way, and be on H1B until that case is approved.
Okay. Thank you so much, Chant, for taking that up for Abha. And right now, I think I would say that we should go for a short break. But we also have Sanjay who has joined us with his questions. Sanjay, stay with us. We will take up your questions after the break. And Chant, I also have some more questions from my end. So for now, we'll just go for a short break and be back on Immigration Talk Show. Folks out there, don't go anywhere. Stay with us. It's Napasa and Chant. Hello and welcome back, everyone, to Immigration Talk Show. I'm Napasa, and today we have a very interesting webinar with none other than Attorney Chand Parvathaneni from SPP Law Firm, Dallas, Texas, and we are discussing about H1B and the most common RFEs this year. And he's also giving out tips on how can we prepare ourselves for this upcoming lottery, the March lottery. So thank you so much, Chand. It's been great so far. And also folks out there for joining us, Abha, and we got Rag, Geeta and Nandini. And also, let me tell you that if you're enjoying this session, do not forget to subscribe to us. Our handle is at Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, and also on Instagram. Do check us out. And also, if you want to contact Attorney Chand Parvathaneni directly, have a one on one consultation, maybe have him guide you for your H1B this year, call him on this number 817-523-8247, and you can also email him at law@spblawfirm.com, and do go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni. So, also, friends, you can join us on call. Why don't you call us? I mean, Appa or even Rag, maybe even anybody out there who's watching us. Why don't you join us on call to ask your questions yourself? 425-436-6335. That's the number. And when they ask for the access code, dial in 988-888. Okay, so I was saying after the break, I'm going to take up Sanjay's question. Sanjay is asking, I work in STEM field, but my job requires a mix of technical and managerial skills. If USCIS issues an RFE asking for proof that my role is a true specialty occupation, what kind of evidence should my employer provide?
So USCIS has certain requirement on how you would prove a job is a specialty occupation. So the way you would do it is you look at the normal industry standards. So you look at the industry standards for the job. And if you're working at a client location, you look at what your client requirement is. You look at how specialized your job duties are. You look at for that occupation, you look at what the occupational outlook handbook says regarding those job duties. And so there are like a whole bunch of ways you can do it. So you can also get expert opinions from a professor, where the professor will talk about the nature of the job and so on. So USS has a certain certain requirements. So they have like 4 prongs that you can meet any of those prongs in general to prove that your job is specialty occupation. Again, the goal is as long as your job duties require at least a bachelor's degree or above in a field, in a relevant field, not like any field. So when I say relevant field, it could be like computer science, IT, software engineering. It could be like different fields, but all of them have to be related to the job duties. So if you say like software engineering, computer science, IT, they're kind of related to the job duties. But if you say mechanical, that's completely a different field. So you, as long as a set of closely related degrees are required to do your job duties, pretty much that job is a specialty occupation job. And the way you prove it is just looking at the detailed job duties, seeing how does somebody qualify, the industry standards, if you have a client, the client requirements, and so on. And that's how they would do it. And again, if you are in a very technical role, more than likely you should not have a problem.
Thank you so much, Chand, for taking that up, Sanjay. And Rag was back. He was still asking because okay, he asked, thanks, Chand. And are blanket L1A not eligible or tougher for EB1C?
So EB1C is basically where your company will apply an I-140 on your behalf in that managerial category. So again, when the company applies for EB1C, you don't even require an L1. In general, like L1A is not even required. But what happens is when the company applies for a L1A, as a part of the petition, they're trying to prove that you are a manager in India, you're a manager abroad, and your role in US they will talk about your role in abroad entity, the role in US entity. They'll try to prove all those things. So normally, what happens is you can reuse a lot of that data when you apply for EB1C, because EB1C is again it's like independent application. So whether you're an L1A or not even an L1, the company can still apply for EB1C directly. But since if the company does an L1A, individual L1A for you, the company is documenting all those things, they are getting everything ready. Your EB1C normally becomes a lot easier because you have all the documentation ready. You can easily convince your company that, hey, we already have all the data. It's a lot easier. But in terms of eligibility, L1A is not even required for EB1C. EB1C is completely independent by itself. And the company will have to do it independently. So theoretically, even if you don't have an L1A, individual L1A, if you are eligible, the company can still file EB1C for you.
Okay. Thank you so much, Chand, for taking that up. And Rag, I hope you've got your answer. We also got K. Vishwanathan with a question saying, "Hello, Sam. Hi, K, but I'm not Sam. I'm sure you miss Sam. Sam is going to be back with another webinar at 2 p.m. Eastern Time, so don't forget to tune in to Immigration Talk Show, all right? And I'm sure that this question is also going to be very relevant at that time. But Chand, if you would like to take it up, or maybe you could just briefly answer to K. Vishwanathan asking, my question is L1A visa interview getting into any challenges or hard vetting. I am waiting for appointment scheduling for L1A2 with family. Should I go alone or with family together?
Sure. So I think starting from January, we are seeing a lot of issues with appointments in India, and they've been canceling appointments. And again, like 2 weeks back, they actually announced and changed the rules for Dropbox. And what that means is more and more people are required to go for interviews, and we are seeing challenges where appointments are getting very, very tough. And we also heard some news about 10% of the staff at Department of State, so at the consulates, could be reduced in the next couple of months. And what that means is the staff gets reduced, and now the Dropbox appointments, people are not getting Dropbox, but they're mandated to go for in-person interviews for a lot of other visa classes. All of these are going to like create more challenges at the consulates for your interviews. We expect things to slow down even further. And what that means for you is keep checking the website, and rather than go with the family, try to book an appointment for yourself. The minute you get an appointment, try to at least get your appointment done. And unfortunately, because so many rule changes, so many staffing changes, uh, getting appointments could be tricky, could be taking longer. And to me, if you ask me, definitely go. You as the primary applicant, I think you should go get your visa first, and then the minute the family gets their appointments, they can go for their appointments.
Thank you, Chand. Thank you. So he also is asking another question. Kay, what's your thought? He's saying, "Hi, Chand. What's your thoughts on L1A staying in same city as mentioned in I-129 petition, or take risk to move to another city, but I work legally and justice to my job and organization and my client."
So this is again something you might have to talk to your company, because you have to make sure you follow the terms of your petition. So whatever the company's petition is, you do have to follow the terms of your petition. So just make sure you check with your company, and if you got an L1A, you're probably working at a big company. So and again, the company will know what they've done in their filing. So as long as you maintain the terms of your petition, you will not have a problem. So you cannot do anything that is violating the terms of your petition. You cannot have material changes. So just make sure you check with the company and see what they have filed, what they have notified USCIS. And as long as you maintain the terms, you should not have any problems. If you have any material changes, typically that's when you could have issues.
All right, Chand. So thank you for taking that up. And Kay, I hope you've got your answers. Also, like my next question to you, Chand, would be, if you could tell us about specialty occupation again, and what specific documentation can H1B applicants provide to avoid or effectively respond to RFE related to specialty occupation issues.
Sure. So when you talk about specialty occupation, you have to convince USCIS that that particular job requires at least a bachelor's degree or above in a particular field. That is pretty much what you're trying to prove when you apply, when the company applies for your H1B. So in terms of what you can provide upfront to avoid these kind of RFEs, the first and foremost thing that you should do, your company should do, is they should give a very, very detailed and elaborate explanation about your job duties. And normally, where I see an issue is some companies are giving only 5 or 6 lines of the job duties. And if the job duties are not clear, not very elaborate, that's basically your biggest risk, because USCIS has to know what your detailed job duties are. You're asking for a H1B for the next 3 years. And what that means is be as elaborate as possible. To me, that means maybe 2 or 3 pages of detailed job description, put percentages. Okay. So what that means is, say you're working on client calls, and so client calls don't require like any education. So So you have to be very, very specific. If you say client calls, you're calling the client, you're getting on the client calls to discuss about technical requirements, for example. So you have to detail your job description. You have to put percentage, how much time do you spend, because you have to spend your time on complex tasks, specialty occupation tasks. So give as detailed explanation as possible about your job duties, very elaborate description. Put the percentage of time that you will allocate. Okay, just don't give some random duties, but very clear, and give a very clear picture to USCIS on how your day looks like or how your week looks like. Maybe 40% of the time you're spending on software development, 10% of the time you're spending on software testing, 10% of the time on requirements gathering for your technical product, and so on. So uh, elaborate job descriptions with percentage allocations is the first and the foremost way that you go to USCIS. That's first thing. Second thing, again, if it's a third party client, if at all possible, try to get vendor letters or client letters where the client or the vendor, they talk about the education requirements. So if the client comes back and says, hey, for doing these job duties, our normal requirement is so and so degree in so and so field, that adds a lot of value. So what you should be doing is, if it's a third party client kind of an arrangement, get a letter from the client, get a letter from all the vendors discussing the educational requirements for doing this job. So that will give a very good clarity to USCIS on what kind of a what kind of an education requirement you need. And the other thing is your employer themselves actually telling USCIS what the education requirements are, their normal practices are for that particular role. That is also very important. And again, some employers go ahead and submit some kind of proof upfront, maybe like a expert opinion from a professor, or maybe some of their prior hiring history, and so on. But on a high level, at least the basic these basic things have to be tackled upfront. And on top of it, you have to use the right ONET code. So when you use the right ONET code, good practice is to also include the occupational outlook handbook documentation, because the occupational outlook handbook documentation or Bureau of Labor Statistics, their reports, they clearly show for this occupation what is the standard. For example, if somebody is a software developer, the industry standard is a bachelor's degree in computer science or a very close field of computer science. But if you see something like basic web developer, for example, if you look at occupational outlook handbook or ONET, the general requirement is not a bachelor's degree. So including those documents upfront as a part of the filing, showing the ONET code, showing what the occupational outlook handbook requirements are for that ONET code, that upfront will tell USCIS what that requirement is. So these are some of the things that you do to reduce the risk of specialty occupation RFE.
Thank you so much, Chand, for taking that up. Now we have Galela, who has another question for us. Hi, Galela. Thank you so much for joining us. I wish you can also join us on call. If you can, dial this number 425-436-6335, and the access code is 988-888. So Galela is asking, do I need to mention about my green card application in DS 160? Perm process just started. I have a visa appointment in May 2025. I am on L1B right now. I am in USA, changing H1B, same company.
So the question that the DS 160 asks is, do you have an immigrant petition filed on your behalf? So perm is not the immigrant petition. So if the perm has just started, your immigrant petition has not been filed. If somebody's I-140 has been filed, I-140 is the actual immigrant petition. So if the I-140 is filed, you would always mark it as yes and give information about your immigrant petition. But if the perm has just started, the perm is just a Department of Labor application. So perm is not really an immigrant petition. The I-140 or the I-130. So for family-based folks, I-130 is filed, or for employment-based folks, I-140 is filed. So, and for like investors, like EB5 investors, I-526E is filed. So if one of these petitions are filed with USCIS, that is when you have to mark it on DS-160 and notify the Department of State, the consulate, that an immigrant petition has been filed. But if it's just the perm is not really an immigrant petition, so you don't really have to put that on your DS-160.
Thank you so much for taking that up. Galela, I hope you've gotten your answer. Rag is back with another question asking, I am in current light. Could applying as a third country national work if consular appointments are not available for work visas?
So be cautious about the third country nationals, the TCNs. So what is happening is now all pretty much like every consulate is overburdened because of so many people trying to apply for visas in the last couple of months. So even before President Trump started, there was a talk that people, I mean, I guess people thought that things will slow down. So there were like countries like Mexico. We saw a lot of challenges. Even in December, November itself, people were finding it very, very challenging to get an interview appointment. So, and what this I mean, these foreign consulates, a lot of these consulates, if you're not a resident of that country, they tend to prioritize things for their own residents. So the rules for the consulates keep changing very, very frequently. So you would have to actually call the consulate or talk to the consulate and look at the rules. We had a number of cases where at the last minute appointments got cancelled. So whenever you're in a third country, uh, be aware that the third country, every the consulate, they can make their own rules. So things keep changing. For example, if it's Mexico, if it's first time H1B stamping, they don't do it for TCNs. If it's Canada, they're doing it. And again, within the country, you have multiple consulates. So the answer for you is you would have to personally check with that consulate's requirements, because the consulates don't have uniform rules. So every consulate is different. And if you're not really a resident of that country and you're going to a third country as a third country national, they may or may not accept you.
Okay, thank you so much. And okay, Kay is saying, just for your information, my friend I-129 is approved, say 131 and 310 in his family visa interview. So about 20-30 days lag for now, I see. I'll update next week the dates I get for myself. Okay, thank you so much for the information, Kay. And I think, yeah, Chan.
Yeah. And again, what I see with the dates is all of a sudden the dates get opened up. So I think you have to constantly look for the dates because they open up dates and then you have to take appointments. And again, right now I can tell that there is a lot of demand for appointments. The reason is this whole Dropbox, the way they change the Dropbox rules. Now they're saying that majority of the people have to come for in person because a lot of people who used to be eligible for Dropbox, they simply never had to go for an appointment. Now those people are having to go for in-person interviews. So so you'll have challenges, but again, keep constantly looking at the slots. The slots will open up at random times, and then you just have to book a slot whenever they open up.
All right. Thank you, Chand, for taking that up. And with that, I think we should also take up a few questions from our Facebook groups, if that's all right with you, Chand. Control, if you can display,
Yeah,
please.
sure.
This is Brinda asking, hi all, I have H1B visa started on 10/2022 and expiring it on 10/2025. When should I apply for extension?
So one can only apply for an extension when they're within the 180-day time period. So if it is 10/2025, 6 months, so basically April 2025. So from April 2025 till October 2025, during that 180-day period time, extension can be applied. And our recommendation is applied as quickly as possible. So what that means is, in April, she'll be eligible because that 180-day the time window will start. So as quickly as possible, which means April or May, it's a good idea to finish off the extension part.
Okay. Thank you for taking that up for Brinda. And Kay says, wow, as we chat, I got my soft copy for I-797B. That's really nice, Kay. Congratulations. All right. So let's go on to our next Facebook question. Control, if we can have that. Yes. So this is from an anonymous member, Chand, asking how much usually the cost for H1B extension, H4 extension, and first time H4 EAD with average attorney fees. Company is small scale business, less than 25 employees.
Sure. So the H1B extension, so I'll tell you the fees. So the for a company that is less than 25 employees, the first time they file a H1B, it is 2010 dollars. For the first extension, they have to pay $500 less. So it is 1,510. So 1,510. That's the first time extension fees. And the second time it gets even lower. So the second time the fees is even lower. It decreases by another $750. Okay, so that's the USCIS fee. And then when it comes to H4, the USCIS fee is $470. EAD again has its separate fee. EAD, the fee is $520. So you're looking at about close to $1,000 for H4 and H4 EAD, just the government fee. And then that attorney fees, I mean, typically you'll start seeing from $1,000 for the H1. And depending on what your company is doing, whether they're doing it in-house or they're using an attorney, the price could differ. But in terms of the USCIS fees, those are the constant fees for anybody that has less than 25 employees. Once they cross 25 employees, the fees increases a little bit with USCIS.
Okay. Thank you so much, Chand, for taking that up. Now, our next question is on the screen. This is also from an anonymous member. I received my I-120, I guess. I want to prepare myself for the interview. Why is the best question about why USA? What can I answer about I want to finish my studies now because I haven't studied for years? How can I answer this question and how can I convince her? I want this really. I got rejected twice before, and the second reason was that I wasn't proficient with English.
Sure. So I think so when you go for an interview, I think for an F1 interview, the officers are looking at two main things. One, what is your real intention? Are you coming to study and follow the rules of F1? That is the first thing. The second thing is your intention to go back to your home country after your studies are done? So the focus will be a lot on these things. And what that means is so they have to be able to convince that they have ties back to their home country. So they have to show through evidence what their ties are to their home country and why they would come back. That is very, very critical. And the other part is what exactly are they studying, how it will fit in their career plan, and what exactly is their goal. So once they finish their studies, what exactly is their goal? And if somebody is not able to articulate the reasons for studying, the reasons, their future plan, normally we see issues. So the thing is, you have to be able to articulate and explain to USA's officer what your the nature of your study program is, how it would fit in your career aspirations. And everybody's case is different, so that and everybody's program is different, because some people are taking computer science program, some people are taking English as a second language program. It could be different programs. So overall, the nature of the program is very important, and they have to establish their ties to the home country. And again, every officer is different, and the consulate officers have a lot of discretion. And if they deny the case, unfortunately, you cannot get it reviewed. You cannot file a lawsuit in the court. So the thing is, they have a lot of discretionary power. So all that means is that particular office, a lot depends on that particular officer. So you have to be able to convince that particular officer. And if they're convinced that somebody's intention is to come and follow the rules of F1 and then go back to their home country, they're successful. If not, they typically have challenges with F1.
Right. Right. Thank you so much, Chance, for taking that up. And now we have another question. This is also from our Facebook group and from an anonymous participant asking, Hi, I am on an L1B visa and I will be completing my third year in September 2025. My company will apply for a green card, and they said that I should extend my L1 visa for another 2 years and at the same time apply for an H1B visa, as the green card process may take more than 24 months. My question is, can I get an H1B visa on a future date? And can I apply now and get the visa after the expiration of my L1B? Or do I have to move to H1B immediately once it's approved?
So again, in the new rules, when I mean, the first thing is somebody has to go get through the lottery, and if they get through the lottery, the new rules say that you can apply with a future date. So when you apply, you can put a date that is 6 months ahead of time, and that can be done. And the other thing is whether somebody has to move to H1B right away or not after the approval. There are two different ways of doing a H1B, and this is applicable to even students. You can do H1B as counselor processing, or you can do H1B as change of status. And if you do it as a change of status from the day, so if you do it as a change of status filing, the H1B is immediately active from the date of that change of status approval validity date. If somebody files a H1B as counselor processing H1B, So people can always take some time and they can convert into H1B in the future. So a lot depends how the company is filing the H1B, whether they're doing it in consular processing or filing it directly with change of status request.
Okay. Thank you so much, Chand. So now we have another question, right? Control, if we have, can you please display it, please? Okay. I'm on OPT. I want to travel to India in April, return back in May first week, and my OPT is ending on 17th of June. Did anyone travel from Canada to USA on F1 visa from Montreal Airport to Toronto Airport? My question is, where will be the immigration in USA or pre-clearance in Canada, and what they ask? What do they ask for?
I'm not sure if Montreal has pre-clearance. I mean, like some countries, like for example, Abu Dhabi. So you can have customs clearance done in Abu Dhabi airport. I'm not really sure about Montreal, how it works in Montreal, but at a certain point of time, they have to go through CBP, and CBP officer has to be convinced. So a CBP officer, only if he's convinced, they'll grant admission. So definitely, whether it's either in Canada or in US, you have to go through the CBP. Some airports like Abu Dhabi do have the CBP officers in the foreign country itself. I'm not really sure how Montreal does their things.
Okay, Chand, thank you for that. And I think we can take one more from our Facebook group. This is I applied for a change of status F1 here in America and got approved last year. I'm planning to visit my home country, Philippines, this June for my sister's college graduation. Will it be hard for me to come back to America? I've heard mixed opinions from other people that I will have a hard time. Your opinions and suggestions are highly appreciated. Thanks.
So I think the challenge is because it was a change of status approval. So when he goes to Philippines, they have to go for stamping. So I think basically that word mixed opinions from other people. I think it's because when you go for stamping, anything is possible. A lot depends on the officer. So this person has to go for stamping for F1, and depending on the officer, if at all there is a denial, there is a problem. But my experience is if somebody is already studying in US, you have a lot to prove that you're paying your tuition, you're actually uh, progressing towards your degree, you're getting all the pass grades and so on. So most of the time, when you're able to show that evidence, I think the office it's easy to convince the officers because this person has already started his F1. He has done a change of status. He's in US, already studying in US. So in general, it's a lot easier to convince the officer showing all these evidences. That being said, it is not 100% guaranteed because the officer will still have to give a visa. Only if the visa is given, he can come back. So that uncertainty is always there until he gets his visa stamping done.
And so the mixed reactions, the mixed opinions, right? Thank you so much, Chand, for taking up all of our
Yes.
questions so patiently. And I have this one last question to you, because there could be chances also that people would not make it to the lottery. So for those who would not be selected in the H1B lottery, what alternative visa or work authorization options should they explore?
So again, if somebody is in US, most of the time they are in US either on F1, majority of the time. Some people on H4 because they try to convert from H4 to H1, or sometimes people are on L1 and they try to convert to H1. So if somebody is already in US, again, they can continue that status. The only problem is if it is H4, you can't really work on H4 until you're eligible for H4 EAD, which means you're dependent on your spouse getting I-140. If it's a student, most of the time, what luckily happens is students still have their OPT period, and some people will be having like STEM OPT and so on. So if somebody is a student, has their EAD card, continue on your OPT as long as you can. Some people, what they do is they extend their F1. They again get enrolled in another program, and if you're doing it, make sure that that college is legitimate. You're actually following all the F1 regulations. If you're doing that F1 program, uh, and for the folks that are not in US but are outside the US, again, in terms of work visa, again, you have the O visa option. So O visa again is a good option even for people in US. However, O visa is very tough. But again, a lot of people have been exploring O visa. So everybody that is not getting selected in the lottery can look at their O visa options. And some folks who are eligible for L1 because they're working in the foreign office, the company is also in US, they definitely should explore the L1 option. So L1 and O1 are actually very good options. And other than that, I think there are not many options for specialty occupation. But if somebody is from some other countries like Mexico or Canada or Australia, there are other options. There are like options called TN visa. There are options called E3 visa and other options. So depending on where your country, where your passport is from, you might be able to find some other options in general.
Okay. Thank you so much, Chand. I'm sure that would be of great help, to folks out there. So, folks, if you resonated with today's webinar, and I'm sure you did, do not forget to, subscribe to our channel. We are Immigration Talk Show on YouTube, and we are also there on LinkedIn, Facebook, X, Instagram. Do check us out, and also go visit www.staffingly.com. And in case you want to have a one-on-one discussion with Attorney Chand Parvathaneni, why don't you go check him out as well? His website is www.spblawfirm.com, and you can also call him on his number 817-523-8247. And it'll be best if you can actually email him with your case, because every case is different and need its own attention. So his email address is what you can note down. It is law@spblawfirm.com. Thank you so much, Chand. And yes, I think H1B lottery season is knocking at the door. So maybe if you have final words, to folks out there who are watching us right now, it would be great.
Sure. So again, the H1B lottery, I mean, I definitely think we will have a lottery, but I think the numbers will come down compared to last year. Last year, we had 400,000 registrations. I definitely think the numbers will come down. And the big reason for that, I think, is the $215 fee. And that being said, I think the companies should not wait until the last minute. March 24th is the last day. March 7th is when it starts. So I don't think people should rush and file on the very first day. But at the same time, they should not wait until the last minute. So try to do it maybe like in the middle somewhere around March 15th. So that way you're doing things carefully, making sure all the data is accurate, and finish the registrations. And just because I think the numbers will be lower than last year, I think the selection percentage, the selection chances more than likely will be a lot better than last year. And I think people should just, I think, look out for the lottery once it is done. They have 90 days to do the actual filing. And we have cases where people wait until the last minute and then they miss the deadline. So getting through the lottery next month, that doing it cleanly with the right data, that is very important. If they're selected in the lottery, remembering that there is a 90-day deadline, and again, not waiting until the last minute, but doing it a little early than the deadline and wrapping it up, that's also pretty important. And hopefully, I mean, again, at this point of time, we are not really seeing like denials or anything for H1B. As long as the company is legitimate, the job is legitimate, USCIS is still approving cases. And President Trump's administration, they're also saying that they're not really in favor of doing anything to H1B. Yes, they're talking about changing EB5 and other immigration things out there, but in terms of H1B, most of the administration officials, they're coming and saying H1B is valuable, and they don't have any plans of removing H1B or making any drastic changes at this point of time. So hopefully, I think people get selected in the lottery and they get through and use this as a part of their career and move ahead.
Absolutely. All the best, folks out there, especially those who are going to, try their luck in this H1B lottery this season. So thank you once again, Chand. It was such a pleasure and an honor having you here on Immigration Talk Show. It was a great discussion and a very insightful one. So thank you once again.
Thank you,
Have a great
Natasha.
day. And folks, do check him out and also check us out at Immigration Talk Show. Do not forget to also, check us out at www.staffingly.com. And you can also email me. My email address is nipa@staffingly.com. You can also WhatsApp me. My phone number is 408-335-6444. This is also where you can call me and message me on WhatsApp about your case or questions. So thank you once again. Folks out there, have a great day and stay tuned on Immigration Talk Show because we got more webinars lined up. Thank you for joining us.
Hi everyone, welcome to Immigration Talk Show. I'm your host Rivera, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration Talk Show. I'm Rajni Bharara, your host, and today we tackle a topic that is at the crossroads of opportunity and controversy. The H-1B visa program. Is it a catalyst of economic growth and innovation, or does it pose a threat to American jobs? Well, we are going to talk about that with our guest today, who is none other than attorney Erin Green. He's not just an immigration attorney, but also an H-1B visa expert. So we are glad to have Erin on our show again. So now, without any further ado, because I have a lot of questions that I would like to ask from Erin, so I would not like to waste any more time and directly, welcome him to the show. So, Erin, welcome to Immigration Talk Show once again.
Thank you. Good to be here. Thanks for having me.
It's a pleasure having you. And, I was so excited for you to come back so that we can talk about this topic, because this topic in particular, everybody is talking about it and people are so much curious to know about what's been happening. And because every now and then, just yesterday, we got an update on uscis.gov about H-1B visa. And every now and then we are getting so much information about this particular visa. So, before we talk about H-1B visa, or whether it is good for the economy or whether it is posing a threat to American jobs, I would actually like to know from you, like from the time President Trump has taken the office, a lot of people are always having a debate about whether it is good for the immigrants especially, or whether it is bad for the immigrants. And now that the deportation is going on, people are having so much to talk about. Some are in favor, some are against. Celebrities are crying and making a video and posting that on their social media. So I would like to know from you, with all that have happened, what do you think about it? Is it like, with whatever that is happening and whatever that Trump administration is doing, do you think it is benefiting the immigrants, or is it going against the immigrants?
Yeah, I think what Trump's doing is benefiting legal immigrants, people who come here in categories like H-1B, L-1B, TNs, people who abide by the laws of the country, people who do not for a second want to have any kind of violation, even if it's an overstay of an I-94 or anything. So it's a good thing that when people break the law, that it's taken care of. I can't believe it's even a debate. Especially at this stage, they're removing criminals right now, and hardened criminals, some of the worst. I can't believe that's a debate. But as they remove all the criminals, yes, they need to look at, for example, those who have been given asylum hearings and don't show up, when they're called, which is probably 90 to 98% of people who are given asylum hearings just don't show up to their hearing years down the road. That shows you how much of a scam the asylum entry that's been going on for years, and especially the last 4 years, where it's been elevated to a degree that no one can believe. So yes, what's going on now is what Trump promised. Those who are criminals and here illegally are being removed from the country. It's going to take a long time. But yes, illegal immigration is bad for legal immigration. Right. H-1Bs wait years and years to do everything right. They so-called wait in line, quote. They wait in line, they pay fees, they make sure everything is right, they stress out, they do it the right way. We're the most generous country in the world. We offer the most legal green cards in the world by far. And especially when it comes to work visas and work green cards, we offer the most in the world by far. So there's a mechanism to get here. The fact that we cannot take on the entire world's poor people, even though we have a heart for poor people, but you can't just allow people to come in the country just because they're poor and tell them, just claim asylum and then you're in and you can get everything you want right away. That's not how the system should work. That's a broken system. And yes, it does affect those in the legal immigration community, like our H-1B workers.
Right, very well said. But then, Erin, I would also like to know from you, all these influential celebrities who have so much influence on people, and because people do look up to them. So, I mean, they are not directly involved with all these things, but when it comes to all these, controversies, they do share their opinions and viewpoints on what they think. So, why do you think these people are, if I can say, even crying for these people who are being deported and posting the videos and coming in favor of them, though they know that, that the path that they chose and how they came to the country was not the legal way. But then why do you think, this is also happening on the other side?
The problem is that celebrities are ignorant and or stupid. So that combination can be very influential when they have millions of followers or fans that like them just because they can sing a song or act in Hollywood or Bollywood. But here it's Hollywood. Or, it's ridiculous. Those who follow these people are probably and believe in their opinions and what they say are probably the most ignorant people in our society, unfortunately, and not the brightest. And unfortunately, a country of 330 million will have a lot of folks who never read anything about immigration or any topic, but they get a little feed on their Twitter or Instagram or whatever they use, and some celebrity is posting that, and now they think they understand the topic. They don't. It's misinformation. It's terrible. These celebrities are the worst. If they could just do what they are paid to do or what they are famous for, which is either sports or acting or singing or whatever, then everything would be a lot better for the rest of us. But they have to now chime in on every social topic or legal topic that they know nothing about. It's unfortunate. For your listeners, I would not pay attention to any of them. None of them are experts. None of them know what they're talking about. And, everyone has sympathy for poor people. I don't have to be a celebrity to say, I feel bad for poor people. I like them to come and have an opportunity, but you have to do it in a systematic legal way that's fair to everyone. Right. I've said for many years, if they could increase the H-2B program, this is a little bit off topic. The H-2B program is for non-degree workers. It's different than the H-1Bs where you have to require a degree, right? A 4-year degray or equivalent. H-2Bs are your farm workers, people who work in hotels. They come in seasonally, and it's great. They're usually people looking for a little bit of a better job, more money in their job, and this was established for that and to fill a need in the U.S. The problem with the H-2B program is that there's not a lot of them given out. I don't know the actual number, but again, like the H-1B, there's a cap in the lottery for that, and companies apply for those, and it's great. The people are vetted thoroughly. They come seasonally, they go back, they bring the money back to help their families in different countries, and then they can come back again. If we could expand that program, we could help a lot more of the world's poor. But by doing what they've been doing for the past 4 years, especially, and before, with this phony asylum claiming sham, scam, and just allowing people to come in willy-nilly from anywhere, it almost blows your mind. Right. And that's an educated opinion. I've been reading and lurking into this for years and years. Plus, I'm an immigration lawyer. But just by being an immigration lawyer doesn't mean anything. Because I know a lot of immigration lawyers, very well-respected immigration lawyers, who take the opposite approach, who think, no, all these people should be coming in and should have an asylum hearing. It makes no sense. These people don't qualify for asylum. They know it. And they're just trying to substitute some kind of logic in there to bring in masses of people. Some of these lawyers profit off them, obviously, and others are just ideologically backwards.
Right. So, but Erin, do you think, because if immigration attorneys themselves, if they, come in favor of these people and also celebrities, them being so influential and they have so much influence on people and people's mind, and also by the political parties, they are also called for campaign promotions, right? When they are going out for campaigns, these celebrities are also called. So, do you think if they make these statements, do you think it creates any kind of influence or like the government also creates this or also have decisions or makes decision based on what these people are saying?
Not this government. No.
Okay.
Tradition. Traditionally, when you talk about these celebrities, they have been in our country. They've been 80 to 90, even higher, left wing, meaning Democrat, very liberal, left wing.
Mhm.
We're seeing a shift now as the country saw in the last election how it had been destroyed for the past 4 years, and how these folks are just preaching nonsense. We've seen a shift in a lot of voters to say, you know what, this is ridiculous. We've gone too far. These celebrities have lost most of their influence, in my opinion. And the fact that there's a rise of celebrities that are actually posing another opinion now without the threat of being canceled or, fired, which is what had happened. They use fear in their industry to hold a grip on one political position and opinion. And if you disagreed with them, well, you weren't going to get your next acting job or your next music job, etc. So now there's a big shift. If I'm an H-1B worker and I see these yo-yos screaming because we're enforcing the law, finally, I wouldn't pay any attention to them. And so that's my advice to anyone out there who's not American or who thinks these celebrities have some kind of influence. They don't, especially not on this administration that's just been elected overwhelmingly.
Yeah, glad, really glad, right?
Yeah, I can't imagine if the other side would have won, how this immigration mess would have continued and gotten worse. Who knows what would have happened, leading to the destruction of our laws and our country. Who knows? But now it's time for law and order to restore the destruction that has been done over the past 4 years. And they're doing it now. They're starting on day one and they're getting going and they're just starting.
Mhm. But do you think this mess will be, all this mess that the government is or the administration is trying to clean or that they're trying to accomplish, do you think they will be able to do this in these 4 years?
In terms of stopping the ridiculous, everyone come in, we'll let you into the country, we'll even fly you in program, that's already been stopped. So it's like a drain with water. That's been shut off. Now, what has come in the last 4 years, we don't know. Is it 10 million? Is it 12 million? Is it 8 million? A lot of them came in, just over the border, and there's been no, they didn't have enough resources, and they didn't want to have enough resources to catch them. So the challenge will be how to remove a lot of the illegals that came in the past 4 years, and I don't know how long that will take. But they need to start somewhere. You start with criminals. You have a record of them. You know where they are. I think they'll move on to people who have not showed up for their asylum hearings, which is the whole reason why they were allowed here in the first place. Then they'll go after them, and but that's a whole different topic. That's not something I'm an expert in, but I certainly am very fluent in it, watching what's been going on the last 4 years in that arena and how our border we don't have a border. So now we need to build a border, and that's what they're trying to do.
Right. Okay. Now let's come back to our topic, H-1B. So I would also like to know from you, Erin, that how do H-1B actually impact American job markets? Because, some people are saying that it is posing threat to American jobs. So would you say that it is posing threat to American jobs? Or because we have, also heard conflicting reports about whether these visas create jobs or they reduce the job opportunities for American people?
I really think they create jobs. Look, if we had an abundance of American students who want to get computer engineering degrees and electrical engineering and mechanical engineering sometimes, and all these other related degrees, STEM, if we had an abundance of that in the computer field alone, then you can make the argument that, yeah, the H-1B is not needed, and you would see companies would not utilize the H-1B like they do now. But because we have a shortage in school of American students not taking these particular majors, they simply don't want to do coding. They find it boring. We have a great need for foreign talent. H-1Bs fill the gap immensely. And we could use even more. You can see the numbers of H-1B applications in the lottery every year. Last year was over 700,000, I believe, if I'm correct. And that doesn't even include all the existing H-1Bs that are in the country who've already made the lottery. And they're all employed. None of them are unemployed, very few. So, and you can look at these big companies' web pages, you can see all their career openings, and there's just tons of openings in these positions everywhere. So I believe that it does not hurt the American worker at all. In fact, American workers who are in the field are at a prime. Companies do not need to spend thousands and thousands of dollars on green cards and H-1Bs and extensions. If they have a talented American worker at the same level, they'll simply hire the American just by economics. So my answer is no. I don't think it hurts American workers at all right now.
Okay. All right. So also, guys, if you're enjoying this conversation and if you're getting information out of this conversation, make sure to subscribe to Immigration Talk Show and like the video, share with your friends and family who you think needs to hear this. So yes. And coming back to you, Erin, I would also like to know if you can give provide some examples of maybe some companies or sectors where you think, hiring H-1B workers has led to significant job creation.
So most H-1Bs, as you know, are computers and computer-related jobs. Now expanding into AI, which involves obviously computers, data engineering, software, anything from software to even project management, anything related to the STEM field of computers and computing. That's the biggest use of H-1B. It still is. You can see the LCA data statistics. So what exactly is the question? How do these H-1Bs contribute to growth in companies?
No, I was saying if you can provide some examples of some companies or maybe some sectors where you felt that, this hiring H-1B workers have created significant job creation for, US workers. Has led to
so the IT sector. So for example, if you don't have talented folks here and you need an abundance from overseas, well, what comes with that is very innovative people. Some of them will go on to start new companies after they leave their company. They'll start startups. They'll make new products. The H-1Bs who are working for existing IT companies, even if they're big companies, they can develop things within their H-1B role that will lead to new products, new platforms, new algorithms. These will turn into new services and products, which will need additional employees to support them. So there can be a lot of growth, not just from the H-1B worker, but from other workers. Let me give you an example. When I was the head of immigration at Infosys, I used to go to all the client sites, which were all mostly Fortune 500 companies. And I met with all the managers and we talked to all the employees and answered their immigration questions. They were all mostly H-1Bs and L-1s. And at the time in California, there was a big controversy over one of the clients removing their H-1B department and replacing it with Infosys, for example, and another contracting company, and basically taking over the whole IT function. So when I talked to some of the managers, I said, they're removing the IT department that's there, and they're bringing you guys in. So 3 things. Number one, in a lot of these situations where the IT department is removed, they offer the jobs to the folks that are already there. In a lot of these cases, I know they did at Harley Davidson. That was one that I worked on. The electric company in California. I'm not sure about that, but going further, the managers would tell me that when they come in and bring in a specialist like, an Infosys or another company similar to that, they save them a lot of money because what they're doing is very innovative. They save them money. And I'm not talking about just saving them salaries. They know how to do things better and faster, leading to a better product that saves them money. And in turn, by saving the money, the company can hire a lot of other employees in different fields. And those are majority, obviously, American employees. So it can be a win-win approach when a lot of H-1Bs come in and innovate. And that's what it leads to. Again, I mentioned entrepreneurship as some folks leave and start their own businesses or move. But yeah, I think it's a positive. I know fear mongers out there will say, yeah, but Americans are losing jobs. I don't know about that. There's so many jobs out there that if an American did lose a job, let's say because they replaced the IT department at that person's company, well, they could easily find another job. Also, some of those workers, let's face it, are not that great. Okay, so these companies have old IT departments. They're not doing very well. They come in and innovate. You can see right now, like with the government, what they're doing. They're going into all these government agencies and they're cleaning out the pork. People who either don't come to work, they're lazy, they're getting rid of them. They want efficiency. So a lot of that happens when you utilize either a big IT subcontractor, or just, you're hiring H-1Bs in general.
Right. Thank you so much again for answering the question, Erin. We have started receiving a lot of questions from the viewers, which we are going to take in a bit. But before that, I would like to come back to President Trump, and I would like to ask you that, very recently, he changed his stance on H-1B visa. Earlier, he said it's very, very, very bad, if you remember. And then later, he said, he came in favor of it, and he supported the H-1B visa. What do you think? Why do you think, that sudden change of stance happened? And, what do you think actually influenced that?
Okay, first of all, he never said he was against H-1B visas. In fact, I can remember during his first 4 years in office, he was very supportive of them and made statements to that effect. So if we go back in the record, I guarantee you I can find you that. If he said anything negative about it, he changes his mind. When he gets educated on a topic, he's the type of person that seems to listen to people and can change his mind. So if he did say something where he doesn't support look, he runs the Trump organization. They use H-1Bs. They probably use a lot of H-2Bs as well. What I've seen is that he's very supportive of H-1Bs. He realizes the value in them, the need for that labor force, the professional labor force as it is. So I question those people who say he was very negative on it. And if you can send me some links of stuff he said, I could probably find you. I know I can, because I remember I can send you other links where he said the exact opposite. So I wouldn't put too much stock in something in the past. And also, if you want to look at the past history of the 4 years where he was president, H-1Bs did not decline in any way. And in fact, the wait times were much less. So we're hoping to get back to less wait times, which is frustrating our whole firm and probably every other lawyer out there. It's become crazy how long you have to wait. Yeah, you can pay premium, but premium is now close to $3,000, which is crazy. It's a big expense, especially for small companies. So I think things will only get better. I wouldn't put any stock in fear mongering, which is what people like to do when it comes to Trump, just because for some reason they don't like him, and then they start making up things.
Again, thank you so much for answering the question, Erin. Let me quickly.
And I don't know where that very, very bad shift comes from. I'd like to see that in writing, where it comes from, because I don't think that's what he said at all.
Okay, all right. But thank you so much again for answering the question, Erin. Maybe if I get it, so I'll also try to share that link with you if I get that, if I see that. But for now, let me quickly take the viewer's question. But you answered it very well. But again, I would like to take the viewers' questions, and because we have been getting many, so let me very quickly take Sahil's question for now. Sahil says, as an H-1B visa holder with several years of experience in the US, I have begun to question the program's impact. Do you think the H-1B program genuinely contributes to job creation and economic growth, or does it primarily create competition for American workers? And I think you already have answered this, but still, if you would like to take it and answer again.
I mean, in general, I think it's good. Again, I work with recruiters all day long, my clients. I work with HR departments, legal departments, recruiting departments. But when I get to talk to the recruiters and I can see what they're doing, it's just basic common sense. If you have an American worker and you have an H-1B worker and they're both applying for a role, which has a salary band, sometimes has a salary band, obviously they can go from here to here. But my point is, why would the employer want to hire an H-1B worker when you have an equally qualified American worker and take on thousands and thousands and thousands of dollars and time and a little bit of unknown? Things can get denied, when they can just take the American worker is what I'm saying. So if anything, I don't think it hurts the American worker in dealing with recruiters all day and seeing how they recruit. And yes, in some cases, they're going to need the H-1B employee because there simply aren't enough Americans who have applied, or it's some kind of niche skill and this person has it and they just happen to need sponsorship. So no, I don't think the H-1Bs damage the American IT workers. I think American IT workers are some of the best off, most well-paid workers that we have.
Right. And you're not just an immigration attorney with that, you're also an H-1B visa expert, right? And if it genuinely hurts, you would know, right? More than anybody, I think you would at least know. So
typically what happens is there's a case. There's a case, someone complains because he's an American, he feels he's been wronged by his company, he files a lawsuit, and then the issue is, well, I was replaced simply by someone else because I'm American and I'm not, and that's why they replaced me. That's usually not the case. Those are far and few. I remember years ago when I was working there, when I was the head of immigration at Infosys, I remember we dealt with a lot of these cases when we were contracted to come in and perform a lot of work for some of these big companies. So there are cases here and there, but if you break it down, it's not a lot of people who are complaining. And in a lot of cases, that person simply was there for many, many years and was basically not contributing, not innovating, not doing a good job. We have at-will employment in the United States. You can fire anyone for any reason. That's how our laws work. So, but those tend to make the headlines. Something like that, it's juicy. There's an element of racism in it, maybe. So those make the headlines. News reporters love to pick that up and make a whole story, and then that gets out, and people think that's happening everywhere. It's not.
Okay, so Sahil, I hope you have got your answer. Thank you for your question. And guys, if you have any more questions related to this topic that you like to know, answer off. So what you can do is you can also give us a call on the number 425-436-6335. And you can also put the access code, which is 988888. Yes, you can ask your questions by also calling us. You can give us a call and ask your questions by dialing the number 425-436-6335. And don't forget to put the access code. The access code is 988888. Yes, and make sure to subscribe to the channel and also like the video and share the video with anyone you feel should know and watch this episode. And for now, let me quickly take RK's question. And RK says, do you think the problem with us immigration is the employers? H2A is uncapped, yet so many undocumented agriculture workers. Had the Bracero program employers abuse the workers? Okay, I think.
Is it talking about H2B?
Yeah.
I'm not familiar with H2A. To be honest with you, our firm doesn't handle, we don't handle H2B, we don't handle H2A. So I'm not really an expert on that. I don't know if I can give a comment on that. There are definitely a lot of undocumented agricultural workers here. Is there a need for them? Maybe. Do Americans, the old argument is, well, Americans don't want to do these jobs, so we need to bring them in from, South America and now from everywhere. I mean, if that's the argument, then you got to expand the H2B program or the H2A program, which I don't know much about. And if you do that, maybe you can bring a lot more people in legally and it would benefit everyone. It's a win-win. But Congress needs to do that. It's not something the president can do. H2B numbers, like H1B numbers, can only go up through an act of Congress. The president can't sign a presidential executive order and say, okay, we want more or less. This is set by Congress. That's why we have 80,000 right now.
Right. And, he goes on to say that layoff FYI show that between 2022 to 2024, 580K IT workers, 580,000 IT workers got laid off. Why does Congress not restrict level 1 and 2 H1B workers when mass layoffs? Keep level 3 and 4. They create jobs for H1B and USC. What do you have to say?
Well, Congress can do whatever it wants. If Congress comes together and passes a law that says you can only get H-1B if you're level 3 or level 4, that will become the law. So Congress can do that. The problem with Congress is they never will pass. They haven't, I don't know in how many years, they're never going to pass a comprehensive immigration bill, either because they don't want to, they like the status quo, both sides, or they just can't agree, obviously, both sides, or because these bills are filled with so many things that they get crazy. I remember, I think it was 2012 when the Gang of Eight, when they were going to pass. I did a lot of lobbying for my company in DC, and they were close to passing an immigration bill, but it didn't happen. And then if you do pass an immigration bill, you can make some changes. You can, like what he says, maybe let's get rid of level 1 and level 2 H-1B workers and just keep it at level 3 and level 4. Okay, you can do that. I don't know what effect that would have on the IT industry, because a lot of level 1 and level 2 workers are very vital. Some of them are students who finish their master's or their undergrad, and then they're working for a nice company, and they need that H-1B to continue. They only have 3 years on their OPT and their STEM OPT. So who knows what the impact on that would be. I think they should create more numbers personally. We have 80,000 now. I think they should get back to like maybe 200,000 a year would be a solid number. That's just my opinion. I think, judging by the cap numbers, we certainly need that, if not more. So those statistics don't lie, the number of applications.
Okay. So RK, I hope you have got your answer. In case you want to know more, continue posting your follow-ups, and you can also give us a call on the given number. And yes, but thank you so much again for answering the question, Erin. We still have a lot of other questions. Okay, Skywild Designs is here and says, hello, any news on H-2B program, since it feels like employers are not proceeding with out-of-country recruitments? What do you have to say, Erin?
Again, I don't deal with the H-2B program. I know about it. It can be very useful. It can employ a lot of good people who might not have an opportunity in their country or just want to come here and work and bring the money back to their family without necessarily moving the whole family here. It's a good program. They do a lot of jobs that we so-called may have a shortage in America on. For example, landscaping, hotel industry, agriculture, as you say, things like that. If Congress can look at expanding these programs, we could have a lot more opportunity for people who want to work, who maybe don't have the opportunity in their home country because it's a poor country or whatever.
Okay, looks like I have a slight technical problem, but I'm trying to resolve it. But meanwhile, let's go for a short break. So let's take a short break and come back quickly. And Welcome back, everyone, to Immigration Talk Show. I'm Rajni Bharara, and I'm so sorry about that technical glitch that happened before the break. But now we are all sorted. And welcome back, Erin. I'm so sorry about it. And
No
which we had
problem.
to take a short break, but now it's all good and we can continue the show. And Erin, I would again like to move to the viewers' question because we had so many. And so I hope Designs, you got your answer. Thank you so much for your question. And let me take Empire's question. Empire says, why do groups try to remove H4 EAD? Why do they keep litigating in the courts to have it removed? As well, it was on the regulator agenda in the past by the Trump administration to remove it. Why? What do you have to say?
Well, in the past, L2s and H4s were not allowed to work for many years. When I started working as an immigration lawyer, there was no work option for an L2 or an H4. And then they changed that because they figured, the spouses come here for long periods of time and are very hamstrung and handcuffed. They can't do anything. So they changed it. And then L2s could work. And then for the H4s, as you know, they could work as well if the spouse if the H-1B had an approved I-140. So it's a little bit different than the L2. There's just groups now in that situation, you can make a stronger argument because an H-4 can work anywhere for anyone in any position that could impact American workers. If you think about it, it could be any job. So there are a lot of groups out there, lobby groups and whatnot, who don't want the H-4s working. And they could make an argument that it does affect the American worker, as I said, because it can be in any industry at any level. So theoretically, you could just simply be taking a job. As opposed to my argument with the H-1Bs, where we have an industry that we really don't have enough people in our own country. So it's a little bit of a different argument, and that's why it's constantly being challenged by groups and in the courts.
Okay. Empire, I hope you have got your answer. If you have a follow-up, please continue posting your follow-up. Meanwhile, let me come back to my questions and let me ask, the question that I prepared for you, Erin. So, Erin, recently, the new H-1B visa reforms, starting January 17th, it was said that these reforms are aimed to improve fairness, right? So what do you think, what are the most significant changes that workers and employers should know about?
I think you're referring to reforms about the lottery program. A lot of what you mentioned, a lot of what's in that January 17th has to do with cleaning up the CAP registration program so there's less fraud. That was a big part of it. There was a little bit about CAP exempt employers. As you know, if you're an employer that's not a regular employer, let's say you're like a government institution or sometimes educational entities, sometimes nonprofits, they can get H-1Bs year round, so they're not subject to the cap. There was something about, making that a little bit friendlier. Otherwise, then something about how they define the specialty occupation itself, maybe when they're going to look at petitions. That could make adjudications a little bit easier for H-1B. Right now, I don't see much of a problem in the H-1B field. We file, I can't even tell you how many H-1Bs we do every day. But so we see responses, we see the levels of RFEs. We can get pretty good statistics even internally. And right now, H-1Bs do not seem to be issuing a lot of needless RFEs like they have in the past. I can remember about I think 5 years ago, we just saw, it comes in waves. So there's got to be some internal directive. We all of a sudden be quiet, and then every other H-1B was getting RFE'd with the same RFE. So no method to the madness. But right now, I think it's pretty good. We file H-1Bs. The wait times are a little bit annoying, but we're not seeing too many RFEs, what we call the boilerplate RFE, where you get a 10-page RFE, and then you can see they haven't even looked at it, and they just print it out and send it to you. In addition, I can see lately that with H-1Bs and some other categories, They're getting a little bit better with the RFEs. I think that's internally they've been instructed to do a little bit more on asking for very specific things. So maybe you'll get a shorter RFE, but it's looking for something very specific. We're seeing a lot of that trending lately. That's good because they can focus on something that actually is a legitimate issue, and you don't have to send them a response to 10 pages of nonsense when you've already provided everything there. So yeah, I hope that answered the question adequately.
Right. It does. Thank you so much for answering the question, Erin. Erin, with that, I would also like to know from you about, with India providing the majority number of H-1B visa holders, right? So, how do you think these recent policy changes are specifically going to impact Indian tech professionals?
Well, anything that's done in the H-1B program will impact any H-1Bs. It doesn't matter if they're an IT professional from India or a chef from China or an accountant from Brazil. It doesn't matter. Whatever they implement, it affects them across the board. So there's no specific cutout for, let's go target. They can't do that. They can target the H-1B program. They can make some changes, maybe some beneficial, maybe some negative changes. But yeah, so to answer your question, Indians specifically will not be hurt any more than anyone else who has an H-1B.
Okay.
Indians and Chinese do make up the vast majority of H-1B users. That is true. Sometimes they get a bad rap for it because when people are criticizing H-1Bs, in a sense, they could be criticizing Indians because Indians use the most, let's say. And it's just it's an unfair criticism. I work with Indians. As you know, I was the head of immigration for Infosys for over 5 years. I've been to India a lot. I live in an Indian community in Texas. 80% of my neighbors are Indian. This happens to be an Indian community. I can tell you the Indian population is the type of immigrants we want here. I can tell you the crime rate for Indians is almost zero. There might be a little bit here and there. Very good students, very good parents. They want their kids to get a good education. These are the role models for the types of immigrants and H-1B workers we want in the country. So maybe sometimes Indians get a bad rap because they're using the H-1B so much, but at the end of the day, these are the types of new Americans that you want here eventually.
Right. Okay. Thank you so much again for answering the question, Erin. Let me quickly take Empire's question again. Empire is back with this question. He says, if the 580K layoff is okay, I think we already have taken this. Maybe let's take Yuri's question. Yuri says, I'm on vacation in India and was laid off effective Feb 1st, 2025 with a half-month severance. I'm on H-1B exempt visa since June 2023 with stamping valid until June 2026. My return flight is on February 17th. What are my options for safe re-entry into the US?
Well, if you're no longer employed by the company on your H-1B visa, you should not enter with that visa unless you have a new H-1B approval for a new employer. And then you could use the visa plus the new H-1B to enter. But if not, technically, you shouldn't make an entry back into the US on that H-1B visa because you're not working for them. You're not on their payroll. You're separated from the company. So that technically would be illegal.
Okay. So Yuri, I hope you have got your answer. In case you have a follow-up, continue posting it in the comments below. And
if Yuri can enter on a B visa, he could come in and look for jobs while he's here. Obviously, he's not working. And then if somebody wanted to hire him, he could change status from B to H-1B while he's in the US. He could do that.
Okay, Yuri, I hope you have got your answer. And let me quickly take Amarjeet's question also. So he says, my wife is on H4 here in New Jersey and also have Canada open work permit. She's planning to visit Canada as a tourist. Is it allowed on open work permit or need to apply visitor visa? What do you have to say to Amarjeet?
To enter Canada? Okay, so I'm not a Canadian immigration lawyer. I have colleagues who do rest of the world. I do US only. But an H4 can travel to Canada. I believe Indians have to get a visa to get to Canada. Oh, she said you have a Canada open work permit. So the H4 could enter Canada legally. She's planning to visit as a tourist. Okay. Yeah, I'm not familiar with what Indians need to travel to Canada. If I recall correctly, they need a Canadian tourist visa to enter as an Indian, I think. So in that case, yeah, you can't use visas and be deceptive about your entry. So if you're coming in for one purpose and not to work as a tourist, you shouldn't be using your Canadian open work permit. Same thing goes for the US.
Okay. So Amarjeet, I hope you have got your answer.
I get the Canadian visa. Yes.
Okay, but guys, Erin is not just an immigration attorney, but also an H-1B visa expert. So if you want to get a detailed consultation with Erin, and if you have any case regarding H-1B, you can directly get in touch with him and contact him on his number 469-459-1771. I would like to repeat the number 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. Yes, you can also email him and also visit his website, which is www.eeglawgroup.com. So make sure to get in touch with him for a detailed consultation regarding your H-1B cases or any immigration case that you are looking to looking for help or looking for a consultation. But for now, let me quickly take Rag's question also. Erin, Rag is here and he actually wants to know, okay, we have also, we have people posting on Facebook groups questions related to H-1B, which we would like to take, but I think we will take them in a bit. But right now we have another viewer, Rag, and it's not related to H-1B, but he wants to have your guidance on L1A. So if you have anything for him.
L1A, in order to qualify for an L1A, you have to work for a company outside the U.S. that's related to the future U.S. employer. It can be a parent, subsidiary, they're affiliated companies owned by another company. There has to be a relationship. You have to work there for at least a year. And to qualify for the L1A, you have to be a manager or an executive. So if you're a manager abroad or an executive abroad and you're coming into the U.S. to fulfill a manager or executive role, then that's the most straightforward way to do an L1A. You can also do a hybrid L1A where you're a specialized knowledge person abroad and you're coming in, or vice versa. But most L1As, they're a manager in their current job, they're coming to be a manager in the US, and they've worked outside for at least a year. And those are the best cases for the L1A visa. There's no cap on the L1A. The L2 spouse can work right away as soon as you enter. You don't even need an EAD card anymore. So the L1 is a good tool or mechanism for companies who need to move their workers to the U.S. And yes, if I'm an expert, if there's one thing I'm more of an expert on than H-1Bs, it's L1s. So those two are pretty much my bread and butter. I've been doing that for over 20, I don't know how many years, but yeah, solid visa. Your company will obviously have to sponsor you just like an H-1B. But if you want to reach out to me, a lot of our clients are companies, or most of our clients are companies, and they do a plethora of L1s or H-1Bs.
Great. So maybe Rag, you can directly get in touch with Erin. You have the details right on screen. You can note down his phone number, his email, and you can also visit his website.
Oh, one thing about L1s, I get people calling me a lot, and they're like, "Well, I don't have a company." We're a law firm, so if you have a company that you're employed with and they're thinking about moving you, yes, call me. I can speak to your company. We can explain how it works. I can talk to you. That's great. But if you're just asking about L1s, the first thing you need to do before you come to me is have a company that you work for. Same thing with an H-1B. Have a company that's going to sponsor you. So once you get that company, then yes, I can talk to you and answer your questions, and we can move from there and facilitate how we're going to do an H1, an L1, whatever the work visa is.
Okay, so he's back and he says, thanks, Erin. What are the latest trends for L1A?
Trends, they've been pretty consistent over the past 8 to 10 years. The trending L1As have gotten much harder over the last 8 to 10 years. When we used to do them 20 years ago, it was very simple, very small application. You just put an org chart and you didn't need much more. But now, even an L1A, which, as I mentioned, you just need to be a manager overseeing professionals. Our applications are like this. I mean, because there's been a big shift into attacking these. So we don't just put org charts in. We want to show them that you're overseeing people. We want emails. We want resumes of the professionals you oversee. We want examples of you calling a meeting, making a decision. Maybe you have budgetary authority. So there's no right or wrong. But when we do an L1A, the support letter can be 18 to 25 pages, if you can believe it. Whereas years ago, it was 2 to 3 pages. So they've come a long way with L1As and L1Bs in terms of making you prove it. Really, that's the big trend over the last 8 to 10, maybe 15 years, I'd say.
Okay, great. So thank you so much again, Rag, for posting your questions. If you have more, continue posting them. We'll try to take as many as we can. Okay, so I think Skywell is again here, and Skywell says, thank you for answering that. I would like to know if you need a petitioner to acquire the H1B, and does it only get tied to Silicon Valley companies only? What do you have to say, Erin?
Number one, you do need a petitioner, but it doesn't have to be an IT company or Silicon Valley company. I'm doing a H1B for a construction company that needs a project manager, for example. I have another client that's a social working group in New York. They're like social workers, and they're hiring an H1B. As long as the job requires a 4-year degree. So if you say, well, I want this restaurant to hire me as a waiter, that's not going to work for an H1B degree. I can tell you I've done an H1B for an executive chef years ago, which was a tough one, because a lot of chefs at that level traditionally don't require a 4-year degree. So we really had to prove that this role did. Not easy. But most occupations that require a 4-year degree, it can be in IT, and it can be in accounting, it can be in construction, it can be really anything. As long as the role is it's a specialty occupation requiring a 4-year degree within the industry and within the company generally. And you can show that, then you can go ahead and pursue the H1B category.
Okay, so Skywell, I hope you got your answer. Thank you so much for your question. If you have another follow-up, please continue posting it. And Rag says, thanks, Erin and Rajni. You're most welcome, Rag. And make sure, I'm sure you must have already by now, but if you're not, please make sure that you subscribe to the channel. And all of our viewers, please make sure that you subscribe to the channel, like the video. And if you think your friends who needs to know the information about H1B, please do share this episode with them. And let me take Miss K's question. And Miss K says, why would the birthright citizenship EO include work visa and students? Administration asks individuals to do it right away, but I think the executive order would punish H1B workers. Why would the administration do that? Also, why the uptick in 221G at the embassy? What do you have to, I mean, it's not related to H1B. So, I mean, if only you would like to answer, Erin.
No, I can answer the first question. The reason why they put out that executive order is because they want this issue to finally go to the Supreme Court. It's not because they want to hurt H1Bs, people here legally. They want the Supreme Court to decide who should benefit for birthright citizenship. As you know, there's not many countries in the world that have blanket full birthright citizenship that we do. So it's a very novel idea. When it was introduced in the States, the purpose of it was to give freed slaves and their children citizenship at the time, and it served a useful purpose. Since then, there hasn't been much debate about it. It's just always been the law, and it's been abused. I can tell you, they've busted Chinese and other rings where they would bring in these rich folks, rich Chinese people. They put them in a very fancy hotel just to have their babies, so the kids could one day, the kids would be citizens and they could come back and and then they would go back to China, for example. They busted a lot of those rings up. So me personally, I feel, yes, the Supreme Court should take a look at this and decide. And the reason why they worded the executive order that way is because they knew the next day it would be challenged. Okay, they knew that nothing was going to change, and then it will be appealed until it gets to the Supreme Court. The Supreme Court will eventually have to decide this case. My personal opinion, I think H-1Bs and L-1s and people who come legally should definitely maintain the birthright citizenship. I think that's a good idea. On the other, I don't think anyone who comes illegally should benefit from birthright citizenship. I just think it's just a tool, a wrongful reward for people breaking the law. I don't believe that. Now you might ask, well, what about tourists? Someone who's here not too long, like a B. That's a little bit of a gray area. I'm not sure about that. There's a lot of tourists that come in. There's more Bs that come in than any other category. So do we want to maintain the birthright citizen? That's something that's an interesting question that should be decided. There's a lot of people who feel that birthright citizenship was for a specific purpose and not for the way it's been used for hundreds of years. So we'll see. But to answer your question, Trump wasn't attacking birthright citizenships for Ls or H-1Bs or people here legally. He just knows that it's going to be attacked, so he wants to get the issue out there, and then they want to debate it and have a final decision eventually about it.
Right.
What was the second question?
Also, why the uptick in 221G at the embassy?
I don't know if I can report an uptick. I have a lot of L blankets all over the world. I have a lot of you can imagine the amount of people processing. I don't report an uptick, but if you see an uptick, I don't know. I don't think there's an uptick. I just think, different embassies are harder than other embassies. For example, I do a lot of E2s. This is a little bit off topic, but E2s India doesn't have an E2 treaty, but E1s and E2s are per treaty, and most countries have them. I can tell you, for example, E2s in Canada or other countries are pretty straightforward, whereas if you try to get one in Tokyo, it can be very hard, and they're very strict. So, different consulates have different people working there and different protocols and different ways in which they decide cases, and probably the same thing for 221G. I don't know if there's an uptick now. I haven't seen anything about it.
Okay. Thank you so much for answering the question, Erin and Ms. K. I hope you have got your answer to both your questions. And if you have any more, you can continue posting your follow-ups. Even if the show is over, we will try to, share your question with Erin. We'll try to get an answer from him. But thank you for asking your question. And now, Erin, I would like to move to the Facebook questions that are posted by the people and the viewers in the Facebook group. So, Control, please, if you can share the screen. And yes, so one of the viewer has said, hello, my H-1B extension was approved on January 23rd at the Texas Center. So when can I expect the approval notice?
Yeah, so unfortunately, it can take, we're seeing anything, this is something that has trended downwards. It can take at least a week, 2 weeks before you'll get the approval notice. I assume you looked online based on your receipt notice, or was a premium case and you haven't received the approval yet. Either way, yeah, they can take time. I'm going to say anywhere between 7 to 13 days from when you can see that it was approved. You should have your receipt notices. That's what we're running right now, approximately.
Okay. Let's move to our next question. So the next question that we have is from this anonymous member who says, what is the current processing time for H-1B approval notice to be released for master's court?
So if you're talking about the master's cap lottery, that is done on the same day as the regular lottery or the day after. They used to do that one first. They used to do that one second. Now I believe they're doing that one second. Yes, to give the Masters people a better chance of winning the lottery. They switched that about 2 years ago. I'm not sure the processing time. Processing, you mean just to get an approval notice after being approved, like the last question? It would be the same answer. I don't. This is kind of a vague question.
Okay, maybe let's move on to our next question. So, because not much details are there in this question, so let's move to our next question. So, this anonymous member says, "Hi all, my H-1B transfer has just been submitted to USCIS, but my wife and my son have to travel on family emergency to India. Is it okay for dependents to travel while petition is filed with USCIS?"
Yeah, so H-1B transfer, also known as an H-1B portability, is when a worker finds a new employer who files an H-1B, and they call it an H-1B transfer. Everyone should know that if you wanted to, you could start working when the case is filed for H-1B transfers. You don't have to wait for the approval notice, which is great. Although a lot of employees, they want to wait until the approval is in hand before they jump ship, just to make sure, give them some peace of mind. The question is, yes. So the I-539 H-4 for the wife and son were filed together with the H-1B, and now you need to travel. Well, look, if you have a visa that's still valid and you can travel back in, then I would say you could travel. You're going to need that visa anyway, because you're not coming back without a valid H-4 visa. Sometimes what will happen is when that's filed, they will notice that the person has left the country, and they may cancel the I-539 application. It's possible. So just be wary of that. But if you have to go and you have an H-4 visa to return, you can certainly do that. And in most cases, you should be okay.
Okay. Thank you so much again for answering the question, Erin. I know it's 5 o'clock, but we have completed an hour. But if you have like few more minutes, I would like to take maybe 2-3 more questions. If you're like.
Yeah, sure. I have time. That's fine.
Thank you so much. Thank
Go
you
ahead.
so much.
Yeah.
Okay, let's move on to our next question. So the next question that we have is. Control, can we please move to, okay. Anonymous member says, hello, I just came to United States on H-1B in the end of December. It was finalized that employer will pay me 180,000 annually. Now he's saying to pay 150,000 USD per annum. So there will be change in petition. Is it an issue or is it normal? Please advise.
Normally, H-1B employers don't lower the salary, but they certainly have the right to. But before they pay you the lower salary, they must submit what's called an H-1B amendment, which tells the government that we're paying less than what we stated on the original H-1B. So it looks like here they're going to file a new petition with an H-1B amendment, and then they will be able to change the terms of the H-1B that you're currently under. If they don't file an H-1B amendment, then you're entitled to the 180,000, which should be noted on the I-129 and in the support letter, and they must pay you that. They cannot pay you less unless they file an H-1B amendment.
Okay. Thank you again for taking that up. Let's quickly move to our next question. So the next question that we have says, hi everyone, sorry, this is not related to H-1B. Last night I had an accident. The person in front stopped in the middle of the road. My insurance expired recently and yet to renew it. Her insurance company called me today and said the blame is on me for everything, but I can dispute it. Please, what should I do, and will it affect my green card application? How can I get a lawyer? Thank you for your help and suggestions. What do you have to say, Erin, to this person?
It won't affect your green card application. This was an accident in the road. Everybody thinks the other person is at fault. If you have an insurance company, you should have an insurance company, car insurance company they're using. I would speak to them and explain to them the situation and see what they say, because they're supposed to represent you in this situation. And then based on whatever their suggestion or their guidance is, you may get a lawyer or not. But I think if you talk to your insurance company, they will tell you what to do. Yeah. If you don't have insurance, then I would hire a lawyer. You can go online and there's a million lawyers who do personal injury. This is what this is. Just put your city, put personal injury lawyer, and you'll have 100 coming up, and you can call them. Yeah, that's what I would do.
Okay. I think now let's quickly move to our next question. Okay, this is from Yogeshwara, and Yogeshwara says visa process for family. Hello, I'm currently on H1B and wife is on H4. We are planning to start the visa process for my parents, sister, and brother-in-law. I have few questions on the process. Can mother, father, sister, and brother-in-law go for the visa interview together or separately? Let's take one by one. What do you have to say about this?
Okay, first of all, you have an H1B, your wife has an H4. Your mother, your father, your sister, and brother-in-law are not entitled to any H category visa. Maybe he's referring to them coming to visit on a B visa. That happens a lot. Indians in the U.S. like to bring their parents here, and they come. Sometimes they'll come for up to 6 months at a time. So if you're doing that and they're going to get B visa interviews to visit you, that's perfectly fine. Your mother and father could technically go at the same time. Remember, each person needs to fill out their own DS-160 online and schedule an interview. So I think the mother and father can go together, and the brother-in-law and sister would go together separately, but together. The process for a B visa is the same, whether they're a parent or a brother or a friend who wants to visit you. And what are the documents needed? Well, for the B visa, you want to show that you have ties to, I assume you're from India, you want to show you have ties to the home country. So, maybe you get a letter from your employer. If you have an employer, your last pay statements, bring a bank statement. If you're renting an apartment, bring your last few rental payments, even the contract, the lease of your apartment. If you own a home that you live in, you can bring that. I've counseled clients sometimes to bring a gym membership to show that that's still active. There's a lot of stuff you can bring, but those are the most popular ones. And you have to convince the officer that you're going to the U.S., but you have a life to return to, and that you're not just going to stay in the U.S. forever and ignore your I-94. So, yes, I think he means getting a B. So I answered it in that context.
Okay. All right. Let's move to our next question. I hope Yogeshwara, he got all his answers. Let's quickly move to our next question. So next question says, me and my wife have upcoming travel to India for stamping. We have booked our tickets, but lately we are feeling very anxious to travel, fearing what would happen if 221G is issued, which may take weeks to months to resolve. Having said that, I'm reaching out to understand your experience. If you or your friends have traveled to India or stamping in last 2 weeks, they are talking about this anxiety. They want to know how people are dealing with it. How are you dealing with this anxiety if you are planning to visit for stamping in coming weeks? There is a lot on stake here with the kids' school and mortgage in US, and hence want to understand how is everyone. Okay, so this is more about, I think they just want to hear from other people, but as an immigration attorney and an H1B visa expert, what would you like to say? I mean, what would you like to tell this person?
So the first thing is when you're going abroad to get your new visa, plan ahead. You obviously want to have the appointment already scheduled while you're in the US, and usually schedule it for the beginning of your trip abroad, not the end. So you can have your interview at the beginning, and then you'll get your passport back and everything will be smooth, and then you can enjoy the rest of your trip. In some categories, you can use the Dropbox. So if you've already had that visa already before, you may be entitled to use the Dropbox where you don't need an interview. Nevertheless, my advice to anyone is if you're traveling abroad and you're going to need a visa to come back and get the stamping, when you're in the US a few months before, secure your interview date already, do your DS-160 and secure your interview date from here, have it all set up, and then plan your trip around that date. That would give you the least amount of anxiety, because at least you have it early. Maybe there's a week or two delay. You're still good because you're there for 2 or 3 weeks, but try not to schedule your appointment towards the end of your vacation or your trip, because, you got to get your passport back. And sometimes there are delays and they're out of your control.
Right.
I mean, that's the best advice I can offer.
Miss K also has an advice to offer to this person, and Miss K says, I don't think the child should be punished for the actions of their parents, but should remove the ability to sponsor that parent for a green card. Let's see. Well, I don't know. But let's move to another question, maybe. If we are left with any. So
That had to do with, I think that was from birthright citizenship, but go ahead.
okay, I think that's it. From the question for the questions from Facebook, but we still have one question which is not related to H1B. Erin, this RK actually has asked this question, and only if you want to answer this. RK says, "Don't you think the federal government has jurisdiction over undocumented immigrants, given that they can arrest and detain them for deportation?"
Yes, I do. The federal government has jurisdiction over them. If they're here breaking the law, they can certainly arrest them. Coming in illegally is breaking the law, so you can arrest somebody for that if you're here illegally. I just came from the Bahamas 2 days ago, and I went through customs. In this case, it was in the Bahamas. It was pre-clearance. But can you imagine if I just ran through there? What would happen to me? And I'm an American. I would be tackled, number one. I would be held in secondary. I probably would be arrested, just for starters. I don't know when I would get into the U.S. I don't know what would happen. But yeah, so obviously the federal government is charged with overseeing our immigration laws, not the states, the federal government. And they have the power to arrest and to, to make the laws, obviously, to enforce the laws or not enforce the laws, as we've seen. So yeah, that's a pretty basic question.
Okay, I think that's it. Thank you so much to all the viewers for asking these amazing questions. And thank you so much, Erin, for answering all these questions in so much detail. And we really, really loved your insightful answers. And, honestly, I would love for you to come back for another episode. And guys, if you want to get in touch with Erin for a detailed consultation, make sure you give him a call on the number 469-459-1771. I would like to repeat the number 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. You can also visit his website, which is www.eeglawgroup.com. So make sure you get in touch with him and his team. And thank you so much, Erin, for being here. Really, really, a great episode. And I really would love for you to come back. So I'll get in touch with you. I'll share an email maybe whenever you are available. So we can do another episode on H1B or maybe L1A, right? So
yeah, we could do L1As for an hour. There's a lot to talk about there. If you have a lot of L1 folks and listeners, that could be a good one. Green cards are always interesting. Yeah, so thank you for having me. I love talking to you, Regina. You're a great host. You're very smooth. I think I should see you on the TV here soon. If you're going to go into journalism, you'd be good. You could ask some great questions. So, but yeah, thank you. Yeah, I look forward to any time. I like talking.
Thank you so much, Erin, for your kind words. Really hoping to see you very soon, and we'll decide on the topic. I'm going to frame a topic and share it with you. But for now, thank you so much for being here. And guys, thank you so much for your questions and for joining the session. We'll see you again very, very soon. We have another show coming up, Daily Immigration Dose. So make that you are tuned in on that. But for now, I'll have to take your leave. Make sure that you like this video, share this video, and also subscribe to Immigration Talk Show. I'm Rajni Bharara signing off for now. Take care and bye. Hello and welcome to Immigration and Jobs Talk Show. I'm Rivera, your host. And today, before I talk about anything else, I would like to read out the very important disclaimer, which we display on our screens before the show. So, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone. I'm Rajni Bharara, your host, and today we are tackling a very hot topic that could reshape the future for thousands of foreign professionals. H-1B visa updates 2025. What do they mean for you and how can you adapt? Well, joining us is none other than Ruby Powers, a powerhouse in immigration law and founder of Powers Law Group. With years of experience helping individuals and business navigate the complexities of US immigration, Ruby is here to break down the changes, share insider insights, and answer the big question: how can you stay ahead in this ever-changing landscape? So whether you're an H-1B holder, a hopeful applicant, or an employer trying to make sense with all of it, this episode is packed with tips and strategies you can't afford to miss. So, without any further ado, let's give a very warm welcome to Ruby. And yes, welcome her to Immigration and Jobs Talk Show for the second time. Hi, Ruby. Welcome to Immigration and Jobs Talk Show for the second time. Happy to have you back.
Thank you for having me. I'm glad to be here and help answer questions and be a resource for everyone.
Thank you so much. Thank you so much for your time. And now, Ruby, without any further ado, we have so many updates coming and going, especially regarding H-1B. So people are really excited and nervous at the same time. Sometimes, the big names, the politicians and the business people, they are backing H-1B, and sometimes they are not backing H-1B visa. So, a lot has been going on when it comes to H-1B visa. So I would like to know from you that what are the key changes in the H-1B visa renewal process starting January 17th, 2025?
Well, there's been a lot going on because, as everyone probably knows, we have a new president who was previously a president, Donald Trump, and we had the inauguration just days ago, and so now the immigration in the news space has been flooded with a lot of changes. There haven't been a lot in the H-1B space other than the H-1B rule that was announced that would go into effect on January 17th, which was to further streamline and the modernization final rule to improve program integrity and efficiency that was going to go into effect by January 17th of this year. That was put under place under Biden. What is in the news a lot, which just looking at it right now, is this going back and forth between Elon Musk and it's Vivek Ramaswamy and the whole Department of Government Efficiency about something about regarding H-1Bs and things like that. So there is a lot of talk because it has been confusing leading up to this moment as we're in cap season, H-1B season right now, about to start. And this is a time when you think about it, you talk about it, and you get screened. What will this administration do differently, if anything at all, on H-1Bs? I do have some information just generally that I can share about the H-1B process, and just to make sure we have some good background, if that's okay, and then we can go into taking in some questions. But let me go ahead and share some information. So in terms of updates and what people need to know, a little bit about myself. I'm board certified in immigration here in Texas, and it is federal, so we can help individuals all around the world on U.S. immigration matters. And the firm is Powers Law Group. It's 15 years old, and I've been practicing 16 plus years. So the H-1B is well known, I think, by our audience here as a non-immigrant visa that allows U.S. employers to temporarily hire foreign workers in a specialty occupation. And usually what we're seeing is in IT, engineering, healthcare, academia. and it's a really great place for skilled workers. Unfortunately, we just don't have enough visas allocated for the demand. And you know what the process was before, and this is one thing that Trump put into place in his first administration. Remember how it used to be that everybody who was applying had to prepare the entire packet, FedEx it, and for that April 1 arrival, flooding the USCIS locations, and then they would then take those and do their lottery system. But one thing under the Trump administration was to create the registration process where before you did all of that, yes, you need to double check that you're eligible, but what they would do is you would go on the USCIS website, registration, and then they would randomize. There was an opening of about a 3-week period in March, and then you would have that randomization and be able to see who's got chosen. Then you would prepare and submit. So this saved a lot of legal fees for companies, individuals, and things like that. And so I really do think that that was a great suggestion to streamline the process. But then over time, they called like people gaming the system and applying for multiple people and trying to get more chances. And then they were cracking down on that later in 2024 by some of the innovation and efficiencies that they put in place. But in general, you either have a bachelor's degree or higher in a specific field. You can use equivalent experience, but for the most part, we're working with the bachelor's or master's or beyond. And the job offer is in a specialty occupation requiring the applicant's skills. They have to demonstrate that they need this, the foreign talent. And so just some of the things to know, there's 65,000 H-1B visas annually. And what we're talking about are the cap. The cap is where there's a limitation. There are exemptions to the cap where there's not the same limitation when we're talking about universities and affiliated nonprofits and government and research organizations that qualify for being cap exempt. And back to the annual cap numbers, additional 20,000 for individuals with advanced U.S. degrees. And so that does put a priority on those with, like, mostly we're talking masters from the U.S. That helps with the U.S. schools, but generally people might be here with their F1, they get their OPT. If they don't get picked up for their H-1B, and they're in the STEM, they have some more years. And so there's been like an opportunity there to help them. Often what I find is even though you can do consular processing, that most times it's the employer knows the potential employee and has worked with them in some capacity in OPT or some other visa status and is willing to, because of that, willing to petition for them. So we in 2024, according to this, they received 758,994 applications. I think that's registration actually, but there's a lot of demand. And so that's the other thing that there's been talk about is why can't we increase those numbers? And basically it's a political issue too, because there's just that concern that you're not taking jobs away from U.S. workers. But a lot of statistics and research show that there's not enough U.S. workers to do these jobs. And by bringing in foreign skilled talent, we're infusing a lot of ingenuity and just creativity and just, I don't know, I'm thinking of synonyms for like the amazingness, let's just say, and that later on can turn into other opportunities because they're making great strides here in the U.S. And what's great about the H-1B is that it is a nice pathway can be a nice pathway with it being a dual intent for perm sponsorship. And so anyway, there's the process. And just one other change that did happen was because of that final rule that went into effect on January 17th. There's a new I-129 that came out like the same day, and so that's a new thing. H-1Bs, you can get them usually around up to 3 years at a time, but the 6 years, and then you can get the 1 year extensions while your perm is pending. And the prevailing wage requirement is critical, and that changes over time with Department of Labor and where the person will be working and based off of experience. And this is how they make sure that they're protecting the domestic job market, and also the potential employee and beneficiary to make sure that they're paid that prevailing wage. One other thing about the H-1B, which I think a lot of people know, is that H-4 is for the spouses and married children under 21. There is a small carve out for giving work authorization for H-4 spouses if there's a perm pending. That had been going in and out of availability over the years. I hope that remains, because for some individuals with a long time visa wait, then this makes life a lot better, while the spouses are waiting for the green card to be available, especially for Indian nationals when the visa wait time can be quite long. And because otherwise the spouse would need to get on another visa. And the other thing we always have to remember is, while that visa wait time is pending, watching out for the children and what visa can we move them over to. So like we said, there's a lot of political changes going on right now. And a part of the base in which the Trump administration or Trump his candidacy was really trying to protect U.S. workers. I think that there's a section that are using the H-1B that are not part of his base that would be at risk. But I think just the concept can be very politicized. I'll just say it like that. I don't know. I don't want to go into the nitty gritty, but I think that's why we're seeing a lot of headlines right now where there's a little bit of some confusion as to, is he pro H-1B or not? And it sounds as if he has been, but then it's been really confusing, honestly. And so anyway, a lot of big name companies have been stepping up for H-1Bs, just like they had for DACA, for example, and saying, hey, we need this. We need more of this. We need to stay relevant and stay competitive for us to be able to keep these jobs here in the United States. And so that's a lot of part of this conversation. There were so many other changes, executive orders that happened in the last few days that even though we are gearing up for H-1B season, so this is timely, I feel like this is just one of many things that are going on right now to sort of see if he's going to have any substantial changes other than what has been happening under the last year or so under Biden and the improvements. So he has said that he wanted the need for the skilled individuals and supports the personal. He knows about the program. I think he's had employees within the program. We need the best people in the field, apparently. He said that. But in terms of expanding it, I think I'm not sure what he's going to do. There's a lot of supporters, like Elon Musk, who's a part of his DOGE, is that the Department of Government Efficiency or something like that. I'm still memorizing all these new things from this week. But and then there's others who are not as are critics of the program. But anyway, a lot of big name companies have used a lot of H-1B, a lot of employees through the H-1B process, and are definitely strong supporters of it. I think it says a lot that with Elon Musk in Trump's ear, that who's a big strong proponent of H-1Bs, and we'll continue to see what will happen. But right now, there's the 85,000 visas available, and 20,000 are going to the advanced degree holders, which really is not enough. Like when the economy is strong, when there's labor shortage, I mean, these numbers go by so fast. When before the registration process, and you flew all your cases there by that April 1 date, usually they would stop accepting them within like 2 days or something like that, maybe 3 days, because they knew that they already hit the numbers and that within that they were going to do their lottery. So I think when you look over time, when historically economy is strong, labor market is tight, these go by really fast. And anyway, well, we know the importance of it. They contribute to the economy, that innovation, and it does provide a lot of options because individuals can have a pathway to, usually it's like the foot in the door. Maybe they were already here on their F1, then they get the OPT, the company likes them, they do the H1B, it gives them an opportunity to get that experience, build their resume, and then the traditional path is to be sponsored by the company. But, if there is a timeline to get that done because the H-1B visa is available only for 6 years. So you want to get that perm going usually within a couple of years. That usually works if you move quickly. Other than that, depending on your nationality, you might want to try to move to another visa, or you build up your resume and try to be a national interest waiver candidate of some sort. Or depending on your spouse's nationality and eligibility, you might be able to get on some other type of visa. But lots of global collaboration, lots of options, and there's been different talk. We don't know. Removing caps for U.S. educated international students, simplifying that transition from H-1B to permanent residency would be great. Streamlining processes to encourage top talent to stay without being so bureaucratic and confusing. But honestly, there's been so much change this last couple of days. I don't know when we're going to get to this conversation, but it's probably going to be hot because we're going into H-1B season. So what will some of the changes be? We're not sure, but I think that other issue that was clarified recently was making it easier for the OPT, so F1 OPT, H1B, and that whole gap, clarifying that, streamlining that. And then, that was awesome when there was given more time for OPT for STEM degrees. That gave people more of a chance, bite at the apple, the H1B registration. And so it's hot. It's prevalent right now. This is timely. And other than it being in the news and the January 17th rule and some of the other changes from 2024, with the fact of how that needing to show your passport when you do the registration to minimize the amount of multiple registrations per person beneficiary. Those are like sort of the hot changes that have been happening in the last year. So this is a little bit about my information, and we'll go ahead and open up to questions.
Thank you so much, Ruby, for explaining everything in so much detail, for pointing out all the changes that has been happening with the H-1B visa. So that was very detailed and very insightful. Thank you so much for making the efforts, on creating the presentation. It means a lot. Thank you so much for that. But now I would like to move to my next question after this. So Ruby, with this, I know that you have explained each and everything in so much detail, but still I would like to ask you a question before I move into the viewers' question, because I know the viewers are also waiting to get an answer from you. And guys, if you directly want to give a call, so you can also give us a call on the number 425-436-6335. I would like to repeat it, 425-436-6335. You can put the access code 988888. Yes. We'll put you through and you can directly ask your question to Ruby, through call. So, but right now, Ruby, I would like to come to you and ask you that now, can all H-1B visa holders now renew their visas domestically, or are there specific eligibility requirements?
Oh, okay. Well, if you could, or if the individual is here in the United States, you can do that. And there's a lot of different considerations about if you're planning to travel and with your stamp and things like that when you're coming back in. But you can you can do an extension while you're here in the country. One of the other things that happens with this is that one thing that happened a lot under the Trump administration, and just thinking about consulate right now, is that there were a lot of resignations and there was a lot of change. And then they had a hard time filling some of those roles. And so then things just got slower and a little more difficult. And one of the other things that I remember during that first administration was, and I'm just sort of talking in general, so I'm just sort of putting that thing in perspective. So when you're deciding whether you want to do an extension here or, abroad, but I would definitely, if you're here, and I would do it here. And you can also take advantage of premium processing if you need it or things like that. But the other thing that happened is that there was this sort of, even if you had been approved before at the consulate, they were reviewing under Trump first administration, reviewing things de novo, like looking at it with fresh eyes as if it had never been approved before. And one of the first changes that Biden put in place to basically honor the fact that it had already been reviewed and approved was to give a lot more credence to a prior approved petition and not look at it with fresh new eyes, assuming that it was a brand new case, and sort of giving it the deference of it being approved before. And so I'm bringing that up because there's going to be a few things that are going to happen. Like with the change in administration, it just happened on Monday. And we are going to see, I remember when with Biden, it took about 6 months or so to really feel like he had made his administration change footprint and on immigration. And so I think we're going to concede that. But right now, a lot of new cabinet members are getting into office or being confirmed and everything. And then they're changing their leadership. They're changing the marching orders of what they're going to do. And so that's why a lot of this there's going to be a lot of moving parts, more than a typical year. And so I think even though there's lots of questions and I love being able to help give some general ideas, I think that nothing takes the place of just having a good old consultation and with an immigration attorney. And maybe if you have a company that is sponsoring and doing all of the the process, but you want to have an attorney that just is helping you know what your options are, then that's also like what we do as well, or that's an option that you can have. You don't have to just ask the attorney that your company has. You can ask another one just for like a second opinion to know what your options are. So anyway, I went a little bit over there, but I wanted to explain that a little bit for you because there's a lot of different moving parts. And one little policy, even though there's probably only going to be one law that's going to be passed anytime soon that's regarding immigration, and that's the Laken Riley bill act about the some criminal matters that even if you're arrested could have you detained. But what I'm getting at is that for the most part, we haven't had immigration laws in many years, but what we have had is policy interpretations or rule changes. And so when there's a lot of these changes that are announced, like about 80 executive orders were returned or rejected or reversed. I think it was reversed of Biden and Trump on the first day on Monday. But when you think about all the changes that are being proposed, you have to think about where is the source of power or where is the source of law that the things we assume or that we know come from. And sometimes it could be, like I said, a rule, a policy. It could be an interpretation from like USCIS, for example. And after a while, they're like, we may have a new interpretation of it. And they create a memo and they say, this is our new interpretation of it. And so maybe that's a little too nerdy about it. But like right now, that's sort of how immigration works. And so when you ask questions and when there's a constant change, us immigration attorneys have to evaluate these things when we're answering those questions. And with a lot of moving parts, I am starting to liken this to playing 5D chess. I don't know if that's a thing, but it's sort of like what we know, what could potentially happen, and what could change. Anyway, so, but this isn't going to be that complicated as 5D, as like some other areas of immigration right now.
Right. So, but Rivera, a lot of things has been happening when it comes to immigration. Since the time President Trump has taken the office, he has signed executive orders and ended birthright citizenship. The courts have also challenged it, and then the mass deportation has already begun, and so many things, and the ban on CBP app. So I mean, there's a lot to actually talk about, and then these changes in H-1B visas, and then sometimes they are backing it, they are in favor of it, then sometimes they're going against it. So a lot has been happening. So what do you think? Do you think it's more than they are, what they're trying to do is they are actually it is more of a political move than what they're trying to do?
Well, I think that one of the things to note is that okay, that's probably where I saw the 5D chess was on Star Trek. Thanks for putting but I've been using it this week in media because I that's why I feel like my brain is like hurting already. Okay, this is the way I approach this right now. There's the political motives, and unfortunately immigration has been politicized, but ultimately life must go on. Immigration impacts so many different aspects of the US, from the economy to the movement of people to the food that we eat, to our culture and innovation. We're in this whole AI revolution and everything in the tech space as well. And so I think on the political side, the way that our president is part of his base, that part of his campaigning is to stoke fear amongst immigrants, and unfortunately, and so I think a lot of that is through the expedited removal expansion, the mass deportation talk, the getting rid of the CBP one, making asylum harder, the Lincoln-Riley Act, which is, in theory, it sounds good, but when you realize it, a person who's just arrested could be mandatory detained, even though they haven't had their chance to defend themselves and clear their name. And so that's contrary to what we normally do. And even ICE has said that we're not going to be able to implement this because we do not have the resources. But anyway, so one of the things I've said is that we have to evaluate what really can happen and where are the priorities. I think the priorities really are a lot about border and deportation and the crimes. I think that he may have swayed back and forth about H-1B, but I think ultimately he knows it's important for business and companies. And I think for the most part, he'll stay a little bit out of it, but it is getting a lot of headlines right now, especially with Elon Musk and such, who's a strong supporter of it, and a lot of other big companies. So I think for the most part, it's not going to be changed that much. And plus, there's not a lot of time to make a lot of change. Like, it's January 24th. Registration should start in early March. It should only open for a few weeks. We already had, rules take time to be put in place. There's a comment period, there's the posting, and then you have to give people advance notice about it. So I think for the most part, whatever was done under Biden in the last year is probably what's going to stay forward. For this next season, it could be like the following H-1B season that we see a little more change, but for the most part, I think it's relatively safe. But like I was saying, like, you have to look to see where's the source of power, and how long and how quickly could one person, or could he make a change to it, or would it require Congress to act, which is going to be a little bit easier because there's a lot more consistency on the Republican side and numbers there. But that's probably only going to be for maybe 2 years. And then the pendulum will swing again and so forth. So yeah, those are some behind the scenes type of thoughts about it. But I think, some of the things that we remember under the Trump administration were, he made that registration process. He made it a little bit harder for F1 students, and there was a lot less students. And you know what? F1s, they're the pipeline for H1B. My
Mm-hmm.
and so I don't know. I don't think there's been a lot of talk about like reducing that, but it could be that target certain nationalities that they target reducing F1 for, but that really hurts the schools because of the international.
Like, if you
Yeah.
can give some example, nationality, like what all countries?
Well, it could be like Chinese or something like that, or certain countries that like he might be like retaliating against for political reasons or something like that, or
Right.
security reasons. But I don't honestly. I really try to stay in my immigration lane, but it looks like I need to go up like 30,000 foot high level and see like a whole lot of big picture. But even with immigration, we're still full service law firm. So, I mean, I'm thinking about asylum and complex citizenship and family based on a regular basis. But yeah, I think yeah. So I don't know if he's actually said anything about F1s, but I was just giving, I mean, a student. But what I have said is that what I was mentioning is that was something he did before. He made it a little bit more stringent because, okay, where do F1s come from? Usually the consulate. If you make it
Yeah.
difficult at the consulate, which like if there's more scrutiny, less discretion, less staff, whatever the policy is, less reviewability. There was a Supreme Court case last June that gave a lot more power to consular review. And so if that's that pipeline, so at the consulate is where all the F1s pretty much were coming in. And then for the most part, you could do a change of status. And then the F1s usually turn into OPT and then they turn into H1B for the most part, right? One other good thing that happened, and I think that was pretty much only under Biden, was that you could do a change of status to an F1 and pay the premium processing. I remember how you used to have to wait a whole like year and a half for them to adjudicate the change of status before you could start school. That was so stupid. And that's another thing that Trump did under Trump 1.0 is that he got rid of premium processing for so many things, which was really unfortunate for USCIS because USCIS, that's extra money. Like you do something faster, you get more money, and that helps the USCIS be more efficient. But also it makes it more difficult for companies and individuals if you don't have premium processing. And so that was one thing, if you paid attention to that under Biden, having more premium processing for even national interest waivers, student change of status and things like that. Anyway, I guess I'm going on a little bit of a rant there, but giving a little bit of a history lesson of things and keeping in mind what might potentially happen. So.
No, I think that's necessary and that's very important. You know what you're saying. You have to inform the immigrants, especially because they are expecting a lot of things. But Ruby, before I take from the viewers, but before I take that, I also would like to know from you that before we already have seen administration, and now that he was coming to power for the second time, I know we were expecting a lot. But then, as an immigration attorney, were you expecting all of this to come on the first day itself?
Well, we had heard rumors that there was going to be a whole bunch of actions on day one. So, I mean, I sort of lost count on the number. I heard like 150 or I don't know, 200, I don't know, whatever. But, the one thing to note, it's like there's more to the U.S. than just immigration. Like, I'm thinking his presidency, like there's other areas of law and life, but I feel like he just really wants to focus on this one. But anyway, I think we had heard rumors. We knew, I think as the day was getting closer from him winning the election to January 20th, we were like getting more things were getting leaked out and more was coming out. A lot of that first focus in November was really in early December was to try to get a whole bunch of things filed and take care of things that we knew would probably not be run smoothly under the Trump administration. So that's where our focus was. And then as we were leading up, we were thinking a little bit more. But honestly, it does feel like it's like drinking from a fire hose right now. We had a little snow day here in Houston for like 2 days. And so there was the inauguration. There was a snow day on Tuesday and Wednesday. We all had to stay home to be safe. And then Thursday, yesterday, I was just like, it's hitting me now. It's really hitting me because it was like there's like this game like whack-a-mole. You're like trying to hit the thing or something. I feel like it's a little bit like that because, there's this CBP one, no vaccine needed for COVID vaccine for 45. There's, just all the different things, the mess that talk about the law enforcement being at schools, places of worship and hospitals. People are getting concerned about that. Just so many different things. Oh, getting rid of that. The Nicaraguan, Cuban, Haitian, Venezuelan parole program. So honestly, what I was telling my staff is a lot of these things are sort of like you maybe get 2 a week or 1 a week of these things, but to get a deluge of all of them on a 2 or 3 day period, it's like that going back to the 5D chess of it's a huge paradigm shift. And so right now we're trying to evaluate all what does that mean for our existing clients and how we can best give them advice for the future.
Okay. Thank you so much again for taking that up and answering the question, Ruby. Now, I would like to quickly shift my focus to the viewers' question because they've been waiting in line for a long time. So let me quickly read out the questions. So MBB is here, and MBB says, I'm sure the USA will lose hugely the talented students from all over the world, especially from India with Trump's executive order, and huge gain for India as brain drain will be arrested. USA's loss is India's gain. And I think it's like a statement that this person is making. And also says, goes on to say that on the other hand, the USA will become, I don't think so that's going to happen. But what do you have to say about this? What do you have to say about this statement of his?
Well, I think that the sentiment of it is whoever can make it attractive to bring in the skilled talent and educated and innovative talent is going to win, right? And what we saw under some of that Trump 1.0, just going to call it that, make it simple, is that we were turning away great talent. And so where were they going? They were going maybe to Canada or Europe, or I don't know where they were going, but some of them were not they weren't feeling so comfortable to come to the US. And so what does that mean? Well, then those countries were going to get, and those companies were taking advantage of that opportunity. And then that can lead to, more innovation, more profits, more strength. And so, right. I mean, that is the problem with brain drains when there's political issues or there's just not a lot of options for those to move up. And so the countries that take advantage and look around and say, hey, let's make it easy for companies and individuals to come here and bring their awesomeness, for lack of a better word, to our country, they're the ones who are going to win. So I hope that we're not going to see that these next 4 years. What I will say is if we do unfortunately see that, then I will believe that we do have the pendulum swinging back and forth. And so it could just hopefully be a temporary loss. And then we rebuild with new leadership and new insights. But ultimately, I think that there's so many different aspects of immigration to this conversation, from a person who has no status to a person who's had some type of a quasi status to someone who's coming from another country with education, to a legal permanent resident, to a naturalized citizen. And each one of those individuals is taking something away from a lot of this last week's news. And as to how really these things are going to impact them, I think it depends on where they are in the totem pole of their status. But for the most part, Trump was a business or is a business person, and he's surrounding himself by certain ones like Elon Musk and such. I think that there'll still be some reason in knowing that we need to not harm this process. There could be maybe some more potential restrictions, but I think for the most part, it's not going to be too greatly impacted. Unlike some of the other areas, like if you you don't have a status or you're trying to come in from the border.
Okay. Thank you so much for answering the question. Ruby, let me quickly move on to next viewer question. Gauravi is here, and Gauravi says, I have been working in the US on an H-1B for 3 years now. With these 2025 updates, what specific changes should I be worried about? Could these updates affect my ability to renew or transfer my visa? What do you have to say?
I think for the most part, if you already have your H-1B and you're secure with your job and things like that, I think you're going to be fine. I think what I normally would tell someone in that situation is, have you already talked about legal permanent residency, perm? Do you have a plan? Because remember, you're at the 6 years unless you've traveled and you can recapture some of that time. But you're going to be wanting to be having those conversations if you haven't already, because 3 years has gone by fast. What's your plan afterwards? And are you married? Can they get a visa? Can you what can you do? That's what I'd be more concerned about. The typical plain vanilla thing of what's your plan. I wouldn't be worried about these changes right now. There's not a lot of changes, honestly. There's not. It's really what Biden put in place. And we already knew about that coming in before this administration started.
Okay. Okay, so Gauravi, I hope you have got your answer. In case you're looking for more, continue posting your follow-ups in the comment section. And meanwhile, let me move to Rekha's question. So Rekha is also here. She says, I'm currently on OPT and planning to apply for an H1B through a consulting firm. With the 2025 updates, are there additional restrictions or red flags that USCIS might focus on for consulting or third-party placements? What do you have to say, Ruby?
It was for, okay. For the dual intent doctrine, I don't see any changes on that aspect. Oh, right. This is the different question here. I haven't seen about the dual intent one question. I don't see any changes with dual intent. I think that's still there and it's still a benefit. And like we said, it's sort of a gateway to legal permanent residency through the perm, but it doesn't have to be the only way. And there's other options that you could try to pursue. But let's see. So for the I think that there's just a lot more protection for the beneficiary. I haven't seen exactly something completely on point to answer this question about through a consulting firm, but I think that it's just they're just wanting to make sure that there's a lot more integrity and efficiency and protection of the beneficiary, and also making sure that employers are not gaming the system and things like that. They are going to be conducting inspections and imposing penalties for failure to comply, and that proving that it's a bona fide position, a specialty occupation. But for the most part, I don't see anything that is to be of concern for this specific question.
Okay. Okay. So, Rekha, I hope you have got your answer. But in case you're looking for more, please continue posting your question. And we'll be taking that and asking it from Ruby. Let me move to Lokesh's question in the meanwhile. Lokesh says, in the context of H-1B visa programs, dual intent doctrine, how do the 2025 updates affect the ability of foreign professionals to pursue permanent residency or citizenship while maintaining the H-1B status? And what are the strategic considerations for balancing short-term and long-term immigration goals?
All right. Well, that's
yeah.
Well, okay. So I don't see there was a change or a mention about the dual intent. And so, the general path, the general traditional path that we usually see is the H-1B. Probably after 1 or 2 years, you start the perm process, which can take a couple of years depending on different factors and if there's an audit and things like that. And then you, if you have the I-140, approval, and then you can continue the H-1B extensions beyond those 6 years. And so that's generally what we see for individuals. But if for some reason that doesn't work, then there are ways to try to either recapture some more time, stay out of the country for 1 year to restart your H-1B clock. I don't see a lot of people do that, but it is something that exists. Maybe you have a spouse that can get on a different type of visa, and like an E2 or an L, and it can include you, and then you are able to work on as an E2 or an L2. Or maybe you're eligible for a national interest waiver, or an O, or something along those lines. So I think that those things are still there. A lot of the implementation changes that were announced just a month or so ago are just like little tweaks, but it doesn't have a huge impact on the big picture of those short-term and long-term goals that you want to have. And usually when I have a consultation, we're talking like, okay, short-term, mid-term, and long-term, plan A, B, and C, and the different permutations. And sometimes we're like the individual, the beneficiary's attorney, and we're like there to give ideas and suggestions, but the company is the one who's sponsoring has the attorney in-house or what have you for the H-1Bs. So, those are other potential options to just keep in mind so that you're thinking about the big picture. But I think you're going to be okay. So just as long as you're having a consult and you've already thought about these plans, because if you have your plan in place and then there's a little change in the policy or interpretation, then it should just be a little bit of like, okay, how do I refresh this and look at it in a new perspective? And it won't be it should be a substantial shift.
Okay. So Lokesh, I hope you have got your answer. Thank you so much for your question. Let me move to Ciara. Ciara has actually posted this question on Facebook, and she says, hello, I am Senegalese. I am H-1B seeker. I have a master's degree in finance accountant with a non-profit area. Is it possible to get sponsor job in accountant or financial?
So it can, but one of the things that's important is that the job description and the position requires that you have that degree. But there are a lot of private situations where H-1B sponsors accountants, and that's very common. But if the nonprofit, I think one of the things to note is proving that the nonprofit can pay that prevailing wage, has a role that can include a master's accounting professional on staff. Those are some of my little things of thinking a little bit, but that might be a little extra, but it is possible what you're asking for to be. And then if they qualify to be a CAP exempt, then you wouldn't even have to go through all this registration stuff we're talking about. But you have to look closely to that and have it evaluated to see if they are or not. Because if they are subject to the cap, then you have to go through it just like everybody else that we're talking about here.
Okay, so Ciara, I hope you have got your answer. Thank you so much for posting your question. If you have more, please continue posting your follow-ups. Meanwhile, Ruby, I also have a lot of questions from Facebook. I would like to share my screen and ask those questions because, those are some people, who post questions in the Facebook groups. So, yeah, I think it's already shared. So, okay. I would like to take them one by one. Before that, Ciara is actually back and she says, okay, thanks. And I have visa B1, B2.
Oh, okay. I was looking at that question. Okay. So for the B1, B2, you're usually only given 6 months of I-94 at a time. You can usually do a one maybe extension inside the country, but you have to realize that, okay, if you are subject to the cap, you wouldn't be eligible to start being in the H-1B until October 1, and that's more than 6 months from now. And if you were to do a B2 extension, you might not know how much time, if it's approved or not. It could get a little risky if you're trying to do a change on top of a change. So I would just do a consultation. And if the nonprofit you're talking to doesn't have an attorney that they've ever worked with, then, like we help in those situations. And that's a pretty common thing for us, or if, just in general, is if the company or the nonprofit that you're trying to work with has never sponsored anyone before, then what often happens is they comes to us, they get an opinion, and then they hook us up with their employer and say, hey, maybe this could be a good attorney for the employer. And this usually happens with more of small operations that haven't ever gone through the H-1B process before. So that's something that could happen, I'm suggesting, but also just it is possible to do what you're saying, but I'm a little worried about the timeline of it, especially if you are subject to the cap. You might need to just leave the country and, make those connections, leave the country and do the consular processing to finish it all up instead of a change of status. Because we still a lot of unknowns. If you're subject to the cap, then you have to be chosen the registration and it has to get approved, right? So there's a lot of unknowns there.
Right. So, Ciara, you can also directly get in touch with Ruby. I would like to share her details. I would like to show the details over here, Ruby Powers. You can, for a detailed consultation, get in touch with her so she can help you because she also by now she also knows your case. So you can directly get in touch with her for a detailed consultation. Give her a call on the number 713-589-2085. I would like to repeat the number, 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. And you can also visit our website, which is www.rubypowerslaw.com. So please get in touch with her so that she can help you in a better way. And because of the time constraint, we won't be able to take all of your questions. But then you always have an option of getting in touch with the attorney directly. So here are her details. Get in touch with her. She says, okay, thanks. Thank you so much, Ciara. And now I would like to, again, Ruby, I would like to share the screen and show those Facebook questions to you, and I would like to get an answer from you. Okay, so this question was actually posted 53 minutes back by an anonymous person who says, my lawyer by mistakenly sent I-485 to family-based AOS logbox instead of employment AOS logbox in Dallas. Now, starting February, they will only accept application on final action dates. I'm filing based on filing dates. It's been 3 weeks already. What will happen? Is there anything I can do? My checks haven't been cashed yet. What do you have to say, Ruby?
Well, that's a very technical question, but in theory, if something is sent to the wrong place or it's not the right, something's wrong, they usually reject it. And rejections can I've seen take 3 to maybe even 6 weeks sometimes. I've actually done a tour multiple times of the Dallas lockbox, and they open everything up, they look at the numbers, and they blah, blah, blah. But I would also check, okay, you don't have a receipt number. They didn't cash the checks, and it's been 3 weeks. And you probably already checked the FedEx or the mailing, and it wasn't, okay. I think I would probably give it another 1 to 2 weeks, and it'll probably be rejected and come back. I don't know off the top of my head if it'll get routed to the correct place. It probably won't. But in those cases, if something is sent to the wrong place, or something is deficient with it, then they reject it, and then it can take a little while, and then they'll just give you that rejection page, and then they'll just send that to you and the whole packet. Now I get what your point is that you lost that opportunity because of the visa availability. There can sometimes be, with some great advocacy, being able to, if it's super worth it, there could maybe some advocacy to show when it was sent and trying to retain the priority date of when it was sent, but for the error. But given the situation, I think you have to look at the whole picture and see if it might just be worth just waiting another month for the visa to be current at the right time. I don't have that, what you're saying, memorized where it is and how, if it's backlogged, retrogressed and everything off the top of my head. But these are some things to consider. But rejections usually can take about 4 to 6 weeks usually, and if they haven't cashed it in like at least 4 weeks, then it's probably going to get rejected and it's probably going to be sent back. So but then watching the visa bulletin and strategizing what you're going to do once you get it in your hands is another thing to have in mind.
Okay. All right. Thank you so much for answering the question, Ruby. Let me quickly move to another question. I also have a question here from Jeremy. But Jeremy, we are going to take that in a while. Let me please complete these Facebook questions before. So this next viewer says, hi everyone, I'm currently on an H-1B visa and have received a jury duty summons. Am I eligible to serve as a juror, or is there an exemption for visa holders? What steps do I need to take to confirm my eligibility or respond appropriately? Any guidance would be appreciated.
Well, that is quite a fascinating question, because I think you have to be a U.S. citizen to be a juror. What I've seen be an issue is that they tie jury summons with driver's license. Did at any point you say you were a U.S. citizen when somewhere accidentally? Because as far as I know, you need to be a U.S. citizen to be on a jury. But I think that I don't know if that's a blanket across the country. I think it is, though. Actually, I've never been asked this question before. But let's see. I think that, yeah, I think you have to be a U.S. citizen to be on the jury. So now I'm wondering, how did you get that? But it might have been you might have checked a box somewhere on the driver's license. So look to see what might have triggered you getting that, because I've seen this happen a couple of times where people accidentally registered to vote when they got their driver's license. So look to that, and then I'd say have a consultation just to see if we need to clean something up there.
Okay. Thank you so much again for answering the question. Let me quickly move to the next one. So the next one says, if we can zoom
and
it in a bit.
We might have to make this one of the last ones. Sorry, for timing purposes, if that's okay. I've got
okay. So this person says, Indian citizen living in USA on H-1B. I recently renewed my Indian passport from USA. So while traveling to India, do I need to carry both the passports, new and old? Also, while coming back, will I-94 be marked to the new passport? But it doesn't have visa, as USA visa is an old passport. Will there be any issue? Also, I'm planning to go to India for a visit for a few weeks. Any suggestions on necessary documents needed to come back, even if I have stamped visa on old passport that I would be carrying?
Usually this is just that annoying thing that happens because your visa's in the old passport. So it's best to have both of them. Often, I believe they put the visa stamp in based off of where the visa is located. But ultimately, it would be good to eventually transition to having it in your new passport. But this is just sort of what happens. We're going into some new territory, so I don't know if you have an attorney already, with your company, or you need to have a consultation just to make sure what the requirements are at the time. But for the most part, verifying your employment and having those up-to-date information it's always safe to have. And we could be getting some updates as to what the answer of like returning or getting, that was one thing I forgot to mention that Biden did, is that they waived interviews, right? They waived interviews for people who previously had like a B2 or an H1B, like in some select situations that they were exempt from that when they were at consular processing to come back. And I'm not sure if that's going to be continued or not, or if they're going to, make them all go do appointments and things like that. So I'd say have a consult in your particular situation. But yes, in general, when your visa's in one and it's expired, you're going to be showing both, and then eventually you'll be trying to phase out the old one. But you always want to keep a copy of your old one and keep scanned of it, because if your long game is to get your green card, you're like, having those are so awesome, because they shows entries, exits, validity of periods, and so much. So always make a copy of that and have it somewhere safe so you can use that in the future.
Okay, thank you so much for answering that. But Ruby, if you can please give us like 2 or 3 more minutes, I'll be quickly be taking 2 more questions. Yes, because they've been waiting for quite some time. So Jeremy is here and he says, "Hey there, we've been living in New York City from 2019 August, and we are using Fregumen, and they have told my wife and I from September 2024, we are just waiting for our green card. My wife is on L1 and I on L2. So any clarity on these types of visas and green card?"
Okay. Well, was it the L1A or the L1B? And is it based off of perm, or is it, you didn't say what your nationality was either for visa availability. So I wish I could help give, I don't know. There's so many different factors, right? So what was the basis of the green card? What are your nationalities? What's the visa wait time? And how much time do you have on the L's? And is it L1A or L1B? Because the L1A has 7 years and L1B has 5. But so those are things I need to know to help get, and what's the exact question? Because I think I don't know what the question is, but, or there's a follow-up on clarity of these types of visas, British and Indian. Okay, well, who's British and who's in? Okay, well, so let's just say in general, but I mean, you can have a consult just for you, even though there's Bragaman is the attorney for the company, but just to understand some of these things. Okay. The L1, there's the L1A and the L1B. The L1A, like I said, has 7 years, L1B for 5 years. You have some of the same rules as H1B. You can recapture time, and there's dual intent. So it's really nice. If you're the L1B, you're usually going to do the perm. And if the L1A, there's another way, and it's a little bit, okay, so you're British. My wife is L2, and she's Indian. Okay. So, but you didn't say whether or not you're L1A or L1B. Maybe you're L1A. I don't know. But anyway, if you're L1A, then the green card process, especially if you're British, is probably is a lot faster if the company is sponsoring you. And so I don't know what the original question mentioned, something about September. They have told my wife that we were just waiting for our green cards. So I think if you're saying that they filed the green cards, the 485, then you would have those receipts and you're just waiting for the processing. And you can also go to USCIS website under processing times to see what those processing times are. But if you're saying like they haven't even filed the I-140, okay, the wife is British and she's an L1A. Okay, well then this is a faster process because of that. But I don't know exactly if you're asking me, like they filed the 485s in September and you're waiting for the green cards to come in the mail. Check to see what receipts are there. You can check the receipt on the processing times and for the case status, and then that can give you a better guidance. But if the wife is British and she's okay, did they premium process the I-140? So the wife is an L1A. She's British. She's the primary. The I-40 was completed. Well, it's likely the company sponsored. And so I think that you can check for those processing times. And I don't know if the I-140 and the 45 were filed concurrently or not. But anyway, these are some of the things I need to know to help give you a little bit more guidance. But it looks like
Jeremy, maybe you should directly get in touch with Ruby. How about you directly get in touch with Ruby? Yes,
that would probably be best.
Yeah. The details are displayed here on screen. Give her a call on the number, send her an email, visit our website, get in touch with her. And yes, I'm going to read out those details in the end. But before I do that, I would also like to quickly take one more question before I let you go, Ruby. It's from Hiren. And Hiren says, due to technical issue, my employer submitted 2 applications for the same employee due to this USCIS and sent RFE for H-1B. Then how can we handle this? What do you have to say?
You're welcome, Jeremy. So due to my employer submitted 2 applications for the same employee due to USCIS sent RFP for H-1B, and then how can we handle this? They sent 2 separate H-1Bs completely. What was the RFP asking for? I need to know a little more as to are you talking about registrations or are you talking about H-1B complete packets? Like they just sent the same one twice. And then was one of them supposed to be like for you potentially? And there are sometimes you can try to solve problems with liaisons, like with the American Immigration Lawyers Association, we have liaisons. But I really, unfortunately, need a little more about this question to sort of figure out how to troubleshoot it, and how big of an issue it is, and knowing what the RFE is for would be helpful. So, there's been, I don't want to say second guess your attorney, but there is a benefit to having a second opinion occasionally. Just like you would with a doctor, right? And if they're not, completely answering your questions, or you just want to have another opinion, there's no harm in that. You just pay for a consultation fee, you get another opinion, and maybe you don't even make any changes, but it gives you a little bit more peace of mind and to maybe think outside the box of what could be a way. These are sort of the situations I call when the train gets off the track and you're like, oh, this is, how do we get it back on track? And sometimes it could be a human error, the firm, or it could be a human error or some type of error at USCIS, and it can cause unnecessary stress. But when people, crowdsource other attorneys and even those attorneys are talking to other attorneys, they can, and have practiced for a while, they can find out ways to troubleshoot things. I know that I've had some funky things in the past, whether it was because of ours or USCIS. And the more I practice, the more I go to CLEs and talk to other attorneys, the more I'm able to figure these types of things out. So I know that doesn't exactly answer you, but I do need a little more to help answer that question. But I think that is that our last one for today? We went a little over.
It is. Yeah, so Hiren, maybe you can also get in touch with, with your detailed question, maybe write your question in detail with each and every aspect regarding to your case, and send it to Ruby or give her a call on the number. You can directly get in touch with her by calling her on the number 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. You can also visit her website, which is www.rubypowerslaw.com. And we also had one more question by Vivek, and he wanted to know about EB3 visa from Nepal. But Vivek, we are going to do one more episode on EB3 EB3 visa. So you stay tuned on this space. Make sure you subscribe to Immigration and Jobs Talk Show. We are going to give out more, we are going to come up with more webinars and more updates regarding EB3 visa. But for now, that's it. So thank you so much, Ruby, for being here. Thank you so much for, giving us this time, and your answers were insightful, detailed. So thank you so much for everything.
Oh, well, my pleasure. Thank you, everyone. I hope I could give you a little bit closer in the right direction. And nothing takes the place of just having a good old private, consultation. But, it is good to see what's out there and learn. And it's great that you have this forum. So thank you again for inviting me, and I hope we can find some other ways to collaborate in the future.
Of course, we'll be more than happy to do it. And yes, I'll get in touch with you again for maybe another episode. And whenever you have time, please let me know. And we would love to do another webinar with you.
Thank you.
Thank you so much. Guys, thank you so much for being here, for posting all your interesting questions. And yes, if you were able to get your answers, great. And if you weren't, make sure that you get in touch with Ruby so that you can get your answers in detail. But for now, I'll have to take your leave. Thank you so much again for posting your questions and watching the webinar. Make sure that you subscribe to the channel, like the video, share with your friends and family who are looking out for answers to these questions. And like I said, for now, I'll have to take your leave. I'll be seeing you all very, very soon in another webinar. But for now, take care. I'm Rajni Parara signing off. See you.